Good morning and welcome back to Law News Network. I'm your host, Jesse Weber. We have very special coverage for you today. Obviously, we will be continuing our coverage of the Florida v. Henry Seura trial, and we are also in verdict watch in the Ohio v. Joshua Gaspar case. But in the meantime, this morning, we actually have different coverage for you. We are looking at golfing superstar Tiger Woods' arraignment hearing for his DUI arrest back in May. Now, you may recall that Woods, who's 41 years old, was arrested back on May 29th in Jupiter, Florida, after police found him asleep inside his running Mercedes with his blinker on. Now, in a dash cam video that was released to the public, and I'm sure many of you have seen this footage, Woods appeared unsteady on his feet, and he had to be asked the same question multiple times during a series of field sobriety tests. But blood tests actually showed that Woods had no alcohol in his system. However, he informed officers that he had prescription medications in his system, including Xanax and also Vicodin. Now, Woods has suffered numerous injuries in the past, and he's underwent fusion surgery in his back this past April. That was 1 month before his arrest. So that marked the 4th procedure on his back since 2014. Now, what's going to happen in this arraignment hearing? Now, during a typical arraignment, a person who's charged with a crime goes before the judge. The criminal charges are read against him. The defendant, Woods, would be asked if he has an attorney. They ask the defendant, how does he plead? Does he plead guilty, not guilty, no contest? Issues about whether bail is put forward and different proceedings go forward. I'm sorry, ladies and gentlemen, we just found out that the Tiger Woods hearing just concluded. Do we have any update on what he pled? We don't have an update. So as soon as I get an update, I'll let you know. We are informed that October 25th is a new date on the calendar at 8:30. Well, as soon as we confirm what that date is, I'd like to continue just talking about this really quick. So as I was saying, that would be what an arraignment hearing is. And until we find out what he pled, let's just talk a little bit about what happened. He's actually charged 3 charges. The first is driving under the influence of drugs. That's a first offense. The charge carries a fine of between $500 and $1,000, temporary loss of his driver's license, probation, and even a possible jail sentence of 6 months or less. The second charge that he is culpable for is improper stopping, standing, or parking were prohibited. This is a lesser non-criminal charge. And finally, he was actually charged yesterday with a 3rd charge of reckless driving. Now, Woods, we don't know, again, we just found out that his hearing was 26 seconds. It was very short. We don't know exactly yet how he pled, but if Woods pled not guilty, he could take the case to trial, and perhaps that is the date that was set forth. Then another option is, because this new charge was just added of reckless driving, it's perhaps possible that he would plead guilty to this reckless driving charge and admit himself to the Palm Beach State Attorney's Office for their first time DUI. Okay, we're being informed that he didn't plead anything. There was a meeting between the attorneys. This is a little bit more interesting than I thought it was going to be, but okay, we have been informed that Tiger Woods has signed a not guilty plea. Basically, that gives the idea that he will take this to trial. But again, that date that was put forth, I think it was October, that's a while away. There might be a deal that comes forth before that happens. But again, if he takes this to trial, we have to analyze what his possible defenses would be. Now, here to help me talk about this is Ken Belkin. Ken, great to see you. We're here. I'm sorry we're last minute. We thought we'd have coverage of Tiger Woods to look a little bit about what's happening. But I do want to talk about this not guilty plea. But before we actually do talk about it, and before we get into the law, I actually just do want to say one thing. You know, as a huge fan of Tiger Woods, and I think I speak for the golfing community at large, it's just terrible to see a man who is regarded as the best golfer in the world to see where he is today. And while many question whether he'll actually make a comeback, I think it's the hope that Woods resolves all of these issues and makes one last attempt at becoming the undisputed legend that we all wish he will become. You know, he was on his path to overtaking Jack Nicklaus's record of winning 18 professional major championships. He had 14, but his career had been stalled by a series of injuries, poor choices, and as you see here, legal issues. He hasn't actually won a tournament since 2013, and he's currently ranked, I can't believe I'm saying this, currently ranked 1,005 in the world golf rankings. This is a guy who was #1 for consecutive weeks on weeks on weeks. So it's hard to be talking about this, but I did want to mention that point. But again, I'm here with Ken Belkin, and let's talk about some law, Ken.
Good to see you, Jesse.
Good to see you. So let's talk about this. He pled not guilty. Doesn't that mean he's going to trial?
Not necessarily. Look, at an arraignment, typically, you almost always enter a plea of not guilty. Look, it's very early stage in the case. There's a lot of negotiations that need to be had with the district attorney, or state's attorney as they call it down in Florida. And, you know, there's no clear indicator that this is going to trial. Look, most cases of some seriousness, you're going to have to plead not guilty at trial, because the fact of the matter is the district attorney, the prosecuting attorney, is not going to give you a satisfactory plea offer. He can't plead guilty today. He would take a misdemeanor on his record. He would be saddled with a criminal record for the rest of his life that could potentially have issues with professional golfing. It could potentially have other issues.
Well, Ken, let's talk about this a little bit. There was another charge that was added yesterday for reckless driving. Many people say that he should have pled guilty, or the idea was that he was going to plead guilty to this lesser charge, be included in this Palm Beach State Attorney's Office first-time DUI offender diversion program, which consists of 12-month probation term, attendance in a DUI school, community service, random drug testing, and an interlock device installed on his car. But his DUI conviction would have been thrown out, the charges would have been dropped, and this case would have later been expunged from his record. So why not take that deal?
Well, I think he has a cognizable defense here, and it's a defense that I've actually played in 2 occasions in the state of New York. It's that he wasn't actually driving. No one observed him driving. Yeah, there were signs of fresh damage to the car potentially, but he wasn't driving. They don't have a chemical test on him indicating there were substances in his blood. The only thing they have is a vague statement where he admits to having Vicodin and Xanax in his system. Now, Vicodin and Xanax are, even though they're controlled substances, they are legally prescribed drugs, and you know, you could have some in your system and not legally be impaired.
Let me just ask you one thing, Ken, before we actually have another guest that we're going to be bringing in, so I'm going to show a little bit of that dash cam footage to bring our next guest in. He's charged with driving under the influence, and under the statutory standard, that's actual physical control, which generally means that a person has to be in the position to control the car at any imminent moment, and they can be charged with driving under the law. So the idea that, yes, he pulled himself off to the side of the road, maybe he felt the effects of the drug, but he was still in a position to operate that car at any moment.
And that is key legally, is that he was operating the car. The car was on. Previously, I mean, now we have, you know, the push-button ignitions, or at least some people do. Previously, the standard was if the key is in the ignition and it's turned, you're considered operating the motor vehicle. Now, even though that is the legal standard, at trial, juries are sometimes hesitant to convict. And the first trial I ever had was a Bronx DWI trial. And the guy slept in his car, parked his car, slept in it because he realized he was a little too messed up to drive, and the jury didn't convict him. Wow. They felt like, look, he did the responsible thing. He did exactly what we want someone to do. He was intoxicated. He pulled off. He took himself out of the flow of traffic and did a responsible thing. And I think maybe Tiger Woods did something similar. And I think his attorney, you know, trying to get inside the mind of his attorney, might be willing to take that gamble in order to get a better offer out of the DA, or maybe even push it to trial.
Well, if he does push it to trial and he hopes jurors would side with him in that way, we might have to see that. In the meantime, let's actually turn to that dash cam footage right now of his arrest, and you'll be able to see the state that he was in. And when we come back, we're going to be here with Ken, but we also have another guest here to talk a little bit more about the impact on Tiger Woods, the man, and his reputation as an athlete. So take a look at this video.
What I'd like you to do is stand with your feet together and your arms down by your side, okay? All right, put your feet all the way together just like last time. Okay. Do you know the English alphabet from A to Z?
Yes.
You do? What's your highest level of education?
Sophomore in college.
Sophomore in college? Okay. With your feet together and your arms down by your side, okay? So go ahead and get there now with your arms down by your side. Okay. Don't begin until I tell you to, okay? But when I tell you to, I want you to close your eyes and tilt your head backwards, okay? And you're going to recite the entire English alphabet in a slow, non-rhythmic manner, meaning you're not going to sing it, okay? Do you understand the instructions?
I do.
Okay, what were the instructions?
Not to sing the national anthem backwards.
Not to sing the national anthem backwards? Okay. What I want you to do when I tell you to, keep your arms down by your side and your feet together, okay? I want you to close your eyes, tilt your head backwards. When I tell you to, don't begin until I tell you to. And I want you to say the alphabet from A to Z in a slow, non-rhythmic manner, okay? Meaning you're not going to sing it, okay? Do you understand the instructions?
Yeah.
Okay, what were the instructions?
I'll repeat A to Z, non-rhythmic lettering between A to Z, making sure you get everyone correct, and what you do, okay?
Okay, make sure you don't sing it, okay? Just say it,
Yeah.
okay? All right, go ahead and put your arms down by your side. Your arms down by your side. Go ahead and touch the side of your shorts. Okay, what I want you to do is close your eyes and tilt your head backwards, okay? And then go ahead and begin when you're ready.
Man, what?
The ABCs from A to Z in a slow, non-rhythmic manner, okay?
Wait a minute.
You may begin when you're ready. Mr. Woods, you don't have to walk anywhere.
Wait a minute.
Go ahead and stand with your feet together and your arms down by your side.
Whoa.
Are you okay? What's wrong?
What are we doing?
Right now I want you to say the alphabet from A to Z with your eyes closed and your head tilted backwards, with your feet together and your arms down by your side in a slow, non-rhythmic manner. Do you remember that?
Yes.
Okay. So go ahead and stand with your feet together and your arms down by your side. Just like this, just like I am.
Yeah.
Okay? Go ahead and close your eyes.
Yeah.
Tilt your head backwards. Go ahead and close your eyes. You're not closing your eyes.
I don't really trust that. What is that?
Alright, I'll put it back. That's okay. What I need you to do is stand with your feet together and your arms down by your side, okay?
Right here. How about that?
Okay, feet together. Alright, go ahead and close your eyes, tilt your head backward, okay? And then you're going to say the entire English alphabet from A to Z in a non-rhythmic manner, meaning you're not going to sing it, okay? Do you understand?
A, B, C, D, E, F, G, H, I, J, K, L, M, N, O, P, Q, R, S, T, U, V, W, X, Y, and Z.
Okay, sir, what I want you to do is go ahead and place your hands behind your back, okay? All right, go ahead and release your hands for me. All right, go ahead and put your hands together just like this. Perfect, okay?
Oh, what is this one for?
Just relax, okay? Just give me 1 second, I'll explain everything to you, okay? All right, right now, okay? I'm placing you under arrest for suspicion of driving under the influence, okay? Do you understand? Okay, go ahead and step right in front of my patrol car for me. All right, go ahead and spread your feet for me. Do you have anything on you that's going to poke me, prick me, stick me, or cut me?
No.
You don't?
No.
Okay. around 4:30. Driver's going to be 1015, reference signal 1. I'll get you the deal number in a minute.
Welcome back to Law News Network. I'm your host, Jesse Weber. We just found out moments ago, as you were watching the dash cam footage of the Tiger Woods video, that Tiger Woods has pled guilty to a lesser charge of reckless driving. That would include him in the DUI diversion program, that first-time offenders program down in Palm Beach. We talked about that a little bit earlier, but let's look at what that actually means. I'm joined now by Ken Belkin, a criminal defense attorney and a good friend from law school. And I'm also joined by Maria Marino from Sirius XM Sports and NBC Sports Radio. Both of you, good to see you, and Maria as well. Nice meeting you.
Nice to meet you.
So I'm going to talk to Maria, Ken, because I've already heard enough from you.
You've heard enough from me over the years.
So he's pled guilty to a lesser charge, reckless driving. We're under I believe he has an October 25th hearing date about this. And if he's included in the DUI offender diversion program, it means that his DUI charges would be dropped. He would be put into this program, and this case would later be expunged. Now, we're talking about Tiger Woods, the athlete, his image out there. Would you say, from a PR perspective, from his career perspective, that was the right move?
Sure. I think in terms of his career, this isn't going to really affect much. I think the damage has already been done in terms of, you know, how we perceive Tiger Woods' character.
Maria, I'm so sorry to interrupt you. We're having activity in another court. I have to turn to it right now.
No.
My apologies. Stick around. I want to hear about
Hold that thought.
I want to hear your analysis on that Tiger Woods case. But in the meantime, we actually just have footage right now in the Seura, the Henry Seura case out of Florida. So we have to turn to that right now, but we'll be back here with more analysis on Tiger Woods.
And what is 139? What's that?
Okay, I missed it. Then we'll do 139 is going to be the cell phone records for Tallahassee Police Department.
And did you have one after that?
Yes, sir. 140 is the cell right of Mr. Segura's 509.
So I think 139 and 140 are the new ones. Right?
Yes,
Clerk arrest have been admitted. I know the defense is subjected to the test. Any additional objection, Mr. Prince?
No, Your Honor.
139 and 140 will be admitted. Okay, ready for jury?
Yes, Your Honor.
Your Honor, I have a small packet of additional cases for the court review.
Okay.
This afternoon, I've already provided the statement approach.
You may. All right, let's have a jury, please.
Mark, we're going to recall Mr. Lewis real quick.
Everybody be seated. Anybody been exposed to anything they should not have been exposed to that we need to discuss? All right. We're recalling Mr. Investigator Lewis. You remain under oath.
Yes, Your Honor.
Investigator Lewis, a name has come up during the course of examination of Jeremy Smith. Did you have contact with Jeremy Smith?
Yes, I did.
And Mr. Smith, who is he as it relates to this particular case?
A boyfriend of Miss Peters.
Did you look into Mr. Smith at all, given his DNA was found on scene?
Yes.
Anything that, any other evidence that would implicate him in this particular crime?
None whatsoever.
No further questions from Mr. Smith?
Any cross?
No, Your
All right, you can step down.
Honor. This time, table call Investigator Chris Morgan. Not mine.
What is speaking? What? Okay.
Do you solemnly swear or affirm that the testimony you give in this case will be the truth, the whole truth, and nothing but the truth?
I do.
May I proceed?
Thank you. Good morning, sir.
Good morning.
Can you please introduce yourself to the jurors?
Certainly. My name is Christopher Corbett, and that's C-O-R-B-I-T-T, and I'm a sergeant with the City of Tallahassee Police Department.
He's there at the City of Tallahassee Police Department.
I currently supervise the Technical Operations Unit, and that is the unit within the agency that's responsible for all the sort of high-tech or technological ways that we gather or analyze evidence to support criminal investigations. And it may be things like computer forensics, audio-video monitoring, video collection, those kind of things. And then what I spend most of my time doing, which is the analysis of communication records or phone records.
Okay. In order to do this analysis of, as we're talking about today, cellular phone data and analysis, do you have any specialized training and experience that allows you to do that?
I do. I have well over 1,000 hours of just general technical training, and then 600, getting close to 700 hours of training specific to cell phones and how cell phones operate, understanding communication records that we get from the carriers, and then how to plot those or represent those for presentations.
Okay. And have you ever previously testified as it relates to your analysis and doing analysis of cell phone data, information that's obtained, as well as the analysis?
Yes, I have, on numerous occasions.
Approximately how many times are you talking about?
44 or 45 now.
At some point, did you become, Your Honor, at this time I attended the witness.
Any board hire is to his qualifications?
No, Your Honor.
All right, you can proceed.
At some point, did you become involved in the homicide or victims of Brandy Peters, Tamaya and Tanaya Peters, and Javante Segura?
Yes, I did.
How is it you get involved in a situation like that?
Well, any criminal investigation that may involve communication devices or phones, as far as trying to locate phones or locate people or identify people, they will contact my unit. And so when this incident happened, I was contacted to see what assistance I may be able to offer the case.
Okay. And .126, have you an opportunity to review of the data for Ms. Peters?
Yes, I have.
They were the information that was provided to you by the cellular company?
Yes, I am.
And which cellular company was that provided for?
Sprint.
Okay. Were you also provided information from a phone number for Henry Segura, 509-4380?
Yes, I was.
Okay. And who did you have an opportunity to review those?
I did.
And were those the information that you obtained from the cellular company?
They are.
And which company was that?
Verizon Wireless.
Okay. And that states exhibit number 136. And 137 is, were you also provided information as it relates to a secondary or an alternate phone for Mr. Segura, the 408-8669?
Yes, I was.
Did you review those documents?
I did.
And were those the documents that were provided to you from the cellular company?
They were.
And which company are we talking about there?
Again, Verizon Wireless.
Now, as it relates to the analysis of these cell phone, the data you get, how do you go about doing that?
Well, of course, the first thing we do is we actually look at the records, and the various records from the different providers can give us a lot of different information. And we can look at things such as who's calling who, what date, what time, for how long. We can also get location information. We know the cell sites that a handset's communicating with. and some other general information. Sometimes we can get content of communications, text messages. So we want to look at all of those things from the various sets of records, and however it applies to the case, whatever's applicable. If we need to know where someone was, then we look at that location data and we try to plot that on a map. If we just need to know who someone was talking to most frequently, then we'll analyze the records and run a frequency report and say, well, this is the person they were communicating with most often. So whatever it is that's applicable, we take those records, we analyze them, and we provide that information to the case agents.
Is it fair to say that the information that you get from the cellular provider is voluminous at best?
At best, yes.
Okay, lots of different columns and things along those lines.
That is correct.
Did you prepare any kind of visual aids to help in your testimony as it relates to the analysis of these cell phones that would also help the jurors understand your analysis?
I did.
Okay, and would that so help you?
I believe it would, yes.
Okay. Your Honor, permission to use the visual aid?
You mind?
Thank you. Okay. Now you talk about the analysis of the cell phone. What are we looking at here on this first display?
It's just a cover page here, sort of depicting the background images, cell sites as they are here in Tallahassee. We'll cover those more in detail as we get a little further in.
Okay. So how is it that you go about doing this analysis?
Well, the first thing that we got to look at is the kind of information that we can get. Two of the carriers that we've talked about is Verizon Wireless and Sprint. So from Verizon Wireless, they're able to provide us really 4 different types of information. And that is what we call a call detail records report, which has the incoming, outgoing phone calls, dates and times and things like that. They have a text message report, which tells us the text messages that are being sent back and forth. And from Verizon, that's a separate report. We have a content report where they actually can send us what was actually sent in a text message back and forth. Sometimes we're able to get that. And then the 4th report that we get from Verizon is called an RTT report or a distancing report. And it's much more like an engineering type of report. It has some very, very detailed information about the network and the handsets and what's going on. So the first thing we do is we look at those 4 types of information that we can get from Verizon.
Let me ask you a question real quick as it relates to the text message detail that you're talking about here. Does this give you content of the text message or just information as it relates to who sent it, who received it, things like that?
So the text message detail report that we can get on a regular basis does not have the content in it. It just says this phone number sent a text message to this phone number, this date and this time. The content is a separate report, and we're not always able to get that, but it is separate.
Okay, and I assume we're going to talk about that a little bit later.
We are, yes.
Okay. All right. So what are we looking at here? These are just basically what the raw data looks like? That's
it. Just an overview of the 4 types of reports that we're able to get from Verizon, and we'll talk about each one of those specifically as we go through.
Okay. What's that?
So this is the call detail records report. This is exactly how it comes to us, and you can see as we talked earlier, there are a number of columns and a lot of different information that comes across. That's sort of what it looks like in the raw. The good thing is Verizon sends us a key. They send us some information to help us decode this, to tell us what those columns mean and what that information represents. So by using that guide that they send us and our training, then we're able to take a look at those records and sort of deduce the information that we need.
You've gone pretty quick here. I assume we're going to slow down and kind of explain this a little bit more.
We are, yes. We'll talk about each section, each column.
Welcome back to Law News Network. I'm your host, Jesse Weber. We apologize. The feed in the Henry Seura trial got cut out. But in the meantime, as we wait for the feed to come back, let's talk a little bit about Tiger Woods before we went to Segura. Tiger Woods has pled guilty to a lesser charge of reckless driving, and it appears that his DUI conviction he won't be convicted of a DUI, and those charges will be dropped. Before we were interrupted, I was talking with our guests here today, Maria Marino and Ken Belkin. Maria, we were talking with you a little bit about the idea that Tiger would plead plead guilty to this and how it would affect his reputation as an athlete and his career right now. We don't see the same Tiger Woods that we once did, and I had to interrupt you to go to Segura. Please tell us what you were thinking about.
You did have to rudely interrupt me,
Sorry,
but we are back.
I'm terrible.
That's okay. In terms of this latest case with Tiger Woods, I don't think it really affects his career and reputation all that much. I think in terms of those things, the damage has already been done. Everything that came out with the scandal in 2009 painted a certain character of Tiger Woods. He lost lots of money in endorsements at that time. After this latest incident, Nike has said that they would stand by him, and so far no other word on his other endorsements. He might end up losing that as well. But in terms of his play as an athlete, he hasn't been actively playing. Whether we're going to see a comeback in Tiger Woods' career, I think is more dependent on his health, and his health is not there. He hasn't played, he's played 2 tournaments in the last 3 years. The last time he won a tournament was 2013. The last time he won a major was 2008. So we certainly haven't been seeing Tiger Woods going out there and playing golf to a high level. He's had 3, I think now 4 back surgeries since 2014. So is he going to come back? Probably not. And so I don't necessarily think that this latest thing, especially because I think we have a lot of sympathy now for the fact that his health has been so poor. We talk about prescription medications as being an issue in this country with addiction, et cetera. And this is a guy that's been dealing with pain. And I think a lot of people in the public eye are pretty sympathetic to that.
Mm-hmm. Yeah, and like you said, he's not the same golfer that we once saw. And
not at
so,
all.
You know, you look at these contracts that he's involved in with these different companies for endorsements, there's morality clauses built in where that says if the athlete does something that harms the reputation of the brand, they might be able to exit the contract. And here, if you have a player who's not playing like he once did, he's not winning tournaments, they might be more eager to get out of those contracts than you would see. And we talked about this a little bit in the break. Even if Woods does come back, he's competing against golfers that we haven't seen the likes of in the 90s or early 2000s. We have Dustin Johnson, Ricky Fowler, Jordan Spieth. These are golfers that are 10 times, they're hitting the ball further, they're playing a game that is comparable to Woods. So whether or not we see him make a comeback is up for debate.
Absolutely, and I think part of the idea of him making a comeback, part of what makes it so intriguing is because we have this nostalgia factor. We remember Tiger Woods as being so dominant, and not just how dominant he was, but how quickly he ascended to stardom, unprecedented with what he was able to accomplish, and how quickly he was ranked #1 in the world, which, by the way, this is the first time that he's been ranked outside the top 1,000 golfers in the world.
1,005, right?
Yeah. Something like that.
Yeah, it's about my rank, actually.
Yeah, no, it's crazy to talk about. It's crazy to talk about with Tiger Woods because I was a huge fan. I'm still a huge fan of the athlete, and I hope for the best.
There's a significant upshot here. Maybe you can get a sponsorship deal with Vicodin or Zen.
That's a good idea, Ken. But in the meantime, you hold that thought because we do actually have our feed back in Henry Segura. So let's turn now to that trial, and we'll be back here with more coverage on LawNewz Network.
Investigation. So the last that we have here, the last 3 columns, this is our called and calling numbers and the duration. So here we can see which number was the calling number, the one actually doing the calling, and which one was being called. So this is another way that we could deduce incoming or outgoing just by looking at these. I wouldn't necessarily need that forwarded or originated column, but they help us out with both. And then the last there is that seizure. And that is in seconds, and that is how long the phone call was connected or how long that event lasted. So again, we sort of divide that by 60 seconds to get minutes, and that tells us, again, approximately how long the phone call was. Certainly.
I looked at it, it says called number, and it appears that there's a bunch of them that are from the 509-4380, and the last one appears to be 321-8577. Does that indicate that these first ones are incoming and that last one is one that was dialed by the 509 number?
Certainly. So the calling party number, again, is the person doing the calling. So we can look at that and say for this first line, 850-644-1371 is doing the calling, and they called number 850-509-4380. So knowing that 509-4380 is our target, we would know that that's an incoming call. And as we keep going down the list, we keep seeing that our calling party continues to be something other than our target number until we get to that last one in the example. So there, the calling party is the 509-4380, and it has dialed the 321-8577. So we know that that would be an outgoing call.
Okay, and I think you covered this, but these numbers for the seizure of the length, that's in seconds, correct?
That is in seconds, yes.
Okay. All right, what's next?
So the next report that we get from Verizon would be the text message report that we talked about. It's very, very similar to the call detail records report. You can see that there's a date time column, there's a target number column, and we can see the origination and destination. So that would be our calling party and receiving party again. So we know which phone is texting which phone. The thing to note here is that, again, there is no location information provided with this text message report. We do not see the cell sites or the sectors that a handset was communicating with in this particular report. Then the next thing that we have is the text message content. So again, sometimes we're able to recover the actual content of the messages from the carrier, and the report looks like this. If I can get a little more detailed, we can see that there's some information here at the top left. We can see that there is the message arrival time, and so that tells us that this particular message was at 10:36 p.m. And I got to kill an application here. 10:36 p.m. on 11/11. We can see that there is a originating number, which will be the 570-8339, a terminating number, which will be the 509-4380. So that tells us that this is an incoming to our target. And then we have the actual text message content here, which would be just a voicemail notification in this example.
Okay, what's next?
So next we would see this RTT report that we talked about. This is Verizon's engineering report. It's a very detailed, very lengthy report with a lot of information in it. But the most important thing that we get from this report is not only do we see the cell site and sector, but we also see an approximate distance from the tower that Verizon is reporting to us. So we will see this access distance in miles. So we can see the first one there is 0.15 and then 1.78. So not only do I have the cell site and the sector that it's using, but now I have an approximate distance from the tower. It sort of helps me narrow down that area to some degree. In the RTT report, we also get location information for text messages. So even though I don't have it in the text message report, if I have this distancing report, I do see locations for text messages, and I might also see locations for data events. So the RTT report is an important report for us, particularly if we're trying to identify where a handset might be or where it was or where it's going.
Okay, if I can, real briefly, the RTP data and the distance calculations here, if you can give a very brief overview, how is that calculated? Are you aware of that?
I am. It is a little complicated. The Verizon, or the type of network that it is, the technology that it uses, sort of uses codes to scramble and identify unique subscribers. So there is this long code that is transmitted from the tower, and it's transmitted at a very specific rate, and these little chips of information come out, and we know exactly how fast they're traveling, and we know how often they're sent. So if we know when that piece of information left the tower, and we know when it arrives at the phone, and we know how fast it was going, then simple, a time of arrival calculation can say, well, if I went a mile at 60 miles an hour, or I traveled for 1 hour at 60 miles an hour, then I must be 60 miles away. So it's sort of it's a very simplified explanation for it, but it is that distance of arrival.
Fair to say we're talking about a lot faster rate than 60 miles an hour, but the same kind of calculations?
We are. It actually travels at the speed of light, and very, very quickly, in very, very small units of information. But yes.
Okay, thank you. All right, what's next?
So the next thing, that's all the information that we get from Verizon. The next carrier that we talked about was Sprint. So Sprint provides us with two reports, and that would be our call detail records report, which is very, very similar to Verizon's call detail records report. And then they have what they call their per call measurement or reveal report. And it is, again, sort of similar to Verizon's RTT. So those are the two different reports that we're able to get from Sprint. So here's the Sprint call detail records report. You can see the same type of columns. We have an indication of numbers that are calling, being called, direction, dates and times, duration, and we'll look at those in a little bit more detail here. Thankfully, again, Sprint sends us a key here to help understand the records so we know what all the columns mean. And then we can look at each of them individually. Again here, calling, called, and dialed digits. This is just like our originating and terminating numbers in the Verizon records. It tells us which phone number is making the call and which phone number is receiving the call. As we go further across, we see that we have this MR or directionality, and here instead of the MTMO, we see incoming or outgoing or routed. If it goes to voicemail, it may be routed. We see not only a start date, but an end date. They give us both. They also give us a duration. This is again in seconds, so we have to divide that by 60 to get to the minutes. And one of the things that we see is that text messages will not have a duration. Obviously, they're very, very short. And we're talking about SMS or short message or text messages. They sort of all mean the same thing. But when we send a message to someone across the network, that would be a text message. No duration, and they do not give us locations for text messages in this report. Well, the other thing to note about the text messages is they're delivered to us in Central Time. All the phone call activity would be in switch time, which would, again, for Sprint would be Jacksonville, the same as Verizon. But the text messages, because where Sprint, the actual office is located, those text messages come in Central Time. So when we see the report, we got to make an adjustment that, hey, the text message is going to be an hour behind. We got to move it up.
And that's because their offices are located in Central Time Zone?
That's correct.
Okay.
Then the last column we have is the same as we saw with Sprint, or I'm sorry, with Verizon. Their repolled is the same thing as a Verizon switch, and instead of naming it, they give it a number. And then we have this first cell and last cell. So that's our beginning and ending cell sites and sector. So just like with Verizon, we know the cell site that a handset was communicating with for a particular event. So going to move on to sort of how we plot these and how they would look and plotted on a map.
Okay. What are we looking at here?
So this would be an example from the Verizon records, and we talked about that cell site and sector as the location information. So we see here that originating is cell site 844, and we have a sector of 3 equals beta. Beta is actually, that tells us that it's side 2 of that tower. So I know that I'm looking for 844, so I go to this rather large cell site key that Verizon sends us, and I can find cell site 844, and it gives me all the information about the different technologies, the orientation of the sectors. So most of our cell sites are actually divided into multiple sectors, and they have antennas that point in different directions. And it's really important for us to know which direction those are pointed, because if I know which side of a cell site a handset is communicating with, that gives me an idea of which side of the tower that handset was on. So if my tower's in the middle and I'm communicating with the cell face that's here, then I know my handset is going to be over here somewhere as opposed to on this side. So that cell site is really important for us to help narrow down the area that a phone could be in. So they give us all that information there, and if we sort of focus that down to the important stuff, it tells us that cell site 844 is located on Putnam Street. That gives me the latitude and longitude of the cell site, and it tells me those 3 sectors and exactly which azimuth or what degree those different sections or sectors are facing.
When you say degree, you're talking about the compass, the 360 degrees of the compass?
That is correct, yes.
Okay.
So if we go to the map, we can see this is Putnam Drive, and if you kind of look close there, we can see that there is actually a cell site there. It's a tower. Yep. And it's actually, we don't call them towers. We generally call them sites because they're not all actually built on towers. A lot of them are on poles. Some of them are attached to sides of buildings or water towers or whatever. So you'll hear me say cell site. So if we take and represent those 3 sectors, and again, we know from the records, we have one sector that should be at 355 degrees, one at 125 degrees, and then another at 245. Then I can put 3 arrows on the map, and those arrows are pointing in the directions that those cell faces point. And it'll get clearer here in a second. So we drop out the background here. It makes it a little bit easier to see. And again, this would be our cell site 844, and that would be the direction that those 3 sectors are facing. They line up with the compass points so that we know that we're accurate in how those are represented on the map. And then as we draw the rest of them around town, we can get an idea of where the various cell sites are located and what direction those sectors are pointing in. So if we're going to represent, if we're going to say it was communicating with Verizon cell site 844 sector 2, well then we will highlight that sector. So here it's a larger blue arrow. So for that one sample event that we're mapping here, this is the cell site and sector that the handset was communicating with.
Okay. Now, I know when we went back, we talked about that compass and these different degrees that the cell sites are facing. Is there a hard and fast line, essentially, where it drops from one sector to the next sector?
There is not. The sectors have to overlap. Otherwise, you would lose coverage as you just drove circles around a cell site. So the sectors have to overlap a little bit. The cell sites themselves overlap a little bit so that we maintain coverage. So there's not a hard and fast line where sector 1 ends and sector 2 begins. It's a sort of a fuzzy area. It's not super big, but there is that area that we'd expect the phone could talk to either sector. And as you move further into the main part of that sector or more in front of that orientation, then we'd expect that that is the sector you would talk to because you would no longer be able to see the other sectors. So here that's just represented by the little dashed lines. When we talk about sector 2 of this cell site, we would expect it to cover approximately this area. So here out, down here out, but that would be sector 2. And somewhere along this line right here, if a handset were moving around, we would expect it to transition from sector 2 up to sector 1. So one of the other neat things that we talked about was the distancing information that we're able to get. So for this sample event, we're given a distance. And so now, instead of talking about the whole area out here that the handset could have been in, Verizon is telling us that that handset was very close to this distance here. So again, I know that my sector is going to change somewhere right about here and somewhere right about here. So I'm really only looking at this arc that comes around right here. This is the part that I'm looking at. That is where, approximately where I would expect to find my handset for that particular event.
So why are we doing a full circle?
Well, we do a full circle because our mapping program, and we use the same mapping program that is part of the city-county mapping. So it's the same mapping that we use to respond to calls for service and the property appraiser uses. It is sort of the official mapping for our area here. And they have some wonderful features and are able to do a lot of really neat things to help us represent. But right now they don't draw arcs. And so we have a circle that tells us, again, that distance, but we know when we're looking at it that we can exclude this part of the arc because we're talking about this cell site and sector.
Okay. What do we have next?
So one of the things in the RTT report, sometimes we not only see the primary cell site that a handset was using or communicating with for an event, but sometimes the handset is also aware of other cell sites that it can see. And when I say see, I mean communicate with. And if it were to need to transition, if it were moving and I wanted to go from one cell site to another or hand off, then it is aware, well, this cell site's over here and I can see it with such and such quality, and there's a cell site over here that I can see with such and such quality, and one back there. So it's sort of always aware of what options it may have. So sometimes in the report, we're able to get distances from those cell sites as well, the alternate cell sites or active set or whatever we want to call them. But there are other cell sites in the report that are giving us a distance. So if we have those and we can plot those as well, then we start getting arcs. We start getting crossing arcs. And we say, well, 2 circles can only cross in 2 places, 3 should only cross in 1. So those, if we have those other distances, kind of helps us narrow down the area, even on that 120-degree arc where our handset might be. And in this case, we do have some different distances. And so we say if we're approximately this far from this cell site and this far from this cell site, then again, that kind of narrows down the area that we would expect to find our handset in.
Okay. And is that basically how you analyze this data?
That is it. That is how we take it from the raw records, find that cell site, put it on a map, highlight it, draw the lines, and make a determination where a handset may or may not be.
Okay. Now, next we talk about the cellular data that you may have analyzed during the course of this particular trial. The investigation. What are we talking about? What's the first analysis you did that we're talking about?
The first analysis that we looked at was the 17th of November, a couple of days prior to the homicide.
Okay, and whose phone were you looking at as it relates to this? Are we talking about Mr. Segura's phone?
We are, yes.
Okay, both of those 509 as well as the 408 number?
That's correct.
Okay, did you prepare a visual as well?
I did.
Okay, can you show it to us?
I will. Take me just 1 second to switch over.
All right. And we're talking about November 17, 2010.
We are, yes.
So we're talking about 2 days before the homicide, correct?
That's correct.
Okay. I noticed that you made a distinction here, the 509 versus the 408. We're calling it the disclosed and undisclosed phone based on interviews, correct?
That is correct.
Okay. What are we looking at here?
So again, we sort of start these off with just an overview. This is the general area of town that we're looking at, which will be sort of the south or southeast side of Tallahassee. There's a couple of addresses of interest that are marked on the map, and then we see the cell sites. So those are all, as we're both phones are Verizon, those are the Verizon cell sites in that area at the time of the incident, and that's sort of where we start.
Okay, you mentioned addresses of information. 908 South Creek Run, what address is that?
That is the victim's residence.
Okay, and then the 1098 Mustang Drive, what does that address indicate?
That was Mr. Segura's address.
Okay. All right. So if you first take a look at it, it looks like 509-4380?
That is correct.
Okay, what are we looking at here?
We're looking at a period of time in the early afternoon hours of the 17th, and based on the information that I had, Mr. Segura had traveled to Ms. Peters' residence, so we were looking at the events in that time frame to see what the records look like. From his primary or disclosed phone, the 509-4380, we saw that all the events after about 1:03 and up till 3 o'clock were passive, meaning they're incoming events. So all of these 3 phone calls that come in at 1:15, 1:36, 2:27, they're incoming to the phone and they get forwarded to voicemail. They're not actually answered or picked up. We saw that there was an incoming call at 1:36 from Ms. Peters' phone, which was the 590-8171. And then we saw again here all of these are communicating with, as we can see, 850 or 851. So if we look at those on the map, we can see that here's Verizon 850 Sector 2, which is over here. And then we also saw the very last one communicated with a cell site that's over here.
Okay. And then I noticed that it looks like you did some distance calculation as well.
Well, not calculation. I'm just representing the distance that's in the records. So if we plot those on the map, then we can see that this is what Verizon tells us would be the approximate distance from the cell site that handset was for all of those events.
Now I noticed that we're assuming he's at the house because you're getting both in the house in the middle. Why would the 2 arcs there not line up on his house?
Well, we see that on most of the events as we go through this, that the estimated distance is a little bit short of where we actually are. And there's a lot of things that go into that calculation, but we see it rather consistently that the distance portrayed is a little short of where the actual location is.
Okay. And I think the key word there was estimated distance.
That is correct, yes.
Okay. All right, what's next?
So We talked again about possibly having some additional distancing, the other cell sites that the handset may see for an event. Those are also very consistent with what we saw for the first. So we would say that it was consistent with that handset being at Mr. Segura's residence during that time frame.
And this is all the 509 phone number that Mr. Segura initially provided to law enforcement, correct?
That is correct, yes.
Okay. Did you also take a look at the 408 number, which is the one that he did not disclose to law enforcement?
That is correct. So here's the excerpt of records for that time frame. As we zoom in a little bit, we can see that not only do we have some forwarded events, but we have some originating events. So we do have some outgoing phone calls that's sort of in that same time frame. So it tells us this handset is being used.
Okay. So that that's an indicator. The other phone, if I understood you correctly, was a passive. Everything's kind of incoming, but nobody's actually sending anything out. And meaning nobody's manipulating the keyboards or stuff like that.
From the records, that's what it would appear, yes.
Okay. And then this one indicates someone's actually manipulating the phone in some way.
That's correct.
Okay. What's next?
So we start looking at those events, and we go to our RTT report to get those detailed pieces of information. But our 12:41 p.m. in the afternoon, we have an outgoing voice call that's Verizon 850 Sector 2. And this is the same one we just saw a second ago with the other phone. So we know that it's using the same cell site the other handset was. We were provided distancing information. And if we compare sort of the one phone to the other, the undisclosed phone being represented in red and the disclosed phone being represented in green, we can see that they're reporting sort of very similar distances, same cell site, same sector, and that would be consistent with those phones being together in that late 12, just before 1 p.m. time frame.
Okay, so we're talking about this is a single phone call on the 408 number at 12:41 p.m. on the 17th, 2 days prior to the homicide.
That's correct.
Okay. Did you do another analysis, another call on that particular day in that phone?
Yes. As we continue looking at the records, we see that this handset begins communicating with different cell sites. So now for a 1:48 p.m. call, about an hour later, we see that it's communicating with now Verizon 847, which is a little further. It's up Woodville Highway here, just inside of Capitol Circle, and we're provided with a distance, the sector and the distance that puts it along this arc right here.
Okay. So we're talking about roughly this area right here is what this is communicating, correct?
That's correct.
Okay. And I think this is Tram Road in this area, is that correct?
It is, yes.
Okay. All right, make sure we're in the right area.
Yep, that's Tram Road right there.
Okay, take a look at another. I see we do additional distancing.
We did. For that event, the handset was able to see some additional towers, report some additional distances. So when we represent those on the map, we sort of get a couple of crossing arcs there. And again, that gives us just a little bit better idea where the handset might have been for that event.
Okay. And I think we heard from, if we can go back just a second. And I think we've heard, or the information is that Mr. Segura was over at her house on the 17th. This information, would that be consistent with that at that time?
It would be, yes.
Okay. All right. What's the next call with that?
We had an event a few minutes later, communicating with a different cell site, one a little bit further south, and we're given a distance from that, which is represented here. And then we also have, for this event, some additional distancing. So it's actually being able to see a couple of different cell sites in a few different sectors and reporting those distances.
Okay. What's the next phone call?
So we now have an event 154, and we're communicating with 847, Sector 1, this same cell site that we're going to talk a lot about. And we're given a distance, again, sort of consistent with that first one that we saw, and only one distance for this event.
Why would sometimes we get one and sometimes we get more than one?
It's largely based on the type of event that it is. With the short message service or the text messages, they're a relatively short blip of information, so the handset doesn't really need to know the other.
Welcome back to Law News Network. I'm your host, Jesse Weber. You're watching the Henry v. Segura trial. This is the case out of Florida. This is the case, the quadruple homicide case. You're watching testimony about cell phone sites, as I should be corrected. They're talking about cell phone sites and particularly where Henry Segura was on the day of the event. And actually, we're going to be turning right now back to our coverage. Just wanted to give you an update about what's happening in this case, and stay tuned for more analysis and coverage here on the Law News Network.
Would that allow them, I guess, to reach out to a farther location than they would if they were in a dip?
Yes, it does.
As it relates to 908 South Creek Run, where is that indication? Is that memory serves me, there's kind of a hill that runs through your follow up earlier.
There is actually, and that will come into play for a lot of the locations that we look at. Sort of Paul Russell here is the top of a ridge. And as you start down here on Tram Road and work your way through the neighborhood and up Saddle Creek and then start coming up Jim Lee Road, you are actually coming up a hill. And you're coming up to the top, and when you get to the traffic light here, and then you start down the other side in front of Rickards. If you've driven in front of Rickards High School, you know that you're going down a hill there. So this is kind of a ridge. And the further that I travel up this, the higher that I get. And just like with the naked eye, I can see further. My handset can also see further. It can see cell sites that are a little further away. So it might be more inclined to reach out for a cell site that it has now a more direct line of sight to, better able to communicate with. So we see that as the test events, or as our mapping locations move up the hill, we start to see different cell sites that it communicates with.
Okay. We'll move on to the 212.
212, again, our 849, which is that cell site that's a little further south. And we have some additional distancing for that one.
Okay. Now it's interesting. I think this is our first part here for the 849, but with the secondary distance, it's actually moved up a lot closer to the home.
It has, yes.
Okay, so that would tend to indicate maybe the home is still that handset, even though it's communicating, and that first part that is communicating with 849, it's still maybe in that same area. Correct?
That is correct, yes.
Okay. All right. Let's look at the 239 phone.
Yep, we have a 239. It's an outgoing voice call. Again, this cell site, we can see our distance that's reported and some additional distancing here. And again, looking at the averages of these, it remains consistent with the Saddle Creek Run address.
Okay, how about 245?
So 245, we're our same 847, Sector 1, but our distancing has gone a little further now. It's actually got a little past the residence. We look at our additional distancing, they're relatively consistent, and it may be consistent with a location that's a little north or maybe moving just away from that area.
And it kind of looks like that's actually almost on Paul Russell Road.
Certainly Paul Russell Road will be included in where that handset could be, yes.
And that is one of the possible exits from Ms. Peters' home, correct?
That's correct.
Okay. All right, and look at the 246 phone.
The next event we see is a 246, an outgoing voice call. We have some distancing and some additional distancing. And now here, a few minutes later, we see that we moved from this area possibly down to this area here.
Okay. And once again, I noticed one of the intersections is there coming down essentially Crawfordville Highway.
That's correct.
Okay. What's next?
Then we have an event several minutes later, 259. We're now communicating back with our Verizon 850 Sector 2. We see our distancing here as it relates to Mr. Segura's residence. And our additional distancing, all again now being consistent again with that residence.
And that would be, eventually we would go down Crawfordville Highway to get to that location, correct?
That is correct, yes. That would be one of the routes would be to come down Crawfordville Highway and go across Oak Ridge Road.
Did you do a comparison as it relates to the 408 number, which is the undisclosed phone, and the 509 number, which was the disclosed phone?
We did, yes. Okay. And looking at those events in between the 1 o'clock, 3 o'clock kind of time frame, we can see that the disclosed phone, again here in green, is communicating with different cell sites, different sectors, different distances than the undisclosed phone, which is represented in red. It would be consistent with those phones not being together.
Okay. What's next?
So we have the additional distancing, just throwing in the other numbers that we have, and again, represents the same.
All right, so what does this tell you about those two phones? Were they together or separate?
Well, just judging by the cell sites and sectors they're communicating with, they do not. It's not consistent for them to be together, to be in the same place. Taking into account the distancing, certainly not. So it would be inconsistent with these phones being together.
Okay. And earlier we saw the overlay where they were both essentially together at the earlier communication in the neighborhood of the 1098 Mustang Drive, correct?
That's correct.
Okay. What's the next analysis you did?
The next time that we looked at was actually the 20th of November, which would be the morning after the homicide.
Okay. And it's my understanding at that time, Mr. Segura's his statement of law enforcement that he had gone down to Mr. Thornton's home, correct?
That is correct.
In South County. All right. Can we take a look at that?
We can. Again, it'll take me just a second to transition.
Yes, sir. All right, so it looks like our first look is, again, we have the 1098 Mustang Drive, which was Mr. Segura's home.
Correct.
What is the 56 Natural Bridge Lane?
That was Mr. Thornton's residence at the time.
Okay. It looks like we're going to look at the 509-4380 phone number.
That's correct. And again, we're going to look at both of them together to see if they were traveling together or not, to see if they're consistent with traveling to the location that they reportedly did. So if we look at both sets of the call detail records, we can separate those out for the time frame that we're looking at. And again, that would be that Saturday early morning into Saturday afternoon time frame. And then we can actually kind of put them together here, take out all the columns that don't matter a whole lot for us. And we can see that the 408 in red, the 509 in green, they seem to be communicating with sort of similar cell sites. They seem to be, changing cell sites together. They're both communicating with different cell sites than we've seen before. So that's kind of our first look at maybe they're traveling together.
Okay. It looks like the first call, or the first event we're going to look at is a 605 phone.
That is correct. So 6:05 a.m. From the undisclosed phone, there's an outgoing call. It communicates with the same Verizon 850 Sector 2 that we've seen before, and we know is consistent with the residents.
Okay, what happened next?
The next event we have is 8:34 a.m. Again, the outgoing call from the undisclosed phone. And now we've communicated with a cell site down here off Bloxham Cutoff. We're looking at this cell site that's sort of facing the southwest. So we would, from the 6:05 event to this event, the handset appears to have moved south and now be somewhere down Crawfordville Highway.
Okay, what's that?
Next we have is at 10:21. So this is from the disclosed phone. We have an event that's now communicating with a cell site here in Panacea. So again, that will be consistent with even further travel south and definitely towards the area that it was reported to have gone.
Okay. And it looked like the first two, you get a green arrow here, and the first two that we looked at had the red arrow. Are we talking about the two different phones?
That's correct. Again, as we look at all of this, the undisclosed phone will be represented in red and the disclosed phone in green so that we're able to see which of the two handsets we're talking about.
So it appears that at least in this morning, he used both of those phones.
That is correct.
Okay. What's the next number?
So 10:21, we're now communicating with a cell site here closer to South Choppy, and which would be Verizon 858 and Sector 3. 12:11, we now have, as it's read, the undisclosed phone, and that is communicating with Verizon 861, which is down here closer to the coast, and that one sector of that, which is the one that's facing north. 12:15, we have from the disclosed phone an outgoing phone call, and it is also communicating with that same 861 Sector 1.
All right. I haven't seen any of the distancing stuff. Did you do any distancing analysis here?
We did. Oftentimes, just knowing the cell site and the sector is all that we need to know that it's consistent with travel in this case. So now we have two events that are just a few minutes apart. So we have a 1211 phone call from one phone, a 1215 phone call from the other. So now they obviously couldn't have moved too far apart. So we can look at those two events together and see if we can be a little more detailed about whether or not they're actually maybe in the same place. So we can do that with the distancing. Both that 1211 and the 1215 event is in the RTT report. And so we can look at our the undisclosed phone, and we get our distancing here, which again, a little short, but pretty consistent with our location, or estimated location. Some additional distancing. So down here, it's a little flatter. We're able to see more cell sites, so we report a number of distances. Those are, again, sort of intersecting there, very consistent with where. We can look at our disclosed phone. We see that we get what appears to be a very similar distance, same cell site, same sector. We have some additional distancing from it. And then we can kind of put them both together. So here's our distancing for those events. Again, the red being the undisclosed, green being the disclosed. You see that they're very similar reported distances. And actually, we can add in the additional distances. We can see that these are pretty consistent with both these handsets being in approximately the same location. And we have one final thing. It'll take just a second to load here, but oftentimes when we're trying to look at the distancing of two Verizon handsets on the same map at the same time, if they're reporting the same distances, then we're kind of drawing lines on top of lines. So there's another way for us, if we do that, the line on top of line, then we can't see if it's red or green. So we're able to actually do another type of map here where we can sort of superimpose the two together. So again, the red events would be the undisclosed phone, the green events being the disclosed phone. And as we swipe across, we can see that at least a couple of these distances here and here are being reported pretty much identically. But this gives us the ability to kind of look at both of those distances together without worrying about drawing one line right on top of another.
What was the next analysis that you did?
So the next analysis we did, we started looking at the 19th of November, which is the date of the homicide. We started looking at the victim's phone here, Ms. Peters' phone, and trying to see what events we may be able to learn from that.
Okay. Can we take a look at that, please?
We can. And again, it'll take me just a second to transition.
And I think that we talked earlier that Ms. Peters' information is actually Sprint, not Verizon. Is it a little bit different?
That is correct.
Okay. What are we looking at here?
So this is just the overview. This is the Sprint call detail records for the 19th for Ms. Peters' phone. We talked about the Sprint records before and the kind of stuff that's in there, the cell sites and the incoming, outgoing dates and times, all that. So what we wanted to look at here was sort of more what kind of activity we had. So we can actually kind of pull out some of the stuff, the location stuff, and kind of look at whether the events are incoming or outgoing and when these events are happening. What we see is that we have, starting here at the top, 5:51 p.m., we have an outgoing phone call. Then we see an incoming, an outgoing. These will be text messages here. And then after about this time, just before 7 o'clock, we start seeing that they're incoming, and these 333 would be like a notification, maybe a voicemail notification or something. But we start seeing that everything is now incoming or routed. So we can kind of make a determination about the passive versus active. We talked before about whether someone is actually pushing buttons on the phone and making something happen or not. And that being a little bit of a clue to us whether the handset is being used or not. So we look at those events and look at them as whether they are active or passive.
Okay. And it looks like, and this is the
That is correct.
And by looking at this information, it appears that you have a couple at the top here that are both active and passive events, with the last passive event active event, being at 6:53 p.m.
That's correct.
Okay. The next one appears to be at 6:50. Actually, it looks like there's two of them at 6:55.
Yes, and these are, again, the notifications. It would be a text message, and with that short code there, it would indicate to us just a notification sent from the carrier to the handset. Most often, that's like voicemail notification.
Okay. And those appear to be a passive event, so indicating she's not doing anything with them, correct?
That is correct.
All right. And then again, we have another one at 7:13.
Correct.
Still passive?
It is passive. The direction tells us that it's routed, and actually we see in front of the number here, we see a 1-1. And if we go to Sprint's records key, it tells us that calls routed straight to voicemail will have a 1-1 before the number. So when we see that 1-1 here with these calls, and these will be text message notifications again, but for all the voice calls, we start seeing the 1-1, 1-1, 1-1, and again, Sprint tells us that means they were routed straight to voicemail.
Okay.
And I don't mean that someone had to push the button to send it to voicemail. I'm saying the network sent the phone straight to voicemail.
Okay, so that's the network doing that, not necessarily.
Yeah, I mean, it can be either one, but for this case, it does not require someone to actually hit ignore, and not take the phone call. The network is going to either try to reach the phone and not be able to do it, or once the phone leaves the network and the network knows that the phone's unreachable, then it'll go straight to voicemail. If you've called someone and their phone is on and it rings and rings and rings and it finally goes to voicemail, versus if you call them and immediately goes to voicemail, the network knows the phone's not available.
Okay. So as it appears from this, that starting at 6:53 then, the following 6:53 event, from henceforth there are no more active communications, meaning nobody was manipulating that phone with the speeder's phone, correct?
That is correct.
Okay, and that's from that 6:53 p.m. all the way until the body was discovered?
That is correct. Of things that we look at, the voice calls are important to tell us whether maybe the phone is reachable or not. So we see that there is a voice call here around 6:11. We see that we have a voice call at 7:13, and then the next is 8:21. So I know that we've got at least 3 voice events there in the evening that may help me determine whether the handset's reachable. We do that by going over to that distancing report or that per call measurement data report that Sprint has. And again, being a network report, it gives us a little better idea of what's actually happening on the network side. We can take out all the things that aren't really relevant to us here. And we see that in this per call report, I do have my voice call just after 6:11, 6:12 right there. I do see that in there. I see the text messages that we saw. I see the 7:14, which we rounded up from the 7:13. So that one voice call we saw in the records at 7:13, that is in my per call report. So
and again, this was not one that was an active, it was a passive event.
That is correct. It is an incoming phone call. Our data sessions here, we do have a little data activity. Does not have to be active. Can be your phone checking voicemail, Facebook, email, those kind of things. They can be passive events from a phone. But I do see that 7:13 call was not answered. We saw in the records that it was routed straight to voicemail, but the phone was on the network at that time because it is in our per call report.
So what does that mean? It's on the network.
Well, it means that the phone was in communication with the network. Even though no one answered the phone itself was still seeing the network, and the network reported activity about the phone, approximate location, and other things about the phone for that event. But what I don't see is the 8:21 phone call. So we knew that our next phone call in the report here was at 8:21. So this 8:21 call that is also routed to voicemail is not in the per call report. So at 8:21, when someone tried to reach the phone, the network had no information about where the handset was or what it was doing at that time.
What does that tell you?
It tells me most likely that the phone left the network for whatever reason. Powered down, turned off, ran out of juice, whatever it might be.
Okay.
So again, as This passive data event at 7:49 is the last event that I have. The 8:21 call is not. There's nothing else in the per call report after that. It's consistent with that handset leaving the network in that time frame.
Okay, so as I understand it then, our last active event is at 6:53, and then at 8:21 there is an event that we know the phone is not communicating with the network, correct?
That's correct.
Okay. And just for clarification, were you able to do any kind of analysis of the actual phone for Brandy Peters?
No, it was never recovered.
So it was not found on scene?
No, it was not.
Okay. All right. What are we looking at next?
So we were looking to see if there were communications or who she might have been communicating with that day. Obviously, we were became aware of Mr. Segura's numbers. So we can take her call records and filter those down to communication events between her and either of Mr. Segura's numbers. We can see that starting in the morning of the 19th around 11:30, 1:18, we have a number of voice calls here. This 219 is a text message, but we have a number of communications between Ms. Peters and the 408, which will be the undisclosed, and we have a text message with the 509, which will be the disclosed.
Yeah, just for clarification, it's 590-817-1. That's Ms. Peters' phone number, correct?
That's correct.
Okay. So it looks like we have 1, 2, 3, 4, 5, 6 phone calls or events that are going where Mr. Segura's undisclosed phone, the 408 number, is contacting Ms. Peters' phone.
That's correct.
And some of those are actual conversations that have length to them.
That's correct. The first one is 3,300 seconds.
Okay.
Do the math.
We have an outgoing text from Mrs. Peters' phone to Mr. Segura's main phone, the 509 number.
That is correct.
Okay. And then subsequent to that, we have an incoming call again from the 408 number to Ms. Peters' phone number.
That is correct.
Okay. And let me ask you this. If someone was utilizing a star 67 feature or something like that to block the caller ID, would that show up in this report?
It would not show up in this report because we're looking at our target number here is Ms. Peters' record, so that phone that was doing the star 67 will be incoming, so we wouldn't see it in those records. We would need to go to the person who's doing the calling and look at those records to see what they were actually pushing into the phone.
So if I understand you correctly, then the star 67 feature, if utilized, it obviously blocks the caller ID on the person's phone who's receiving the phone call, but it doesn't necessarily block the information for the network as far as these phone records and things go.
That's correct. The network, we still had to be able to route the call. So while it doesn't present the caller ID information, the network still has to know the number that is placing the call. So we will see the phone number in there. We just don't know for Sprint, for these records at this time, we don't get any indication whether the caller ID was present or not.
Did you do a comparison between this information that came from Mrs. Peters' Sprint records to anything having to do with Mr. Segura's phone?
Yes. Obviously, if we see the incoming calls in the Sprint records, we would expect to see the outgoing calls in Mr. Segura's Verizon records. So indeed, we look over at those and we can see the same events that we just saw, the 3,300 second event, the other phone calls that went to voicemail, the 100-some second events. We see all of those here. And what we see on the Verizon side is that the called number, or what was actually the number that was communicated with, is preceded by the star 67.
And it's just, obviously we've talked about it, but star 67 is the function that would block caller ID.
That is correct.
So Ms. Peters, in receiving these phone calls, would not be able to see the phone number that it was coming from or the person that was coming from.
That is correct.
Now, we talked about a text message that was actually sent from Ms. Peters' phone, we look back at her record, that was sent to Mr. Segura's 509 number. I think earlier you said we can't get the contents of that from Sprint. Is that correct?
That's correct. Sprint at this time was not retaining the text message content, but Verizon was.
Were you able to go back and get that?
We were.
Okay. Do we have it?
We do. So taking that SMS messaging that we looked at earlier, we can see that 2:19 p.m. on the 19th. to the disclosed phone that says, "Did you hang up on me?" And then there is, at 2:27, another incoming call from the undisclosed phone.
And looking at Ms. Peters' record, is that an indication that she's talking to anybody else other than that 408 number during that time frame, correct?
No.
Okay. All right, and in this call, this 408 number, and going back to the Verizon on the 408 right here, again, utilize the star 67 feature, correct?
That is correct.
Okay. All right, so what's next?
Well,
if we've got a good stopping point, Mr. Hughes, probably ought to take a little break.
Okay, can we say that let's finish Ms. Peters and then we'll go on?
Okay, I thought we were.
No, sir,
this is it right here, last.
Okay, so what are we looking at here?
So again, sort of surmising, and we've kind of already mentioned it here, but we know that there was communication back and forth between Ms. Peters and Mr. Seura. The star 67 would not identify to her what number she was being contacted from. The text message that was sent, clearly she thinks that she is talking to the disclosed phone, and then there's a communication back from the undisclosed phone.
Okay. Well, that indicates essentially that, I believe Mr. Peters would be that she was talking to Mr. Seura on both of them.
It would certainly seem to be, yes.
Okay. All right, does that conclude the analysis, Mr. Peters?
It does.
Okay, great.
We take 10 minutes. Okay. Either side, anything?
No, sir.
All right, we'll be in recess.
Good morning and welcome back to Law News Network. I'm your host, LawNewz, and I am here joined today by Ken Belkin and Maria Marino. Nice to see you guys.
Good to see you.
So let's just talk about where we are right now. Just to let our viewers know, we're on our morning break from Florida versus Henry Segura. That is the incredibly tragic case of the murder of a mother and her 3 children. We're on a morning break. We had a witness on the stand testifying about cell phone usage. Possibly one of the most gripping cases, not so much one of the most gripping witnesses. But before we get to Segura, we got to back up a little bit, because on my way into the LawNewz studios today, I was all hyped because it was going to be the Tiger Woods hour. And, you know, not so much.
A little bit of a letdown.
Yeah. So, Maria, you're our sports girl. Tell us what's going on. What did we miss? What's happening here?
Well, I think the main thing to take away from Tiger Woods is the case that he's in right now. I don't see it really affecting his career as an athlete all that much. I think, as I discussed with Jesse earlier, the damage has already been done in terms of his reputation and how he's perceived by the public. I think generally people are pretty sympathetic to what he's going through with having had multiple back surgeries and dealing with a lot of pain, and so he's had this incident with prescription medications, and so far Nike has said that they would stick by him as far as endorsements go, and we'll see about other companies. But I think Ken can probably speak more to exactly what happened today in terms of the law aspect.
So I do want to throw that over to you, Ken. So today, Tiger Woods was meant to be in court for an arraignment.
Yep.
And what we saw was no Tiger Woods. But did the arraignment really happen? Where are we? Did the same functional thing happen?
Well, apparently there was disposition that he's going to plead guilty to the reckless driving and enter into a prosecutorial diversion program where he's going to get some probation, probably a little bit of treatment. There'll probably be some collateral consequences, maybe a suspension of his license. But you know, it's very interesting. Florida does it much differently than New York. You know, the arraignment is when you first go in front of the judge for the first time on a criminal case, and the charges are read against you publicly, and you enter plea of either guilty or not guilty, and the judge sets bail status. You know, he could set bail or release you on your own recognizance.
So just for our listeners and our viewers, we're talking about diversionary programs, and that really means diverting the case away from the trial track, right, to this other track which is, do this other stuff and then you won't have to deal with the court system.
Yeah,
and all that.
look, he's going to face some consequences. He's going to have to do some things and take some steps to make himself a better person and to make amends for the crime he's committed. But in return for that, he's going to get some leniency. He's going to walk away without a criminal conviction on his record, which is the goal here.
Because this is essentially, this is likely to get expunged, right?
Yeah, he'll get like a traffic violation on his record, which doesn't give him a criminal record.
That's exactly, and that really, for someone who is involved in any kind of DUI or anything like that, that's the best outcome that one could really hope
that's
for,
the gold
right?
Standard.
That's it. No criminal record. Maybe you pay a fine, maybe you do something, but essentially you walk away, legally speaking, as if it never happened.
Yeah, and I also think his is a very interesting case. He was not driving when he was caught, but he was still legally operating the vehicle because the car was on and he was in it. But he had pulled over to the side of the road. He had done the responsible thing, and I think he could have potentially had a successful defense at trial. I've actually employed that defense successfully at trial, but I think he might have been concerned about the PR aspect.
Well, and
to drag this on longer.
Yeah, I want to go there. I want to go there a little bit because one of the things that I had been looking into is that his attorney, not his attorney, but other attorneys in Florida in that same world of, automobiles and substance abuse and that kind of thing, were saying that they really felt that this would be a good case for someone to fight for a number of reasons, a number of, underlying facts where he might well have beaten this charge. And that of course it's a gamble because you go into a courtroom and you don't really know, there's never a guarantee about what will happen. But unlike a case where the person took a breathalyzer and blew well over the legal limit, where there's very little that you could say, here he had zero alcohol. Yes, he may have had prescription medication, but it is a little bit more of a gray area. He wasn't driving. He didn't cause an accident. There at least was something for him there to fight for. Some facts that really did weigh in his favor. So what do you think went into the decision not to fight it and to just plead guilty and move along?
I think it's the PR aspect. I think, look, he didn't drive. He did the responsible thing. Legally, he was operating the motor vehicle. The standard, at least in the state of New York, is if the key's in the ignition and the car is on, even if you're parked, you are legally operating the motor vehicle and can be charged with driving while intoxicated.
And that, by the way, is why things like when people very often pull out their cell phones at, say, a red light, that's still illegal because even though you might not be moving, it is still operating a motor vehicle. And if you're in a state with a cell phone law, then you're doing it illegally, even if you're staying still.
Yeah, look, to drag this out to trial is a little ridiculous. Him taking this violation, it's not going to really affect his career. As we saw, it's not really going to affect his endorsements as of right now. Right. And it's not like he's someone. I've had cases where someone worked for the government, and the deal that was being offered to them, if they took it, they would lose their job. He's not losing anything.
Right. He's not going to lose it as a matter of law, where all of a sudden, where there's, no discretion or something like that, where he's going to lose a position, or, he may lose an endorsement, but that's going to be really more of a domino effect and not a direct cause and effect relationship from whatever happens with this case.
Yeah, plus he was so forthcoming with admitting that he was on multiple prescription medications and that he was mismanaging them. He's gone to therapy since then pertaining to how to manage his medications, and clearly we saw the video from the night in question, and he was very out of sorts and repeating.
That's one word for
repeating things, and he was obviously in no condition to drive. And I might point out that while he didn't, as we know, cause an accident, his car was damaged, and he could have. So it's
definitely.
But as to your point, he did pull over, but and no alcohol. So and that's, I think, takes us back to the court of public opinion being a little bit sympathetic, knowing his history with his health and the multiple surgeries that he's had, and living in pain, and prescription medications. I think people understand how addicting they can be. This is a man that has obviously an addicting personality and has been to therapy for other addictions in the past, and so I think, as you said, it was wise for him to just take a step back, plead guilty to a lesser charge, and save a little face.
Now, let me just ask you this, though. At what point have we just heard this too many times from Tiger Woods, though? I mean, this is a guy who, he wasn't just an athlete. He wasn't just a successful athlete. He really had kind of that whole package of having this wonderful image.
Oh, yeah.
And I mean, and he destroyed that quite a few years ago.
Yes.
And it's like he just keeps on keeping on, killing his image. So at what point are his fans and the people who the endorsements are targeted toward going to just have enough of him in this nonsense?
That's a good question. I think with Nike in particular, the relationship that they have with Tiger Woods is a complex one, because since Tiger was so dominant and you know, he holds so many records, and he was the best at his craft, the best in his generation, he propelled Nike, he catapulted them. I mean, obviously they were already a powerhouse, but especially in the golf space, I mean, he put Nike on the map in that regard, and we have all these images in our head of Tiger winning tournaments with that fist pump and the Nike swoosh right there, and so I feel like they just, it's like very hard for them, you know, to break up. He lost a number of endorsements and millions of dollars after the scandal that came out in 2009 about marital, you know, infidelities. So we know he's lost a ton of money, but he's made so much money that he still makes money, even though he's not really an active golfer. And as I pointed out earlier, he's only played 2 tournaments in the past 3 years. He hasn't won a tournament since 2013, hasn't won a major since 2008.
And I think I heard recently that he would, I can't remember what the number was, but the rankings that came out like
Correct.
last week,
So,
and his rankings were like absolutely terrible.
Well, for the first time in his career, he's ranked outside of the top 1,000 golfers
outside of the
in
top
the
1,000.
world. Now, this is somebody who he propelled to stardom so quickly. When he came onto the PGA in 1996, he was ranked, he was the fastest ascent to the world #1 ranking. So, I mean, he was right into the spotlight, you know, PGA Rookie of the Year, youngest player ever to win the Masters, youngest player ever to win a career Grand Slam. So all of these things, he just, you know, he was just a star from the start. And I think on top of that, not only the dominance and the quick rise, it's also the consistency, right? So over a decade plus of winning. And we as fans of athletes, we understand what he has done in terms of character off the golf course, and that he hasn't been, you know, the best in that light. But I think there is still a part of a lot of us as fans of sports that respects and kind of wishes that we could have that again. What we saw from him on the golf course, we kind of want that back, and that's why, even though he hasn't been an active golfer, every time there's a major tournament, I feel like the driving conversation is, well, where's Tiger? What's he doing? And it's like we miss that. We miss those eyeballs being drawn to the screen, that can't miss television. So
I wonder, you know, I'll tell you just my own, you know, lawyer's take on it is that, you know, obviously from the facts that, you know, he was doing something not so smart in a situation that was not so smart, and he's kind of a mess. But there is a part of me that for the drama would have really enjoyed seeing him fight the charges and potentially prevail in a way to say like, oh, well, maybe the hero's not gone, you know.
I think you need to wrap this up. He needed to wrap this up quick. And you know, just to your point
he
about
needed
his
to get
endorsements, you know, from a business legal perspective, look, he did lose a lot of endorsements. He fell into some disrepute due to his behavior. And I think it's very interesting that he didn't lose the Nike one ever. I would love to have been a fly on the wall during that contract negotiation, because I'm pretty sure Nike's not in the business of giving out a lot of money to someone ranked 1,005. I'm probably ranked higher than him. At least at miniature golf. But, you know, I would think that they could probably endorse someone else and get a much better deal. He probably really, when he negotiated that contract, he negotiated from a real position of power. And I bet his moralities clause is like very thin.
If it's even there, right? If it
I'm
even,
sure, like if he got charged with a felony, you know, Nike, stop wearing my shoes.
So I mean, it's just interesting to see how you know, these cases with, especially, you know, substance abuse and how they turn out is often so closely tied to personally who that defendant is, what the backstory is, because of course, you know, entering a diversionary program and then having the case later expunged is a very typical result in a DUI case or any of these type of cases.
Yeah. Although, I gotta say, the fact that he admitted to the drugs, apparently there was no blood test, but I've seen cases where the DA's office takes a position that if there is drugs in the blood, they won't come down off the misdemeanor. Mm-hmm. And I've actually seen cases out on Long Island where they won't come down off the misdemeanor if that drug is marijuana.
So, all right, well, we'll have to just see what happens next, if anything. Probably nothing too exciting going on with Tiger Woods following what happened today, but we'll see, you know. We'll see what happens. But I would like to just move over to talking about State versus Henry Segura. We're on a morning break right now from this case. We have a witness on the stand who is the last prosecution witness. This guy is a cell phone witness. He's talking about cell phone record testimony. The main purpose of his testimony, of course, is to place the defendant having called the victim on, I think it was on the day of the murder. Here's where I'm coming from in this case. So you have gruesome facts. I mean, really just terrible, terrible facts in this case. And then you have a prosecution case that is heavily dependent on extremely boring testimony. I mean, I have no other way to put it. It's boring. You have you know, experts, cell phones, and like who really cares about that, and then forensics.
You don't find the history of the cell phone to be riveting?
I mean, and the thing is, you know, yeah, is it an important point that the defendant may have called the victim? Yeah, that is an important point. Do I have to sit through 3 hours of it? If I'm annoyed by it, I can only imagine how these jurors must feel by this.
Well, look, cell phone evidence, it comes up more and more in proceedings. I mean, look, I didn't practice law before the cell phone, so I can't tell you what it was like before, but man, these things come up in everything. Text messages, emails, your location. I mean, look, anytime, you know, you're downloading information, which, you know, your phone might be updating your email, it pings, and it gives off an approximation of your location. So look, if you're gonna commit a crime, you know, just be aware that there's going to be evidence of where you were.
I wonder if at some point cell phones will become so commonplace and have been around for long enough that we no longer need, like, you know, 4 hours of testimony about how that concept works, and we can just cut right to the chase.
I don't know that, you know, people don't really understand the nature of location technology. Sure. And the cell phone sites pinging anytime there's activity on the cell phone. And the prosecution, they have to lay the foundation. It's just it's a necessary evil in a court proceeding that the evidentiary rules necessitate the laying of a foundation.
That's right. And we're going to get back to this more, because I would like to talk about how that relates to the defense strategy in a case like this, when you have a real juicy defense strategy. But now we're going to go back to the courtroom live in Florida versus Henry Segura. We will take you there where we have witnesses on the stand, and we'll take you right back there now.
Particular importance to this part would be that text message content, where we're able to, for a period of a few days, recover the text messages that were sent from Verizon.
And this appears to be the 509 number, which is the disclosed phone that Mr. Segura had, correct?
That is correct.
Okay.
The other thing that we're able to do when we're able to actually have possession of a handset, then we can do a forensic exam, or where we can take that device and plug it into a machine and sort of extract some of the information that's within the phone. And sometimes that includes text message content and call logs and contacts and pictures and those kind of things. But another good source of information for us is when we do have the actual physical handset in conjunction with the things that we see from the carrier records.
And were you able to get the physical handset from Mr. Segura's 509 number?
Yes, we were.
Okay. And you say you're able to actually go in that, is there a certain, what's that called?
Well, we generally call it a Cellbrite, but Cellbrite is actually a brand name of a forensic software. But we call it just a forensic analysis. It's very similar to a computer analysis, where we go in and maybe take an image of a hard drive and then look through the data that's on there and see what we can recover.
Okay. And were y'all able to do that in this particular case, Tallahassee Police Department?
We were, yes.
Okay. And Your Honor, for record purposes, we're now referring to the information obtained off of Mr. Segura's phone physically. It's State Exhibit 140, and that will be the
It's my understanding that's already in evidence.
Yes, sir. It's already previously introduced in evidence. All right, so what are we looking at here?
So we were able to pull from that handset, the 509 handset, all of the text message content that was within the phone. And we don't have to see too much detail here. We'll look at the individual days later. But in essence, the Cellbrite report is able to take for us the date and time of an event, of a text message. If there's a contact name, it'll stick it in the slot for us and tell us, hey, this phone number is assigned this name, so we know who at least the person who's using the phone refers to that number as. And we have an indication whether it's sent or received and those kind of things. So we were able to get that text message log from Mr. Segura's disclosed handset.
Okay. And I think you looked first at the November 16th date, which is just before the homicide?
Yes, that's correct. So on the 16th, we saw that in the morning hours, 7:44, 7:46, 7:47, we had text messages that were originated from Mr. Segura's phone, actually to Mrs. Segura's phone number. As we had the text message content from the carrier, we were able to look at what the content of those messages were. So the first text message here at 7:44 a.m., we do have the text message.
Okay, and so the last report would be off the actual phone, and this report is from the cell phone company?
Yes, so this is from the cell phone provider. This is from Verizon, and this is again the content that we were able to get from them.
Okay, and what does it say?
It says, I can't wait to get y'all taxes. I'm calling to IRS and tell them that y'all live together so I can get both of y'all money, LOL.
It looks like that's signed Queen B.
That is correct.
And if I'm not mistaken, we had previously seen a text message that was from Mrs. Peters' phone where she also signed it Queen B.
That is correct.
Is there any additional? I see we have some highlighted phone numbers here. But this is sent from Mr. Segura's phone to Mrs. Segura's phone?
That is correct.
Okay. I don't understand. How is it that
The most likely would be that Mr. Segura's phone received this text message from Ms. Peters, and then on this date and time, it was forwarded from his phone to his wife's phone.
All right. But you weren't able to get the actual, you didn't have the actual text that was sent from Mrs. Peters' phone to Mr. Segura's phone?
We have a number of text communication between them in the text log, but as far as how far back we could go with content, we did not see where this was sent to Mr. Segura's phone. But there are a number of text messages that we have no idea what the content was.
Okay, and is that because the provider doesn't keep them very long?
That is correct.
Okay. So presumably it would have been sent before this?
That is correct.
Okay. All right. What's next?
So the next text message of those three that were sent, 7:46, again, we also have the content of that from the carrier.
Okay, and what does this say?
Your mama da bitch, and I'm going to call them in the morning, so don't pay your ass, we'll be in jail.
And again, it's signed by Queen B?
That's correct.
Okay. And this is actually 4 days before the homicide, Tuesday before the homicide, correct?
Yeah, 16th is actually 3 days before.
Okay, yes sir, sorry. All right,
Still, this is the third of those three text messages sent the morning of the 16th. Again, from Mr. Segura's phone to Mrs. Segura's phone.
And what does this one say?
This one says, that's fine, you don't have to text back, but I'm going to see you in court. I'm calling them people today.
Okay. Well, appeared to indicate that she was not getting any return text messages from Mr. Segura's phone.
Would appear correct.
And again, signed Queen B.
Yes, sir.
Okay. What's next?
Well, if we then look at the text message that were recovered from the actual handset, we don't find these. We see that there are a number of text messages on the 15th, and we have to do a little time adjustment here. The phone is reporting those text messages in GMT, and we were right about daylight savings time here. So that's either 4 or 5 hours ahead of us. But regardless, for the 15th, those three text messages that we got from the carrier that we saw in the text message report were no longer on the handset.
How could that be?
Deleted.
So they apparently were deleted from the handset?
That is certainly an explanation, yes.
Okay. What's next?
So another day we looked at was the 19th, and we've talked about this one before, that we had an incoming text message from Ms. Peters at 2:19 We know that from Verizon, the content of that message was the "Did you hang up on me? What happened?"
All right, so this is the text message we're talking about beforehand.
That is correct.
Okay.
We also had some other, looking at the text message report, we had a number of text messages from Mrs. Segura's phone to Mr. Segura's phone throughout the day on the 19th. See 3:56, 4:15, 4:56, 5:04, and 8:14. So there were about 5 text messages that were sent from Mrs. Segura to Mr. Segura.
I'm sorry, if I can go back just a second to that phone, that other text message we talked about on the 19th, was that found on the phone?
Well, it was not, and we're sort of looking at all the text messages on the 19th, and then we'll go and look in the phone and see what we found. But no, it was not there.
All right, so these are messages that are now being sent on the 19th between Mr. Segura's phone and Mrs. Segura's phone?
Correct.
Okay. Did you get content for those?
We did. From the carrier, we were able to see what that text message content was. So the top one there, 1119, 356, we can see the originating number and the terminating number, again from Mrs. Segura to Mr. Segura. And that first message says, "Call me back."
Okay.
Then 415, there is a text message that says, "Answer the phone." And again,
to indicate that there's no communication going on. Well, again, this is the 509's phone number for Mr. Segura, correct?
that is correct. So it would indicate that Mr. Segura is trying to reach Mr. Segura without success.
And his phone is showing passive during this time period, correct?
That is correct.
Everything's incoming, nothing outgoing.
Yes.
Okay. What's next?
So we saw there were a couple other text messages a little later on that day. So the next text message we saw said, "I need to stay late." And then one at 5:04 that said, again, "I will never get ahead at work, can't depend on you."
Again, all receiving on Mr. Segura's phone, but all passive, nothing response, nothing going out.
That is correct.
Okay.
So then the last text message sent, it's actually broke apart into 2 parts, but this is the 8:14 text message, again from Mrs. Segura to Mr. Segura.
And what does that say?
That is, "I am so through with you being such a fucked up husband. You are no one that I can seem to depend on since you get lost so easy. I need you to have my back again today, and you were nowhere to be found. I think that I finally get the hint that you don't have my back, so why should I have yours?"
Again, on the 19th, this appears to be, am I doing the math right, about 8 o'clock, 8:15?
Yes, 8:15, yes.
All right. Again, a passive event, nothing.
Yeah, so
outgoing.
we saw those text messages that seemed to indicate she was trying to reach him. So if we go back to the call detail records, I would expect to see, calls from her into the phone. And in fact, if we filter out for just Mrs. Segura's numbers, we see that there were a number of calls starting at 1:22, 2 o'clock, 2:08, 3, 4, throughout the daytime there that are from either her cell phone or work number. And those are all, as we see in the direction column on Mr. Segura's phone, forwarded or terminated. They're all incoming, but they did not appear to be answered.
And they all seem to have a duration where it appears that it's being left or something along those lines.
That would be correct. 30 seconds is about what it takes to connect and decide whether you're going to leave a voicemail or not.
Okay. All right. What's next?
So we have all of those, and then again, we look at the forensic report from the phone, and for the 19th, we have some events, but we do not see the text message from Ms. Peters, and we do not see these text messages from Mrs. Segura from the evidence we recovered actually within the phone.
All right, so the cell provider's phone, the analysis of the cell phone indicate that any of the text messages from Ms. Peters are not present.
Correct.
As well as any of the text messages from Mrs. Segura indicating that Mr. Segura was not home on the 19th are also missing.
That's correct.
Okay. What's next?
So everything, if we go to the text message log for the 19th and compare it to what was found in the phone, we see that there are a number of text messages between Mr. and Mrs. Segura and at least 1 or 2 from Ms. Peters that were not present. So everything highlighted are things that were not in the phone. The things that are not highlighted were the text messages that were still there.
So it's not like he erased everything. He just erased those 2 particular conversations.
We did not find those 2 particular conversations, correct?
But the other conversations, the other things we were talking about were still present in the phone.
That's correct.
Okay, what's next?
So one of the other text message strings of interest was on the 22nd, which is a few days after the homicide. We see that this is an outgoing text message from Mr. Segura's phone to a 210-4515, and it asked the question, "Are you up?" And then there was a text message at 11:15 that morning, a few hours later, again from Mr. Segura's to the 210-4515. And this message says, "I wasn't sure how to say it on the phone, but I just wanted him to come get this car. He don't have to give me nothing for it. I just want it gone."
So he's trying to get rid of, apparently according to that text message, he's trying to get rid of a certain car.
It would seem so, yes.
Okay. What's next?
So again, as we see reference here, I wasn't sure how to say it on the phone. We would go back to the phone records to see if there was actually phone communication between them. And we do actually see on the 22nd, there are a number of voice calls, either attempted or completed calls, especially one here at 9:05 that's 1,000 seconds long between Mr. Segura's phone and that 210-4515. So there was telephone contact that seemed to be referenced in the text message. Then if we look at the text messages that were recovered from the phone, we can see that the early morning one, which again, if we do the math here, makes our time work out right, that says, "Are you up?" So that text message is still on the phone. But the one later in the day about the car is not in the phone. So these are the rest of the text messages for the 22nd and actually into the 23rd. And we did not find that second text message.
Again, so it appears that Mr. Peters' conversation's missing, Ms. Segura's conversation's missing, and that one particular text message about getting rid of a car is missing, but nothing else is missing that you're aware of.
In these strings, correct. So here we can see that from the text message report, the 803 message is there, but the 1115 message is not.
Okay.
And I believe that's what I had for that.
All right. At some point, did you start going in and looking at Mr. Segura's phones and the record as far as the actual call content and distancing and things like that?
Yes, we did.
Okay. Is that what we're going to look at next?
Yes, the next thing we looked at was just as we did for the Wednesday and the Saturday after, we looked at the location information for the day and evening of the homicide itself.
All right. Can we take a look at that, please?
We can. It'll take me just a second.
Yes, sir. All right, so what are we looking at here with this first slide?
Again, just our overview slide. We know that there's a couple of addresses of interest, that being Mr. Segura's residence and Ms. Peters' residence, and again, all the Verizon cell sites around the area there that we expect the handsets to be communicating with.
Okay. Did you take a look at that information as it relates to the 509 phone?
We did. The 509 or the disclosed phone, we looked at the call detail records for the 19th, and we see that there are a number of events in the records. And if we look at those sort of in detail, we take out the other columns, we can see that at 12:30 the morning or the early afternoon of the 19th, we have an originated event. And then everything 122, 134, 155, we see that these are all now the mobile terminated or the mobile forwarded. So these are the passive events. There's nothing that appears originating or outgoing until actually a call the morning of the 20th. So everything on the disclosed phone at this point is passive. We're not indicating that someone's actually manipulating the phone or using it.
Okay.
The SMS events from that report are also passive. They're all incoming, meaning every one of them, we can see 10:55 in the morning through the 8:14 in the evening. All of those are inbound to the 509 or to the disclosed phone. In our RTT report, our distancing report, all of those events, even though they weren't answered, they still do provide us location information. So we see that all those communicated with our Verizon 850 Sector 2 again, which we see often.
Did you do your distancing?
We did. We have the distancing information here and also our additional distancing information. And again, as we've seen before, this distancing would be consistent with that handset being at Mr. Segura's residence.
Okay. And that's compared to the one that we did back on the 17th where we know that the resident spoke with the early morning hours with the 408 and then his 509 number and all that.
That is correct.
Okay. Did you take a look at the 408 number, the undisclosed phone?
We did. And the 408 phone, we do have a variety of events occurring during the day. And here we see that not only do we have the mobile forwarded, but we do have mobile originated. So we have outgoing events or active events. And all of these events are present in our distancing report, our RTT report. So we can see that we have some outgoing text messages, incoming text message. There seems to be more use or activity out of this handset.
And this is, again, the 408 undisclosed phone, right?
That is correct.
All right.
So the first thing that we looked at was the first two events here. This is just afternoon, 12:32, 12:36, or early afternoon of the 19th. And we see right here from the records, our old friend 850 Sector 2. And if we put that on the map, we can see it here. Our distancing, again, as we've seen before, our additional distancing. So those two events are, again, very consistent with what we've seen when the handsets were at Mr. Segura's residence.
Let me stop you right here real quick. You know, we looked at some dates on the 17th. We also looked at 20th dates and compared them with essentially what we believe to be known locations of Mr. Segura and looked at the data. What is the importance of doing something like that?
Well, first of all, it sort of helps us make sure that our analysis is correct. If I know that someone is at a particular place in a particular time and I look at their records, then I expect those records to be consistent with that, to be communicating with a cell site and a sector and a distance that's approximately consistent with that. So we do it both to verify our information, to make sure that the records we see are accurate, to verify the stories that we're being told, is it accurate or not. So it's sort of a verification for us to look at those known locations.
Okay. Looks like, Nick, we looked at the afternoon hours.
It did. We can see there are a series of events, both voice calls and SMS or text messages. We can see that they all kind of communicate with 847, Sector 1 or Sector 2. Our distancing is pretty similar here. So we kind of looked at those as a group. Since they're all going to look about the same on the map, we kind of take a look at those as a group.
I think 847 is the one right there by Mrs. Peterson.
Yep, that's the tower that we've seen before. It's right there on McNeil Boulevard, just down Woodville Highway. And we see that we're using these two sectors of that cell site during this time, and we do have distancing information. So our distancing information for all those events, again, relatively consistent during that time period, and we do have some additional distancing that we can plot as well.
And again, this is just prior to the homicides, it's the day of the homicide. But at this point, we still have an active communication on the Segura's phone after this, correct?
That is correct.
Okay. And in fact, there's a long phone call, so we believe he'll still be alive during this time period, correct?
Correct.
Okay, but it shows him being in the area of her home.
Consistent with, yes.
Okay. Next, if we look like we're doing that a little later.
Yeah, we had a little break in time here, and we have a couple events where we see a change in cell sites. May or may not mean that the handset moved. Again, we know that we have a tendency every once in a while to reach out and talk to a cell site that's a little further away. But we look at these two events together, and we see this first one here at 545, communicated with Verizon 849. It's our cell site that's down Woodville Highway. We have distancing for that, which again, not inconsistent at all with Ms. Peters' residence. We have the 601 event, which we've gone even further now to a cell site that's way down on Oak Ridge Road. We're a pretty good distance from it. The distance that it reports is, is long, still puts us back up inside a Capitol Circle, but, consistent or not with Ms. Peters' residence.
And again, this is 601, it looks like, so at this point, we still have the cell phone, the conversation following this, where Ms. Peters is actually on a call, and that, of course, that active text that was sent at 6:53.
That's correct.
Okay. What are we looking at next?
So the next little grouping that we see here is from 6:05 to about 6:33. And again, we go back and we see our 847.1 and our 849, so we know where those are. We see some pretty consistent distancing, so we kind of look at those as a group as well. Again, we have our 847, our 849. And as these events are all text messages, we just have the one distancing event for them. But when we look at that on the map, that's what we have for those events.
Okay. And it looks like next we're looking at 6:23.
7:23, yes. So now here, maybe 50 minutes later, we have, again, kind of a little bit of a change. We have a data session. Our distance has changed just a little bit. So we look at these two events, and we say that they, again...
Can you go back to those just real quick?
I can.
Okay. A couple questions I have here. Is there any kind of communication, active communication, between that prior 6:33 time period and that 7:23 time period on Mr. Segura's phone?
The RTT report would contain all the activity there was, whether it was a data session or text message or a phone call. So in this report, we see that terminating text message at 6:33, and then the next event in the records is this originating data session at 7:23. So there would be no events, no activity between that time frame.
And if I recall correctly, Ms. Peters' cell phone, the last activity on it was at 6:53, so her phone up to this 7:23 time period is also inactive.
That is correct.
Okay. What is the 7:23 time period with?
So we have our two cell sites that we've seen. We have distancing information from those two. One we see is a little long, one's as short as we usually see. And we had some additional distancing information for those two events that, again, not inconsistent with the area.
Okay. You say it's not inconsistent. I see one kind of up here. How is that not inconsistent?
Well, we know from our use of the information and testing that we subsequently did that the distancing can be off. So while I could not exclude that area, I certainly couldn't exclude her home from being within the error range of that data.
Okay. All right. It looks like next we're going to 8:21.
That's correct. The next event after the 7:37 we see is 8:21, and it's an originating voice call now.
All right. And anything in between that that prior time period that we had at 7, I think it was 33, between that 8:21?
There is nothing. The there was sort of two events there at 7:23, the 7:37 event, nothing in between that and the 8:21.
And if I recall correctly, Ms. Peters' phone is also inactive during that time period, as it previously was not active after that 6:53 time period.
That's correct. I believe it was the 8:12 phone call that was not in the per call report. So.
And if I also recall correctly, Ms. Peters' phone went, I guess, inactive or stopped communicating with the network also at 8:21 exactly.
Well, as I was saying, I believe, and we have to go back, I don't want to misquote the time, but I think it was 8:12 or 8:14, whenever that incoming phone call that she had was. And that is the one that we did not see in the per call report. So we had the data sessions just prior to 7. We did not have that phone call. So somewhere in that time frame, yes, is when her phone leaves.
Okay, if I recall correctly, and correct me if I'm wrong, but I think there was a 7:14 call that was actually routed, but it was actually picked up by the voicemail, and there was an 8:21 at that point that was routed that was not. Is that correct, or am I incorrect there?
Yes, it is. The 7:13 is the one that we have that came into the phone, and it was 8:21 and 52 hundredths of a second is the one that we did not see. So 8:21 is the one that we do not see in the per call report. So somewhere just prior to this time, we know that something happened to Ms. Peters' handset.
Okay. So what are we looking here at this 8:21 on Mr. Segura's phone?
So the distancing here is just a smidge longer than what we had seen in the other events. And if we plot the additional distancing, now the handset is communicating with some other cell sites. The cell site here behind Rickards High School, one over here. And if we kind of look at that convergence of where those distances are, it's more consistent with the area up here.
And it looks like that's just off of Paul Russell Road, which is also something we saw previously on the 17th.
That is correct.
Okay. So next we're looking at 9:30.
So 9:30, the next event that we have after the 821 is the 9:30, and that is, again, our 850 Sector 2, so we can guess where that is. We see that on the map of Verizon 850 Sector 2. Our distancing and our initial distancing is consistent with that handset now having returned.
All right. And did you compare the two?
We did, just as we looked at on the 17th for this time frame in between our active events, we see that the disclosed handset was primarily or exclusively using our 850 Sector 2, and our undisclosed handset was now using these cell sites up here. And if we look at the distancing for those, again, not consistent with those two handsets being together.
And the undisclosed phone at 408 is not consistent with him being at home until lawful.
That is correct.
Was that the end that completed your analysis of this information in this case?
It did, yes.
For Mr. Segura's phone?
For Mr. Segura's phone, yes.
Did you do any initial analysis?
We did.
Did you conduct an experiment, I guess?
We did, actually.
Okay, and what was that, if you can tell the jury?
Again, we talked about wanting to sort of verify our data, make sure that our analysis was correct. And one of the ways was to look at known locations and look at the records and verify that those things were there. But one of the other options that we had is we knew the make and model of the handset, this undisclosed handset. It's actually in the records. So we knew what kind of phone it was, and we knew the service that it had. So we decided that we could get an identical phone with identical service, and we could go out and create our own events. So we would go to known locations, fixed places. We would make our own text messages, voice calls, data sessions, and then get our own records, and then compare what the records said, where we knew exactly where we were. Then we wanted to see what those records told us. So that would help verify our analysis as well, and we did that.
Okay, and did you utilize Mr. Thornton, who I believe was the originator of that phone, in order to help you obtain?
That is correct. He provided us a confirmation of that. Again, we see the make and model in the records themselves, so we knew. And Mr. Thornton was able to confirm the handset that was in Mr. Segura's possession.
Okay. I'm showing some previously introduced, I believe it's been introduced in evidence as 123. I should take a look at that.
Yes, sir.
Do you recognize that?
I do.
What is that? That
is the Verizon LG 290C phone that we purchased to do our experiment with.
Okay. And Your Honor, permission to publish that to the jury?
Sure, something nice.
All your other paperwork's in there.
And I believe you said that you essentially hooked this phone up.
We did.
Did you also utilize the Verizon network as the 408 number was utilizing it?
We did. We actually subscribed for service. It's through Straight Talk, but it's serviced by Verizon Wireless, a prepaid carrier. So we got our own service, paid for it, activated the phone, and went out and made some events.
Okay. And did you also request the cellular phone data information from Verizon following your test?
Yes, we did.
Okay. And I assume you obtained it?
We did.
And Your Honor, that's been previously introduced into evidence as 139. Did you have an opportunity to go back and verify that information contained in State Exhibit 139 and verify that it was the information you were provided from Verizon?
Yes, I was.
And did you prepare any visual aids and help with that analysis?
I did.
Can you show that to us, please?
I can.
All right. So what are we looking at here?
So again, that RTT report or that Verizon distancing report, way at the far end of the report, actually tells us the make and model of that handset. So we get to see that it is a manufacturer of LG and that model LG 290C. So that helped us confirm the phone that Mr. Thornton showed us It is the same make and model as you saw in the box there. So we went out and acquired our own handset. It's the one that you just saw. And as we look at it, we can confirm that it is an LG 290C handset.
Your Honor, can I actually dim the lights again, please? Now, what are we looking at here? What are these blue dots?
The blue dots are all the places that we went and created our events from.
Okay. And how did you go about figuring out where you're going to create an event?
They were locations of interest to the investigation. Clearly, the incident scene, Mr. Segura's residence, friends or family members that may or may not have been locations we could have been at, other things that were discovered during the investigation that where someone was reported to be, they said, hey, I'm here right now, and we have records, then I might go to that place and create my own records just to see if mine matches theirs. So there were 11 locations that we picked based on things that were relevant to the investigation.
And when you say events, were you just making phone calls? What were you doing?
No, we did them all. We did voice calls, text messages, and data sessions. Even that many years ago, that little phone had a very basic web browser to it, so we could go on and initiate some data traffic that would cause the data sessions that we saw in our original records for Mr. Segura's phones.
And approximately how many, I guess, events did you create at these different locations?
Oh, it varied on the locations, but we ended up with just under 100 events across this experiment.
All right. Location number 1098 Mustang Drive. What are we talking about there?
That's correct. That's Mr. Segura's residence. So we knew that we had a lot of events where the distancing and the cell sites seemed consistent. So we wanted to make sure that our phone showed the same thing. So again, 850 Sector 2 is the sector that our handset utilized. Our distancing, very similar to what we've seen before, coming up again just short of where we actually were. And like some of the other events, we did have some additional distancing that came in from the other cell site on the other side. Again, as we've seen in the other times we've looked at this address, our distancing was very similar to what we saw in the other handsets.
And I notice we're using blue arrows and blue lines.
Yes.
Dallas Police Department.
That's correct.
Okay. All right. So location number 2 looks like you were on Crawfordville Highway.
That is correct.
What's the significance of this location?
Through the investigation, we learned there was some communication with Mr. Segura where he stated that he was just passing the Publix, and this is our Publix right here on Crawfordville Highway. So it's something we might compare the records to. We wanted to go to that location as well and see what our events look like.
Okay. And I believe that was Ms. Hawthorne Smith that provided that information?
That is correct.
Did you go back and look at Mr. Segura's records to ensure that that communication actually happened?
It did.
Okay. All right. And what time, do you remember what time that was, by any chance?
Not off the top of my head. It was the later evening hours.
Around 10:15, something like that?
It was, yes.
Okay. All right. So did you do the distancing on this as well?
We did. We, as expected, we're communicating with a cell site that's relatively close. We can see our distancing, which again comes up just a little short, and our additional distancing where we're able to communicate with another cell site up here, consistent with where we were at.
Okay. And again, was that consistent also with information as that Ms. Hawthorne missed communication with Mr. Segura on that day?
Yes, it was.
Okay. Next location looks like Lakewood Drive.
That's correct.
What is the significance of this location?
A family member's residence here?
When you say family member, Mr. Segura's family member?
Yes, correct.
Okay. And where is this? Where are we looking at here?
So we're just south of Tram Road. So this is 4 Points, our Woodville Highway, the cell site that we've been talking about, mostly 847 is right here, and our victim's residence is right here on Saddle Creek.
So the same general area of Ms. Peters' home, same tower, but a different location.
That's correct. Relatively close.
Okay. Did you do the tower and distancing analysis on this one?
We did. Here for our events, we communicated with Verizon 847. We saw our distancing, which again was consistently just a little bit short. And our additional distancing, we really didn't communicate with any other cell sites while we were at that location. Not to be unexpected, as we were relatively close to that tower. You would expect it to be the one that the phone consistently saw best, and so our event was all of our events communicate with that one cell site.
And it appears that these lines of communication that we're talking about, the RCT lines, are well south of Train Road.
They are, yes.
Okay.
Tram Road is here, and our events are definitely short of Tram Road.
And going back to the analysis of the 408 number, is it, it's my understanding that the RTT data lines were north of Train Road, where they passed in that area?
That is correct.
Okay, so that's not consistent.
It is not.
Okay. Next, you went to Gale Avenue.
Correct.
What significance is this address?
Again, another family member of Mr. Segura.
Okay. This also looks like it's at Tram Road area, just south of Tram Road.
It is. It's very close to where we were. We were just over here on Lakewood. Here is our Gale Avenue address, and again, Miss Peters' neighborhood is right here.
Okay. Again, even getting closer to Miss Peters' neighborhood.
That is correct.
All right. Did you do the tower and distancing analysis on this?
We did. Again, our same Verizon 847 that we've seen. Our distancing and additional distancing.
Again, it appears that the arcs, if you will, are south of Tram Road.
That is correct.
And they're actually short of your known location.
That is correct.
Okay, but that's also still inconsistent with the data that came off that 408 number, correct?
That is correct.
Okay. Next location appears to be Kendall Drive.
We did. A friend of Mr. Segura's. So we went to this location and created events. We saw our cell sites. Again, as we talked earlier, we know that Ridge Road here is a little bit of sort of a high point. And as we start down that other side, we would expect that we would probably communicate with different cell sites than what we did if we were on the other side of the hill. And in fact, we did. We have the cell site here at Rickards and the cell site up on Putnam.
And so this looks like it's in between Paul Russell Road and the Orange Avenue, I mean, almost in the vicinity of the high school, it looks like.
That is correct.
Okay. Okay, there's distance.
Distancing information and our additional distancing information again.
Okay, so that's totally different tower and distancing information that's not consistent with that 408 number on that date.
That is correct.
Okay. Next, it looks like you're on Paul Russell Road.
Correct. This was an acquaintance of Mr. Segura's, Ms. Hawthorne Smith's residence.
Okay.
Again, we see our cell site, our distancing, and the additional distancing.
All right, this looks like it's almost a capital circle in Orange Avenue.
It is, yes, absolutely. So our area that we've been looking at is down here on Jim Lee Road. Now we've moved significantly further east and an area just south of St. Augustine along Capitol Circle.
Again, inconsistent with the data that you got from the 408 phone number.
That's correct.
All right, what's the next location?
Jack McLean Park. Here again, being on the ridge, we would kind of expect to see some different events. And again, we see our 847 that's south, and we see the other cell sites that are north. And again, kind of being there on the top, we would expect that we might see those. We have our distancing and our additional distancing. And some of those, we were able to see some cell sites a good distance away, all the way over here.
Okay. Now this information looks relatively close. You have Paul Russell Road right here, relatively close to that 821 event on that 408 number. Is that correct?
It does. On the 821 event, we do actually pick up the cell site that's over here to the left. We pick up the cell site at Rickards. So there are definitely some consistencies between our information here and that 821 event.
All right. Next location appears to be Jim Lee Road.
It is, yes. And so this is actually the parking lot of the church that is behind Miss Peters' residence, and it's actually her residence is right here. So we're real close to her residence, but we're also going up the hill a little bit now. So we're a little higher, we can see out a little better. So we were curious what cell sites we might communicate if we were north of her residence.
Okay, and did you do the cell tower and distancing analysis on this?
We did, and we saw here our 847 and our 849, which we've seen in other records. We have our distancing information here, which most are consistent. We have a couple that fall short, again, as we've seen previously.
Okay, let me stop you right there.
Mm-hmm.
Those fall short, and I think if we go back to the 408, there's actually one that went well past.
Yes.
The area that it was previously indicated. Is that And I think there was actually a phone call that was, or some sort of data session that were like 7 seconds apart that were substantial distance apart. And I guess I'm going to call them a flyer because you'd have to be in a plane to fly that far that quick. Are things like that, these flyers, are they, did you find them both in your test phone as well as the analysis of the 408 number?
Yes, absolutely. So here is our test phone. This is our data. I know exactly where I was. I wasn't flying at the speed of light one direction or another, but these are the distances that we received. So we definitely saw that, you know, our closer cell sites were usually more accurate. As we started communicating with cell sites almost out of the county, then our reported distance could be off a little bit, but we do see that we have a couple of distances a little short, a couple of distances a little long.
You got a lot of experience analyzing things. Are these flyers, if you will, something you normally see?
It is. We might look at, and we use the distancing data a lot to locate people, missing persons, wanted persons, those kind of things. And if I look at a report and I see a period of time where I think, you know, someone may be asleep or, you know, at their house, and there's 20 events and 18 of them are nice and consistent, and there's a couple that are, you know, a little long, a little short. Just as a matter of practical analysis, I would eliminate those, and I would look at what is most consistent, and that's the area that I would go and look for this person, because I knew that every once in a while we do see those that represent a little short or a little long.
Okay. So essentially, if I understand you correctly, then even though you get those, you still have to look at everything as a whole, but your experience has shown you that those things happen on occasion.
Sure. If I'm looking for someone, I'm going to the average. I'm going to where, you know, they're most likely to be. If I'm going to say where someone may or may not have been, then I have to look at what the possible error of the data could be.
Okay. Next location, Hampton Drive. What's the significance of that?
This is just the entrance to her neighborhood, to Miss Peters' neighborhood. So this is directly off Tram Road. You can see we're just right here in. There's a little parking area. Miss Peters' residence is here. So again, we're very close to her residence. We're a little bit further down that hill. And again, we just want to see, hey, if we're this close to her residence, what does our information look like?
And I think we previously talked about an exit being up there at Paul Russell Road. Does that mean there's two entrances and exits to the neighborhood?
There are two. There's one that comes out right here on Tram Road, the main entrance to the neighborhood, and then you can exit Jim Lee Road up to Paul Russell.
All right, so the north and the south entrances.
Correct.
Okay.
By vehicle.
All right.
So we saw our cell sites here, our distancing, and our additional distancing. So everything that we have, again, a little bit short of where we actually were and shorter than the other data that we had seen.
All right. Next, it looks like you went to the location at 908 South Front.
We did. This is Miss Peters' residence, and we did events both inside and outside the residence. And these first ones here are ones that we did in the driveway outside.
Okay. And did you do the cell tower and distancing analysis?
We did. We saw our same 847, 849 that we've been seeing in other records. We have our distancing. And again, even here, we have one from this further away cell site that comes up a little short, one a little long. But if we look at the bulk of the data, we can see that it's much closer to the other data that we had seen previously.
And looking at this, I know that we talked previously about that line for the segment, and this one appears to be hitting off two different sectors. Again, we're outside the home, correct?
That's correct.
All right. And because on that line, essentially, is that why we're looking at two different sectors like
Yeah, let me see if I can make this work here. So we talked previously about the sector break, and that somewhere between Sector 1 and Sector 2 is where we would expect that phone to start transitioning from one side to the other. And we can see that when we were at the entrance or to the neighborhood, we were more over here, and most of our data was with this one. Here we're a little bit closer to that transition line, so we can understand that the handset may be trying to make a choice between which side of that it sees the best, and knowing that it's not in a real good spot is why it looks to that one that's even further away. Because even though it's further away, it's more in kind of the sweet spot of that sector, so it may want to communicate with it more often.
And I think that, thinking back to the 408 analysis, it was not hitting off of both these sectors. It was only hitting off one, correct?
At different parts of the day, it communicated with both sectors, and sometimes it was just the Sector 1 or the one that's more facing towards the north.
Okay. All right. So what's the next location?
So the next location was actually inside of her residence. We went into her residence. It was still vacant at the time, and created a series of events in the living room.
All right. Did you do the tower and distance analysis?
We did. Cell site here, so inside we're communicating with the same 847, 849. We have our distancing for these events here. And
this is actually inside the home, correct?
This is actually inside her home, yes.
Okay, and I noticed that these are now north of Tram Road.
That is correct.
Okay. And this is the distancing and additional event.
So when we bring in the additional distancing again, we have one event that comes up short down here. But if we look at the bulk of our information and our primary distancing, that first initial reported distance, we usually find to be a little more accurate. The secondary distance or those others, they're not reported to as many decimal places, so we automatically lose a little bit of accuracy there. So we like to look at the primary distances, but we certainly don't exclude those additional distances as well.
Okay. After getting all this information from your phone that you know where your locations are inside the home of Brandy Peters, did you go back and do an analysis between your primary data obtained from the 408 phone number and this information you got from Mr. Segura's phone? I mean, from his phone.
Yes, we did. And again, knowing that some of our distances were going to be very, very similar, we wanted a way to represent these to where that we could see them both. And so if we look at our data in blue and the 408 data, and we're talking about those series of events after 6, text messages, we just have primary distances for those, so we're looking at our primary distances. And we can see that our data and the 408's data is extremely consistent.
Okay. I have no further questions. Cross.
You going to be referring up here, Mr. Prince?
No, Your Honor. Not unless the witness needs to, I suppose. Investigator Colbert, I want to start by asking you about the sequence of communications between the 408 number, the defendant's girlfriend phone, and the victim's handset. You summarized those with Mr. Fuchs. You have a copy of the text messages that were obtained from Mr. Segura's phone, correct?
That's correct.
You also have a copy of the text messages to his primary phone that were obtained from the carrier, correct?
That is correct.
May I approach the witness, Your Honor?
You may.
And I know this isn't the actual exhibit that was in evidence, but is that a true and accurate copy of the same information?
Yes, it is.
Okay. And clarify for the record which particular text message report we're looking at.
So this is the text message report, the Verizon text message report with the actual content in it. And it's the same ones that we looked at for Mr. Segura's primary phone, the 509 number, where we could actually see the content of those messages and read them out.
Okay. And that text message right there was sent from Ms. Peters' phone to the defendant's primary phone on Thursday the 18th, correct?
That is correct.
Okay. What time during the day was that text message sent?
That was at 9:58 a.m.
And what is the content of the text message?
The content is, you was looking good. If you wasn't my baby daddy, I would have given you some, LOL.
May I approach the witness, Your Honor?
You may.
So the sequence of events in terms of communications, we have the text messages that were forwarded to Mrs. Segura, Malika Segura's phone from the defendant on Tuesday the 16th, correct?
That's correct.
About child support, apparently about child support. And is that correct?
It is, yes.
And then on the 17th, we have cell phone location information for the defendant's 408 phone number showing that he went over to the victim's home, or at least at a location consistent with her home.
Yes, that's correct.
Okay. And then on the 18th, that's when she sends the text message saying that he looks good and she would have hooked up with him if he wasn't her baby daddy.
That's correct.
Okay. I want to ask you about what happens between the two of their handsets following that communication. Are there calls from Mr. Segura to Ms. Peters following the text message from her? I'm specifically referencing the ones at 10:02 and 10:08 on the 18th.
I will have to bring up.
Oh, and before you go there, one other question about the text message you read. That one was also deleted from the defendant's phone, correct?
That's correct.
Yes.
So I'm sorry, you want to talk about the 18th
Yes, sir.
and call. So I will look at Ms. Peters' records for the 18th. And your question, sir?
There are, immediately after she sends that text message to him at 9:58, we have a call from him to her at 10:02 first, right?
That is correct.
That one's about 2 minutes long.
Correct.
And then we have a long call between the two of them beginning at 10:05 p.m., correct?
That's correct.
Okay. And of course, there's nothing in these records that would let you know what those calls are about, right?
That's correct.
Okay. I'm sorry to jump back for a second, but I want to clarify that during the time you referenced on the 17th, when the defendant's 408 number is consistent with a location, is consistent with being at the victim's house, the location information provided is consistent with being at her house, his primary phone number, the 509-4380 number, is at a location consistent with his home, correct?
That is correct.
So when he went up there on the 17th, he left the primary phone at home as well?
It would appear, yes.
Okay. I want to ask you a couple questions about the star 67 as well. In the records that we've discussed here and that you reviewed, every time he's calling her number, meaning Mr. Segura is calling the victim's number from his 408 phone, it's always star 67, correct?
Yes, everything that we've looked at, it appears that each time he uses the star 67, and she was unaware of that undisclosed phone number.
Right. So it's like when she looks at her screen, when it comes in, it's going to say blocked or unknown or something like that.
Correct.
Okay. So she wouldn't be able to save that 408 number as a contact in her phone?
She would not.
Okay. And so if someone were to take that physical handset, it's not as if they would be able to see in her phone that he was saved as a contact associated with that 408 number. Her handset wouldn't show that.
The handset wouldn't show if they were saved as a contact, but it would certainly show text message content and other things that would be within that phone.
There were no text messages from the 408 number to her phone or vice versa, were there?
Not from the 408.
Right. So there would be nothing in her actual handset to connect the 408 number to Henry Segura. It would have to come from records from the carrier.
If we didn't have the text message content for both the 408 and the 509 numbers, again, we go back to that text message that says, did you hang up on me or what? We know that went from Ms. Peters to the primary phone and then a call back from the undisclosed phone. If we were unable to get the records from the carrier, then that text message would still been in Ms. Peters' phone if we had it. And we could have seen that she sent a text message to Mr. Segura's phone, which we can see in the records, but then we would have had the actual content. So we were lucky that we were able to get it from the carrier, but the phone would have been another source for that text message.
In referencing that text message real quickly here, that isn't actually the totality of the communication, right? Isn't what she actually says, did you hang up on me? What happened? Isn't that what she said?
Yes.
Okay. So it wasn't as if it was clear to her that he had just clicked the phone off. She didn't know if it got cut off or what.
Correct. It would indicate some abrupt end to a communication.
As typically happens with cell phone carriers.
Unfortunately, yes.
So going back to, I want to be clear though about the last question that I was asking. There are no text communications between the 408 number and Brandy's number, correct?
That is correct.
Okay. I want to jump now to some of the communications for Mr. Segura's 408 phone number during the daytime on the 19th. Starting with there's a set of 3 communications starting at 13:23 and running through 13:26. You see those?
I do, yes.
Okay. And I know you explained this, but I want to go back and clarify. What does it mean when there are calls in rapid sequence like that over a short period of time that are jumping sector lines? First it's in sector 1 of the same tower, then it's in sector 2 of the same tower.
Well, if they are changing sectors and the calls are in relatively close time frame, seconds or a couple of minutes apart, then either one, we believe that the person is very rapidly moving from the good part of one cell to the other part of the other cell, or they could be much closer to that division line, that point where the 2 cells kind of overlap, and the handset, based on the event, may choose one or the other.
Okay. And The victim's house in this case is pretty close to that sector line, correct?
It is.
So using the fact that Mr. Segura's phone is jumping the sector line during the time frame we're talking about and the distance reported from the primary tower, I guess you would opine that his handset is at a location consistent with her house or at a location near her house during that time frame, correct?
Certainly could be, yes.
Okay. And preceding those calls, we actually have another one of the long calls, long communications between the defendant's 408 phone and the victim's phone. Is that right? Starting at 11:30 a.m. on the 19th?
That's correct.
And how long exactly was that call?
It's 3,340 seconds.
Okay, so they talk on the phone for a long time that morning, and then we have him at a location consistent with her house around 1:30.
That's correct.
Okay. And from 1:41 to 3:05, he's only communicating, his handset is only communicating with Sector 1 of Tower 847, correct?
I'm sorry, you're 145 for which handset?
I'm only going to ask now about his 408 phone number.
Okay.
So from 1341, all the way up to 15:05, there's no communications from Mr. Segura's 408 phone number that go to Sector 2 as the primary sector for Tower 847, correct?
Wow. I'm looking at his actual calls. Are you referring to, yes, so you're talking about not just the call log, but you're talking about the RTT report, which has text messages. So there's not a call at 1341, but there is a text message. Right. So yes.
Okay. So all of those are in Sector 1.
After that, from 1341, all of the events, both voice and SMS until the 305 are in Sector 1, yes.
Okay. I want to jump for a second to some of the locations that you discussed during the course of telling us how you did your experiment with the dummy phone here. Can you tell me which of those locations are in Sector 1 of Tower 847? You understand what I'm asking?
Well, you're asking me which of the locations are in Sector 1. So the Sector 1 of 847 is a tower there at McNeil Boulevard, and Sector 1 is a tower the sector that faces kind of northeast. And we saw, when I drew on the screen, we saw about where that split was. So really anything from probably about the entrance of that neighborhood, kind of around that direction, would favor more Sector 1 than Sector 2.
So northeast, basically, of Tower 847 is where we'd be looking?
Yes, probably from maybe 2 o'clock around would probably be about where we would look at.
And of the locations that you mentioned before, those locations would include the church and church parking lot slightly north of the victim's house, correct?
That's correct.
And also the defendant's sister's home, correct?
That's correct.
Okay. Now that we've started to touch on the experiment that you did a little bit, I want to ask about the calculation of error range. You mentioned some of the flyers and also mentioned how you averaged them out. Tell me if I'm wrong. Did I also hear you say, though, that when you're trying to figure out where someone was, as opposed to knowing where they are, like when you know somebody's sleeping at a particular spot, you have to use all of the data to figure out the possible error range? Is that right?
Yes. So again, if I'm looking for someone and I'm trying to find them, then I'm going to look at all the very consistent pieces of data, because I know there's going to be a flyer here or there, but they're going to be in that, where that meat of that information is. If you're going to say, well, for one event, where is it possible that they could have been? Well, then yes, and I have to take into account what I saw as the worst error. But again, even with that, I can say, well, that may be the worst for that one event, but if I have 10 events and only one of them is that bad, then the other 9 to me kind of weigh that it's more likely to be towards the good part of that data than towards those flyers. But for each individual event, yes, I do have to take into account the minimum maximum.
Okay, and so using the set of data that you gathered from your experiment, which includes the flyers, as you term them, for Tower 847, the maximum plus or minus error range was 0.64 miles, correct?
I believe, and I'm trying to catch up with you here to get my spreadsheet open that has that, But it was around that distance, yes.
Feel free to take the time and look at it.
Too many spreadsheets. So for the 847 sector, you're talking about 847-1, again, our McNeil Boulevard sector there. The worst that I saw was just over 0.6 of a mile.
Okay. And again, what you're doing in this case in terms of investigation is trying to figure out where a handset is because you don't know where the handset is, correct?
Well, I'm trying to include or exclude possible locations. So the question is, could the handset have been at Mr. Segura's residence? No. Could the handset have been at Ms. Peters' residence? Yes. So I'm including and excluding. I don't necessarily have to say exactly where it was. I'm not trying to say, exactly where the handset is. I can't do that. But I can include and exclude various locations that may or may not be relevant to the case.
And so what we would expect to see then is that the phone, when it's communicating with Tower 847 Sector 1, the phone is going to be within a, what would it be, 1.2 mile arc. Plus or minus 0.64. Am I understanding that right?
Yes, if you take the worst that I saw, then yes, it would be plus or minus, or that whole range would be 1.2 miles.
Okay. And then for Tower 849, the maximum error range there was 1.25 miles, correct?
That is correct, for the absolute worst that we saw.
And again, that's the sector facing the victim's home, right?
That's correct.
All right. And so that's plus or minus, same as we discussed with the 0.64 figure. So you would expect the handset, when it's communicating with that particular sector of Tower 849, to be within a 2.5 mile arc.
Correct.
Okay. And the locations that I mentioned before, the defendant's sister's home and the church parking lot, those are both within both of those arcs, correct?
They would likely be, yes.
I want to ask you, Mr. Fuchs kind of touched on it, some anomalous or flyer type readings that you got, even within the small data sample from the defendant's actual communications from the 408 number on the 19th, starting at, well, I guess let's start at 6:01 first. 6:01 p.m., 18:01:54. You see that communication on the 19th?
Yes, sir.
The reported distance there is 3.98 miles from Tower 851, Sector 1, correct?
That's correct.
Okay. Where is that location relative to the victim's house?
Well, I can bring it up on a map if that would be easier to show.
That would be fine, or if you know the actual distance, that would be fine too.
I couldn't tell you off the top of my head the distance
Okay.
from that to the victim's residence. To make sure I have the right one going here.
You gonna be a while, Mr. Prince? We probably do to take a short break if you can do that.
We can take a short break. Yes,
All
sir.
right, let's take 10 minutes.
Welcome back to Law News Network. I'm Alura Nanos, and I've got Ken Belkin and Misty Maris here with me at the table.
The dream
and
team.
We got the dream team today, and we are at a sidebar with Christopher Corbett on the stand. Christopher Corbett is a cell phone expert. We've been listening to hours of his testimony in the Segura case, and what does this all come down to? Why do we care what this guy has to say? It all comes down to basically one point where we're talking about, which is
Location,
Yeah.
location, location.
Where was Segura on the day of this murder? So, the prosecution's case, they don't really have a lot of direct evidence, so they're really trying to show that he was in the vicinity using the cell phone pings and records in order to get there. But on our end, and from the viewer's perspective and the jury's perspective, it can get a little dry, although it's a necessary evil.
I like it when Misty says, "There's not really a lot of direct evidence." Also known as, "There's no direct evidence whatsoever in this case."
I mean, their case is really hinging on the fact that he was in the vicinity, provided that that's what the jury
was
believes
nearby,
based on
right.
The fact that he lied about being
That
in
he-
the vicinity.
Right,
That's
and
part
really
of it.
that's
His interrogation video was not so good for him because it showed that he was being dishonest during that interrogation, that he asked an ex-girlfriend for a gun, to borrow a gun, didn't say why, shortly before, and that he got into a fight with the victim.
And he
before.
had a
That's really
motive.
it.
So, I mean, there's plenty of circumstantial evidence. It's not like there's no evidence at all.
Yeah.
There is circumstantial evidence. It's just not evidence directly putting him at that crime scene or anyone seeing him pull a trigger or anything like that. But what we have, and I think it's an interesting contrast, when you see the witness, Christopher Corbett, on the stand, who he's really, even though his testimony is not the most interesting, compelling
You're not
testimony.
finding this riveting?
I mean, it's not riveting. But I will say this, he's a fantastic witness. He is articulate, he's credible, he's very confident, he's clearly testified before. So you have a lot there, and if you compare that to Seura, who in his statements was obviously lying in a number of situations, the contrast alone, I think, does some real damage to this guy as a defendant.
But let's put on our defense caps for a second.
I'll put it on.
Maybe,
I'm always
maybe,
wearing mine.
as am I, mostly to cover my head. But look, Seura, he may not have been honest about where he was or accurate, but maybe he was just mistaken. And these cell phone towers, it's not like you get like such an accurate location. They can sort of like say you're in the vicinity, and they did that circle that showed he was around here. That doesn't really put him at the scene of the crime.
That's exactly right. It's not like it was in remember in the series 24? Every 2 seconds they were doing passive triangulation. They were finding Jack Bauer exactly where he was. It's not quite that exact, right?
Well,
I mean,
right. And
we're
what's
showing
interesting
a
about that is that people expect that because of shows like that.
That's exactly right.
NCIS, because of 24. People expect that there's a beam that's just going to point exactly where that person was, but that's just not the case here. So it's
the same thing with DNA evidence. We think that DNA evidence is totally, like infallible. But the fact of the matter is, DNA gets transmitted all the time. I told Aaron Cowler all the time that, he probably has DNA from me from 2 weeks ago on him.
Right. And that's why, of course, we need this sometimes excruciatingly lengthy testimony from experts really guiding the jury through what is real science, what is sort of TV science that you may think from fiction that's out there, and what really means something with respect to the case at hand. And it really is the classic situation where the jury needs that expert testimony to walk them through complicated information that's being presented. So we'll see. So just to recap our viewers, here's where we are. We are on the last prosecution witness in the Seura case. This is the incredibly tragic case of the murder. It's a quadruple homicide, murder of a mother, her twin 6-year-olds, her 1 3-year-old, I think it was, the children found in a bathtub. It really, really horrific and extremely tragic facts. But as trial watching goes, this is a good one. This is really a case that has a really interesting facts, because we have what actually happened, which of course is tragic and terribly gruesome. And then we also, we kind of know the preview. We know what's coming. We know that what is coming is a really heavy-hitting defense case that says it wasn't this defendant, it was somebody else that did it. So we're waiting right now, 1 o'clock Eastern time, I believe it is. There's going to be an evidentiary hearing in this case about Mr. Santos. And Misty, do me a favor, just remind us who Santos is.
I would love to. So let's go through this, because this is really throwing a big wrench into the case here. This is a big twist. So Santos is the former head of the Vice gang. So he's a gang leader. And he's confessed, actually, from his prison cell, and he said, I'm the one that ordered the hit on the victim.
Which is weird.
Which is very weird. I mean, very strange. So apparently, as the story goes, according to Santos, which, by the way, has changed a little bit from his account to account throughout his interviews with the police and then his pretrial testimony, the story goes that the victim was actually involved in the drug cartel, that she was skimming off the top with whatever cocaine delivery she was making, up to $90,000 that she stole, and that's why this happened to her. This was a hit based on gang-related activities.
And they were negotiating a repayment plan.
Yeah, well, I
don't think that negotiation
2%
went so well.
And all that, and
they did that through their counsel.
Out of your bank account.
Cartel always does 2% interest.
Right, obviously.
They're very reasonable.
Sure, sure. I mean, this is what makes this case really a special case to watch, because in so many homicide cases, what you have, of course, the defense has no burden to bring up their own story, and what you have is a lot of poking holes in the prosecution's case. You have, police misconduct or sloppy investigatory work. That's kind of your typical, let's throw out maybe some things that might have happened, but here we have kind of something thrown in that really, really could make a major difference in how anyone, specifically the jury, could look at this case. When you throw in credible evidence that the victim was involved in a drug cartel, this is not like, I don't know, it could have been a drug cartel. I think there's real evidence here that this victim actually did have ties to a drug cartel. You throw that in, it casts a shadow over the entire case.
Oh, definitely. I mean, do you even really have to show the exactly what Santos said is the truth, or that he's particularly credible? Or is it enough to just say, look, she's connected to this drug cartel? Guess what? If you're connected to a drug cartel and there's issues with money deliveries, etc., the repercussions are generally pretty steep and include death. So, I mean, this is really a huge point for the defense.
Absolutely. I mean, and then when you throw in the issue, the prosecution, of course, we say this all the time, prosecution is under no obligation to put forth a motive, but it always helps if it does, right? Yeah. So the motive here is $20,000 in unpaid child support.
Yeah.
I mean, I guess. That's like a really lame motive, if you ask me.
Yeah, very lame.
The guy is going to kill his own child to skip out on a payment when he might or might not have been held accountable for that child support payment. It just seems a bit much.
Yeah, this is a very compelling defense theory. I mean, look, the jurors, we're all living in the post-Breaking Bad era. This is straight out of Breaking Bad. And for the jurors to hear, look, you've got this guy who owes $20,000 in child support, and because of that, he killed his kids. Because let's face it, kids are expensive, right? That's basically the prosecution's theory. Or you've got a woman that was heavily involved in the narcotics trafficking, and that she was in to 90 to 100 grand deep to the cartel. What's the more likely person to kill the woman and take the kids' 3 lives?
And then
sending a message.
I think you're right. And then if you add in the facts that I think are very difficult to ignore, I know that from the outside looking in, I have a very difficult time even thinking about this case without picturing this awful scene of the children in the bathtub.
Yeah, horrible.
When you think about, really terrible. But the style of that type of crime screams drugs, gangs, cartels. I mean, it really is just like out of Breaking Bad. Like, you could see it being that type of crime. And once you raise that type of thing, once it seems that the signs are pointing to that type of crime, it's a bell that's really difficult to unring.
I mean, the prosecution's asking the jury to make the decision. Was this guy less willing to go to jail for outstanding child support of $20,000 than he was to go to jail for a potential quadruple homicide?
It just doesn't really make a lot of sense.
Make a lot of sense.
Whereas if you think about it from the point of view of a potential drug running gone wrong, it actually makes quite a bit of sense.
Oh,
right?
you can picture that in your mind, knowing what you know about the brutality of those types of gangs and circumstances and drug cartels. So you make a great point. The prosecution, what they're going to do, they're going to go after this guy Santos to the extent, whatever the judge is going to let in, we don't really know. We're going to have that evidentiary hearing later. We know that portions of his pretrial transcript have already been flagged to move forward. So it'll be interesting to see. But the prosecution, they do have a little ammo against this guy. Taking away from the whole just idea that this is a drug-related death, they have some prior statements that he made that are inconsistent. They also have...
Shocker.
Yeah.
Shocker, the drug lord has made inconsistent statements.
Oh, I guess maybe
he has trouble getting it together.
I mean, right. And in real criminal law, that's not out of a TV show. This is, of course, always how it goes down.
Right.
Right?
No, I mean,
everyone's got
absolutely
inconsistent statements.
But let's talk about what's a little unique here, though, is that he's claimed responsibility for other deaths that turned out to not be him in unrelated cases. So he's kind of going around saying this stuff maybe perhaps boasting. I don't know. I'm not sure what's going on in his mind to just confess to a lot of murders that he didn't commit. But that's going to undercut his testimony.
This is an important point, and we're going to go back to the courtroom in just a sec. But I want to pick up on that later. The idea that Santos, the guy who is claiming responsibility for this death, these four deaths, has in fact also copped to murders in the past is very interesting. We might need to know, did he really kill those other people in the past? Was that found to be credible? Does the judge know about that? Is this a guy who sees the value in taking responsibility for things and in otherwise orchestrating the criminal justice system from his own jail cell? It brings up quite a few things. I'm going to leave it there with Ken and Misty, but we will be back as soon as we can. But we're going to bring you back live to the courtroom now in the Segura case, following up with this last prosecution witness.
That's still consistent with the victim's location, the victim's home location, correct?
It could still include the victim's residence. Certainly, if you take the maximum error that we saw in our test for that tower, it is less than that. So it could include her house, or it could be that he left for a period of time and went back. I don't know exactly the sequence of events.
If we were to assume that the handset is still at that location, that would certainly corroborate the idea that the error range is and can be up to the maximum that you have discussed, correct?
Well, we know it certainly can be up to the maximum versus what we usually see, but yes, that is a possibility.
Then by 6:05, we have the handset, the 408 handset, 6:05 on the 19th, in case it's not clear. We have the defendant's 408 phone back at a location consistent with the victim's home, correct?
That is correct.
He's again communicating with Tower 847 at that point, right?
That is correct.
Okay. So from in that 4-minute or less interval there, if the phone had been away, it's a mile back north again, right?
Yeah, and I can actually, I don't know if we're still hooked up, I can project this if it'd be easier to see. I do have the maps. And I'm sorry, your question?
I was just wanting to confirm that the handset within that 4-minute span is again reporting at a location consistent with her home by 6:05.
It is, yes.
Okay. And then if we could, let's jump to the 7:23, those two communications that are back-to-back 7 seconds apart, 7:23:42 and 7:23:49. Let's jump to those two and talk about those. How far away are those reported distances from each other? And I know that takes a few steps of analysis because they're talking to different towers, but how far away are those reported distances with respect to their individual towers from each other?
Well, as they're two different towers, two different distances, that goes from they're exactly together to a maximum of, and as we can see here, so what I have up now is, this is sort of the wizard behind the curtain. This is the map, the GIS mapping that was the basis of the presentation that I was doing earlier. So here I can turn on and off certain features, and this gives me the benefit of a measuring tool, which allows me to answer the questions a little quicker here. So these are the two distancing events that are being asked about. And as they are, again, two different distances, they could either be together here, where the distance between them is 0, or if you go to this point, then the maximum distance between them in miles, and I'm hoping I'm hitting the maximum part of the arc here, is just under 1 mile, would be the maximum that they are apart.
If we're to assume that the phone is at the victim's house here, how far apart are the readings if you draw a line straight through the victim's home?
If I were to look at the victim's home and go the distances here, then this one would be 0.4 of a mile, 4.47 miles would be that distance. And then if I were to look at the other distance, it would be 0.22 miles.
Okay, so a little over 0.6 of a mile. Am I calculating that right? One of them was 0.4 of a mile, or 4.47 miles?
Sure. I mean, I have to look at, it's not necessarily a straight line. You're saying how far is one from the other. So I have to go from the victim's residence to the closest point of that arc, I want for both of them. So for one, that means I'm going, this direction, if you can follow the arrow, and for one, I'm going this direction. So it's not necessarily a straight line, but yes, probably about 0.6 of a mile.
Okay. Erring on the side of caution, that means that if he were actually traveling as opposed to in a single location, he would be traveling at some absurd speed, correct?
It'd be pretty quick, yes.
Yes, okay. In 7 seconds going over half a mile. That's essentially what we would have to find there. Or the other more reasonable interpretation would be that we're working with larger error ranges here. Would that be correct?
Larger than which? I mean, we already knew that our maximum for this tower was 0.6 of a mile, just for this closest tower. So 0.6 of a mile would cover the 0.6 of a mile that we're discussing. Our error rate for the other tower that's south is 1.25 miles, so that would certainly cover that. So if you assume that this event has the worst possible error, they could be a lot further away, but if you assume these events have about the average error that we saw, then they're still consistent with the residents.
I should have asked you before, what was the average error that you worked out for Tower 847 and then 849 not using the flyers?
I don't have one without flyers.
You only calculated the average with the flyers?
Per tower, yes, that's correct.
Okay. What then is the average? We've talked about the maximum. What is the average for 847 and then 849?
So we really didn't do our test phone to come up with an error range. We just wanted to say, hey, what does our stuff look like versus the other stuff? Do they look the same? But of course, it does give us the ability to do that, to come up with an error range. And we looked at the data in a variety of different ways. And I could look at what was my error at a particular location. I could look what was my error for a particular data type. If it was a text message, a voice call, was it different? But what seemed to be the most accurate was to look at the error based on the cell sites. Because as I was communicating with cell sites further away, I would see a little greater errors, closer ones a little less. So that proved to me to be a more accurate representation. So the maximum, as you asked for, Tower 847 is 0.63. You can see that my average is just under 0.2 of a mile. So 0.195 is the average that we saw, and we can talk about those in meters as well. And 849, which is the 1.25, and my average is just over 1/4 of a mile for that tower.
Okay. It's true, though, isn't it, that within the 10 communications that take place for the 408 number between 6:01 p.m. and the second 7:23 p.m. communication, and that's all communications I'm talking about, calls, texts, and data, as indicated in your summary, 3 of those are well outside those error ranges. You've already told, I'll stop there and let you answer that and then ask the next one.
Okay, and again, go back to which events you're talking about?
The 6:01, which you said was about a mile. If we were to assume that the 408 handset is at her house at 6:01 p.m.,
okay,
it was indicating it was a mile south of her house.
That's correct.
That would be within the maximum, but far outside the average for Tower 851, correct?
That's correct. But again, we're talking about that tower that's all the way down here in the south end of the county, and it is the tower that, consistently showed us more inaccuracy than the others. So for that one event, yes, it is, on the larger side of the error range, but it still could include the house.
Mm-hmm. And then for the other 2 communications I was referring to within an hour and a half, one of those communications was with Tower 847, right?
Yes, now you're moving to the 723 events?
Right.
Okay.
One of is it the first one that's with 847?
The first one, the one that's at 723.42, is communicating with 847.
And that one's the one that's north of her house, about 0.47 miles, correct?
That's correct.
Okay. Again, the error range for Tower 847 that you averaged was what?
0.6 of a mile.
Okay. That was the maximum, right?
That is, I'm sorry, yes, the maximum is 0.6. My average for 847 is about 0.2.
Okay. So if we assume with respect to that communication, the communication that takes place at 7:23 and 42 seconds, that one is also more than double your average error rate, correct?
Yes.
Okay. And then for the next communication, the one that takes place at 7:23 and 49 seconds, that's the one that lands south of the victim's house, correct? On this map that you have up right here?
That is correct.
All right. And what did you say that distance was, about 0.2?
Yes, that's correct.
Okay, which is about what your average was, right?
That's correct.
Okay. So out of the 10 communications between 6:01 and 7:23 sequentially, well, I guess there's 9 if we do it to the first 7:23 communication, 2 of those 9 are way outside the average error range, correct? If we assume the handset is at her house.
If you assume that the handset is outside of the house, and since we're talking about all these distances, let me go ahead and get them onto the map here. So there is our data, and I believe that I have them all. 601, 605. So we can see that there are a number of distances. And yes, we have one that's short, we have one that's long. And again, as we deal with this data, we realize that we may have one that's here or there. But if I look at the bulk of that data, if I look at the majority of it, it to me paints a more consistent picture.
Okay. I want to ask you also, I thought that I heard you say during your testimony with Mr. Fuchs that you interpreted some communication around 10 o'clock as being on the way home as opposed to being at the defendant's house. Did I hear you right about that?
I don't remember if I gave directionality to it, but there was an event that referenced being near the Publix.
Isn't it true that all of the communications after 9:30 p.m. from both phones are at a location consistent with the defendant's house?
For both phones after what time?
And when I say both phones, I'm talking about the 408 number and the 509 number.
The 509. So we can actually see. So we have our 9:30 events here, and I have no idea if you guys can see this. Let me zoom in here a little bit. Just want to make sure everyone's clear. So we have the 9:30 event that we talked about earlier communicated with our Verizon 850 Sector 2. And so we knew that was there, and that's the one that we see that's very consistent with the house. As we continue later in the evening on the 19th, now we're up here, this is 10:18. So 10:18 we go over, and now we're communicating with Verizon 848. We have left our 850 that we usually see, and now we're communicating with 848.1, and then 848, 848, 848, 848, and then we drop back to the 850 at 10:45. So these events here in the middle, this one right here, this 848.1, that is the north side of that one sector. And I can actually, I'd have to go to another map to show you, but here is 848. And so that is Sector 1. And that sector would be inconsistent with Mr. Segura's residence. So I can't say that all of the events after 9:30 are consistent with the phone being at the house.
Okay. May I approach the witness, Your Honor? You may. You recall taking a deposition in this case, right?
I do, some years ago.
And you were under oath at that deposition just as you are today?
Yes, sir. you
recall being asked, looking at your summary, you believe his handset is consistent with him being back at his house. Was it 9:16, 9:30? A call comes through, and you say yes. You go on to say you're going to look at the records, and then continue your answer. And for reference, I'm sorry I didn't mention, beginning on page 21, I'll let you get there, at line 23. Continuing your answer, yes, and then down at line 10. So somewhere in between 9:21 and 9:30, he would have returned. That was your answer, correct?
I'm sorry, I might have been a page off. You're on page
22 now.
22. Okay.
The answer ends down at line 11.
So you ask when he's still up at the victim's house, and I say, right, this is still consistent with that. I believe there's another look at the record to say for sure, but I believe that the last event that we had at the residence, the next event is 9:30, so somewhere between 8:21 and 9:30 he would have returned.
And when you say he would have returned, you're talking about to his home, correct?
That's correct.
Okay. So if you're now saying that the communication with the 948, was it 948, 848?
848.
If you're saying that's not consistent with his house, that means, according to what you said under the deposition, your testimony today, he would have had to return home and then go back to Publix and then come back home again. Is that right?
Correct.
Okay. At any rate, he's nowhere near the victim's house again after 9:30, correct?
No. The question asked of me in the depot was, did he return home around 9:30? And yes, as we see in the events here, we see this 21:30, 9:30. The phone is communicating with 850 Sector 2, which is consistent with his house. So yes, the answer is correct. He did return home at around 9:30. I was not asked the subsequent question of, did it ever leave again? But if we look in the records, we can see that at some point it's inconsistent with the house. And your question is correct. It is not near Ms. Peters' residence, but it has left the house again.
At no point that night, just to be totally clear, at no point that night, the night of the 19th, into the early morning hours of the 20th, does either one of Henry Segura's phones go back anywhere near Brandy's house, right?
We have no records that indicate the handsets went back. There are periods of inactivity where we have no idea where they are, but there's nothing that shows that those handsets went back to the scene.
And the 408 number remains active into the early morning hours of the 20th, right?
Yes, it does.
And he's communicating with women, including Natasha Hawthorne, correct?
That's correct.
Okay. That all indicates that that handset is attended at his home, correct?
Well, as you can see here, we have an event at 11:53, and then our next event is 3:35 a.m. So you have 3.5 hours that I can't say where the handset is or not.
Okay. And what about the 509 number?
We'll have to get that one up. Let's see. So for the 509 number, we have a data session at 9:46. We have a data session at 12:25, and then nothing until 10:21. So really, for this handset, that window of nothing active on the handset to tell us for sure that someone was behind it wherever it was. This handset would appear to be at the house, but we have a pretty large window where there's no activity at all.
So as far as you can say, absolutely no evidence from the cell phone records that either handset leaves Mr. Segura's home after returning for the last time that night.
After returning for the last time, no, there's no evidence that it leaves again.
All right. Now you did, we heard some communication, we heard some testimony about the communications between Mr. Segura's primary phone and his wife Malika's phone during your direct exam.
That's correct.
Okay. You did location information or obtained location information for Malika's handset as well, correct?
We did, yes.
And Malika's handset was never anywhere near the victim's house either, correct?
Certainly not that I recall, no.
Okay. I want to ask you just a few quick questions about the victim's phone activity. There were several calls from her phone starting at 5:51 p.m. on the 19th, and then again at 6:11 p.m. on the 19th. Those were longer calls, correct, in duration? Particularly the one at 6:11 was like a 40-some minute call, correct?
Yeah, I certainly want to make sure I answer correctly here. The 6:11 call was 2,500 seconds, whatever the math is. If you divide that by 60, would tell you how many minutes it was. And so yes, it ended at 8:52, so it would have been, by Sprint's math, about a 41-minute phone call.
Okay. And then lastly, you had an opportunity to review all of the records for Mr. Segura's 408 phone, correct?
Yes.
So you reviewed not just the RTT data, which is the distance from tower data, but the text records, call records, all that kind of stuff.
Yes.
Okay. Would it be fair to say that in viewing the text records in particular, it is apparent that many of Mr. Segura's communications are with different handsets, with different numbers, and many of those communications are about setting up sexual encounters or about sexual topics?
Certainly a portion of them include that, yes.
Yeah. Thank you. I have no further questions at this time.
Redirect.
last question. Other females, not Ms. Peters.
Correct.
That last phone call you just talked about on the 19th, you said something, I think you said it was on November 19th and it ended at 8:42. Is that what
well, I hope not. 1842, which would have been 6:42.
1842, okay.
Yes.
Then I misunderstood you. Okay, I thought you said 8:42, my bad. So that's 6:42.
Yeah, it ended at 1852, which would have been 6:42.
Okay.
The military time.
All right, and then we have the subsequent text at 6:53.
That is correct.
And then nothing from there on.
That is correct.
Okay. Mr. Prince asked you a couple of questions about I think it was the sister, the two family members that were within Sector 1. Again, the data obtained from the test phone that you utilized and the data that was analyzed for the 408 number, there's nothing consistent there that would show that he was at either one of those locations, correct?
There's not. Looking at the bulk of the data, again, all those locations we saw, our distancing came up short of Tram Road. We can see for these here, they're beyond. So it's more consistent with being at Ms. Peters' residence than it is any of the others that we looked at.
And you said the bulk of the transmissions. Is it important when you're looking at all this to look at the bulk and not just one particular event?
Yes, I believe it is.
And that is why you made so many events with the TPD phone and, of course, looked at all these analysis.
That's correct.
Okay. As it relates to Ms. Peters, you looked at all her data for a period of time, correct?
Yes, we did.
Is it unusual, or would it appear to be unusual for Ms. Peters not to be utilizing her phone?
I didn't look at particular for periods of inactivity. What I have right here in my hand are records from November 13th through November 20th, so this is a 7-day period, and there's 26 pages of records. So I would say yes, she's consistently active on her phone.
When you look at those records and you look at hourly, just for instance, does it appear that there are multiple different things happening each hour, as in not like a solitary phone call? You understand what I'm asking?
Yes, there's a significant number of text messages, voice calls, and again, I haven't looked at every period of inactivity, but in just this week, there's a good bit of activity on the handset.
Okay. So looking at that, just kind of overview, it appears that a longer period of inactivity, such as we saw on the 19th, is not a common occurrence from this.
It would seem to be unusual, yes.
No further questions.
All right, jury, have a question of this witness. We'll go sidebar.
Welcome back to LawNewz Network. I'm Allura Nanos. We're just on a quick sidebar in the Seura case. Just to let everybody know what's happening today, we are on verdict watch for the Ohio versus Gasper case. We are at the end of the prosecution's case for the Henry Seura case, and we will have you live in the courtroom as any developments on either of those take place. I am here with my girl, Misty Maris. Hey, Misty.
Hello, Allura. Thanks for having me.
So good to have you here at the LawNewz table.
Yes, it's so much fun. I love being your guest, and it's great because we have so many great cases today to go through.
Today's a good day, isn't it? Like
yes.
there's like I feel like there's a lot happening, and you know, we're on verdict watch for Ohio versus Gasper. So you know, no testimony or anything like that today. But that case is an interesting case, I think, particularly in light of what happened with Tiger Woods this morning, or what didn't happen with Tiger Woods this morning.
The anticlimactic Tiger Woods hearing. Yes, well, it is. And we've been watching, obviously, that case gavel to gavel. So we know how all of the testimony played out in Gasper. So there's a real dichotomy between what we saw in Gasper as far as that dash cam video where it's showing his alleged impairment, and what we saw from Tiger Woods and that dash cam video. Yeah. I mean, night and day. As far as Gasper was concerned, there were really no outward signs of impairment. A lot of why he was arrested was based on that arresting officer's assessment of him. He was nervous, he had trouble answering questions, he had trouble understanding. Call it his totality of the circumstances assessment of impairment, you know, maybe not didn't hold up so great in court, as opposed to Tiger.
If you read the report or see the dash cam video, the Tiger Woods stuff, that's completely different. He's a disaster.
Absolutely. I mean, it's objectively clear there was impairment there. Why? Okay, so it's prescription medications. It wasn't necessarily something that he wasn't intoxicated. He blew the 0-0, but impairment's not just intoxication. Impairment also being impaired on those medications. So I think, made the right call here. I mean, I predicted this earlier in the week, that he was going to have to plead guilty and go into the program and just take the hit, because that dash cam video was damning.
Yeah, so, and you know, it's interesting when we see, you know, like I said, we're on verdict watch, right? And we have here, this is aggravated vehicular homicide. This is a serious crime. And what do you think is going to happen? You know, I know you were here yesterday. You're looking at the end of that case. What do you predict? Ultimately, there are a million things, brilliant legal points we could make about the legal analysis. But really, it all comes down to, what do you think is going to happen?
Oh, absolutely. So the aggravated vehicular homicide, you have to have this reckless standard. So the prosecution was trying to show impairment. They were very focused on that. I do not think they came even close to getting there. So the other aspect is, all right, was he driving recklessly? Was his speed too high? Was he following the car in front too close? Well, the prosecution's case kind of fell apart when the reconstruction has said, well, the speed was really only 62 to 65. So I do not think the prosecution fulfilled their burden on the aggravated vehicular homicide. I would be shocked if he was convicted on that charge. The question is, was there enough for the lesser included offense, which the defense attorney brought up in the closing, and that's a strategic decision. Do you want to even bring it up, or are you so confident in your case that you're just going to go for the acquittal outright? Could it be negligence?
We'll see.
Negligence is a little different.
Yeah, we'll see.
Standard.
We're going to pick back up on that in a second. I want to talk about negligence versus reckless versus aggravated homicide. But for now, we are back in the courtroom. The victim's sister, Brandy Peters' sister, Monica Peters, is back on the stand, headed over to the courtroom now. Back in a few.
Let's not say the rest. All right, let's go sidebar for a moment, please. All right, as I told you, I have some legal issues that I need to resolve. If y'all want to sit back in the jury room for a couple hours, you can do so. But we thought maybe you'd rather go home than do that. So we're going to break with y'all till tomorrow morning. Tomorrow we're going to start at 9 o'clock. Please, let's everybody be here by 9 o'clock, please, so we can get started promptly. Don't discuss the case with anyone. Let anyone discuss the case with you or review any media accounts. Anybody have any issues we need to deal with, questions? If not, we'll see y'all tomorrow morning, 9 o'clock. want to do is resume at 1 o'clock with our motion hearings, just to give you all a heads up. I want to resolve the Santos issues first. Those are ones I'm most familiar with, and so let's keep them separate, because I think it can get confusing. We start mixing them together. So let's start with Santos at 1 o'clock, get that out of the way. Yes, Mr. Fuchs?
Your Honor, as it relates to Mr. Hudson, if he is required to be, as far as testimony goes, he had, because of the short notice, he had multiple different patients that were coming in. He said he can make himself available to the court between 2:15 and 3 o'clock via phone, but he's unable to be here in person.
I was not intending to have Dr. Hudson. I may rely upon his reports. I don't see any reason to have him
Fair enough.
Here in person. Does the defense think we need to have Mr. Hudson, Dr. Hudson here in person?
I don't think his testimony is relevant to the legal analysis, so I don't need to cross him.
Well, I mean, it may have some tangential, I mean, I think it might have some significance, but we've got reports from him. I'm not sure what his testimony would offer in addition to that. Do you have a different idea, Mr. Prince?
I don't think so, no, Your Honor.
Okay, I don't think we need to have him here. I may refer to his report, but I don't think we need to have him here. Anything else?
No, sir, that was the only schedule.
All right, 1 o'clock, we'll be ready to do that.
Thank you.
All right.
Welcome back to Law News Network. I'm your host, Laura Nanos, joined with my girl, Misty Maris. And we are here talking about Florida versus Henry Segura. The prosecution just rested, called their last witness, and now we're adjourned until tomorrow morning when we will start to hear the defense case. And it is going to be a whopper. This is going to be quite a defense case.
This is going to be something I'm really looking forward to seeing how the defense deals with some of these issues that we know are coming up. We know we have somebody who behind prison doors said, I'm the one that ordered the hit on the victim.
I mean, that's really good. That is not what you usually get, even in a really aggressive defense. You know, you might get this aggressive story about how the police, you know, framed somebody or the police did lousy police work. But you don't usually get like, hey, it was a drug cartel and this whole other group of people that you, the jury, didn't even know about or think about.
Absolutely. You're talking about a whole underworld here of these dealings with this drug cartel and somebody who is actually claiming responsibility.
I mean, that never happens.
Defense attorneys do not get that served on a silver platter like that. Again, there's credibility issues there. We're going to see that.
Yeah.
But at the end of the day, here's what you're talking about from a defense perspective, beyond a reasonable doubt. That's the key phrase, right? So you don't have to point the finger at this person, or this person. You just have to say, hey, look,
it might have
been any one of these other four. Are you sure that it's him as opposed to him or him? I mean, that's really what they're going to do. And they're going to focus on that fact, because if you're not sure beyond a reasonable doubt that it's Segura, you cannot convict. Do you think it might have been somebody involved with this drug ring or any of that? So that's going to be a very strong argument for the defense.
I think that one of the things that's really important to point out here is, we do a lot of talking about what it means to prove something beyond a reasonable doubt. That it doesn't mean you can't have any doubts at all, but essentially, like, what does that standard of proof mean? But in this case, where you have evidence put forward or an argument put forward that in fact it was another person who committed the crime because he specifically said he did it or that he ordered it. In order to find that the prosecution did meet their burden and prove the case beyond a reasonable doubt, it would require the jury to look at this information about Santos and the drug cartel and say it is totally not credible. Like, there's no way that it could possibly be true, which is a lot. It's not saying, I kind of think the guy's lying or he might be lying. It's saying, there's no way this guy could be telling the truth, which I think is really asking the jury for a lot.
Oh, I definitely agree, especially when we look back. Now we've seen the prosecution's case. We know what their sticking points. We know what that is. We know that in the interrogation, Segura was not truthful. They kind of caught him in that about his location on the day of the murder. He was in the vicinity, so okay, he was somewhere nearby. That's number one. Number two, we know this ex-girlfriend, he asked for a gun, wouldn't tell her why, said he was angry. That's piece number 2. We know number 3, he gets into a fight with the victim about this child support beforehand, and he owes this $20,000. That's the case.
Yeah,
that's the prosecution's case. So, I forgot to mention some of the testimony from yesterday that we were covering was the cellmate. That's also a critical piece of the testimony, who said that
yes.
Segura was actually creating raps about these murders, that he was rapping about it in his cell. We don't know about the credibility. His credibility, a little sketchy. Apparently, he's been trying to cut a lot of deals to get sentence reductions. But that's really what the prosecution's case is, and it's a little bit thin, especially in the face of the involvement in a drug ring with gang-related activity. I mean, that is going to shake the jurors to their core. So the defense has an interesting case, and I'm looking forward to seeing how it plays out in the courtroom.
I really think that you know, in many criminal cases, we see the defense bringing up things that might have happened, but it is not the typical situation that you see a defense built around other facts that have nothing to do with the defendant, where there's a real likelihood that could be what happened. And I think when you factor in the drug cartel is real, Santos really was involved with that drug cartel. The victim really was involved with the drug running. You have the nature of the crime suggests drug cartel just because of the way it happened, and the children in the bathtub, so horrific. It really screams drug ring, drug cartel. So when you put that together, you know, maybe things didn't happen exactly the way Santos is saying it did, but I think that I could easily see a jury saying, yeah, that really does seem like what happened. And even if Santos's account is not exactly what happened, neither is the prosecution's account exactly what happened. And that's really all they need to do. I mean, so we'll see. Either way, I think this is a case, more so than many others, that is going to really turn on how the defense's alternative theory plays.
Definitely.
So
I think you're right, and the jury will assess the credibility. I mean, you got a lot of witnesses with a lot of credibility issues, but you've got them on both sides.
Yeah.
So that's really kind of evens out the playing field as far as credibility.
Yeah, it makes me think, you know, I wonder, is the jury going to eventually take this as just sort of like a scale? Like on one side, we have the defendant rapping to his cellmate that he committed the crime.
Right.
On the other hand, we have some other guy in jail saying he did it. What do we do with this? Which one seems more credible? Which one seems more likely? It's pretty dramatic.
Absolutely. And the defense, they are going to focus so much. You don't have to believe that Santos was the one that ordered this hit. You don't have to believe that it was this other guy who their DNA traces at the murder site. All you got to do is think, I don't really know. I can't be confident beyond a reasonable doubt that it was Segura. So that's going to be their sticking point there.
Yeah, we'll see. So what I'd like to do, Misty, is we're going to go now, and as we have this nice little buffer of time for the rest of today to get ready for what I know is going to be a show-stopping defense starting tomorrow. So I want to go back, look at the defense's opening statements, and see what is that roadmap that the defense has laid out for us. What is the defense promising to show the jury, so that when the defense actually starts doing it, we can say, did they do what they said they were going to do? Did they make good on those promises or not? Don't forget, we're also waiting for a 1:00 p.m. hearing about Santos. This is the drug lord who is he's confessing that he was the one, in fact, who ordered this hit from prison. So there is an evidentiary hearing going on. The judge has made one ruling about that. We're going to hear more about what he can testify to, what his pleading the Fifth Amendment may or may not mean, because he admitted it, then he said he didn't want to admit it in court because he was opening himself up to liability. We don't really know exactly where that's going yet because we're not sure which testimony will be allowed, but it's bound to be exciting. So we will report in on that as we hear that, as that hearing happens, as we hear the judge's ruling. But in the meantime, we're just going to kind of get oriented about what it is that we were promised, so that when we see it, we know if it really misses the mark or if it really hits its target. So Misty will be back with you. I'm going to sign off now. Rachel Stockman, editor of LawNewz, will be in with you hosting the next segment. And you're in capable hands with Misty and Rachel. Here you go. I want you to take a look at these defense opening statements in Florida versus Henry Segura.
Everybody be seated. You may proceed, Mr. Fred.
The crimes are absolutely unspeakable. Horrific. I have seen some of the worst autopsy photos and crime scene photos you can imagine. None of those hit you in your soul like the pictures you will see in this case, like the testimony you will hear in this case. What I'm going to ask you to do is what you said you would do in jury selection, which is respect the presumption of innocence. And I don't mean just sit there and wait for the state to prove the case. I'm going to do something to help you. Of course, right? Of course. I'll show you DNA because I have DNA. I'll show you forensic evidence because we have forensic evidence. I'll show you step by step by step where Mr. Seura was throughout the day, and I won't ask you to draw any conclusions. They're not totally supported by the evidence that you hear. This case is a terrible tragedy. But tragedy is compounded where more innocent people suffer. And so to prevent that, let me just ask you from the outset to remember your oaths and remember the instructions regarding the presumption of innocence that the judge gave you. I have a lot of evidence that I'm going to present to you during the course of the trial, all different kinds. I just mentioned some. As I sat there last night pondering what the heart of the defense is in this case, it isn't the forensics. It's not the DNA. It's the heart of the man sitting at the table with the defense team. My oath to you is that I will not ask you to step over bodies on the way to a not guilty verdict without showing you, with evidence, a window to that soul. That isn't fair to you. I know. Burden of proof, it's their burden, solely and exclusively. I know. 3 dead babies. I know that too. We're all people in this courtroom. I know that too. So while I, at one instance, ask you to follow the law, I'm not going to just hang it on you and say, oh, follow the law, ignore the facts. I will show you who he is. You'll know who he is, as I know who he is by the end of this trial. But of course, the forensic evidence and DNA and all that kind of stuff is important too. So let me tell you about the conclusions that both the defense DNA expert and the state's DNA expert drew upon review of the DNA evidence in this case. Over 200 DNA samples were collected from around the murder scene in this case, from places relevant to the investigation, relevant to the murders. Henry Seura was not included as a contributor to a single evidentiary exhibit. In fact, he was excluded, meaning eliminated as a possible contributor for most of them. Consensus from Joe Ellen Brown, the FDLE analyst who did the initial work on this case, did it blind without having any idea who the suspect was, what the state's theory of prosecution would be, who the suspects were for the investigating agency. Those were her determinations. The defense expert, years down the road, came in, looked at the same electropherograms, which are charts that you'll see during the course of the trial that are essentially the paper printout of what a DNA profile looks like. She reviewed those, the defense DNA expert reviewed those, and drew the same conclusions. Henry Seura is not included in anything. Henry Seura is excluded from virtually all of the DNA samples collected. But that's not all. Other people were found to have contributed DNA. People outside the victim's family. People outside the victim's group of friends. Angel Antonio Avila Quinones. The phone that was ripped out of the wall. Phone cord ripped in half. His DNA was found on that phone cord, on that phone cradle. The defense DNA expert looked at the evidentiary sample, looked at the DNA chart, the electropherogram, for the swab of that phone. He compared it to the DNA profile for Mr. Avila. He was able to do what they call inclusion statistics. Rather than saying, you know, it's a 99.9% match, that's not what the DNA experts say. They do it in terms of rate of inclusion, or frequency of occurrence. What frequency of occurrence means is you would expect to see this particular DNA profile occur this many times within a given population. In this case, the rate of occurrence, or frequency of occurrence, was 1 in every 15,000 Latins. Mr. Avila is Latin. It occurs 1 time in every 15,000 Latins. 1 person would be included. That means, he'll tell you, the opposite, 14,999 people out of 15,000 would be excluded, eliminated as possible contributors, and could not have contributed to that DNA because they don't have those DNA numbers at those DNA markers. Math is simple. 99.95% of the population of the Latin people on this planet are eliminated from being a possible contributor to that DNA mixture. But Angel Antonio Avila Quinones was included. He wasn't the only person who they found evidence relating to, though. It was obvious, and you'll see pictures of this, it was obvious Brandy Peters fought heroically for her children's lives. It's true. It's true that she was beaten to death with multiple different objects and suffered horrible wounds. But she continued to fight until life left her body. Her fingers are broken. Her acrylic nails ripped from her hand. Her knuckles bruised and cut and swollen. There was DNA under her fingernails. Under Brandy's right index fingernail, foreign female DNA, I always say foreign, that means not her DNA, was found. Not her daughter's, not anybody else around the house who she's friends with or family with. Under her right pinky fingernail, foreign female DNA. Under her left index fingernail, foreign female DNA. Under her left middle fingernail, foreign female DNA. There was also a shovel located right next to Brandy's body in the foyer. Upon the shovel, Joellen Brown discovered foreign male DNA. Henry Segura is excluded as a possible contributor to the foreign male DNA on the shovel found right next to her body. The crime scene forensics also proved definitively that multiple people were involved in the commission of the offense. There were 4 separate sets of footprints in the blood in this case. Footprints that did not belong to the victims and did not belong to law enforcement. Victim Peters suffered wounds from multiple different types of objects, sharp and blunt. At least 2, plus the gun. The forensic evidence further proves that one of the victims, Tanaya, was held up by one person and shot by another. The way that we know that is that, number one, there's no saturation of her blood on the floor, meaning once she was shot, her body never hit the ground. Secondly, there's something called stippling on the back of her head. What that means is that the gun that shoots her has to be within roughly 3 feet of her head at the time she's shot. What we don't see, however, is soot deposit, which means that the gun has to be at least a foot away from her head. So if it was one person, he'd have to be holding her like this with the gun way back here and then hold her up after she's shot. I suppose someone could make that argument, but you won't hear me make that argument. In addition to that, we have, as I mentioned before, foreign DNA at different locations on different objects from different people. Again, consistent with the notion that multiple people were involved in the commission of the offense. And then we have the type of evidence that we talked about in jury selection, circumstantial evidence. One of the types of circumstantial evidence that we asked to consider here is evidence you should know about the motive the state's asserting here. It's true Mr. Segura did have a back child support judgment against him. He was going to be asked to pay $700 and some odd a month. It's also true that he was a little bit behind at the time. He was a little strapped for cash. He'd been injured and wasn't able to work like he normally did. But it didn't take him that long to get back on his feet. By the time he was arrested up in Minnesota, he was on a job where he was making $10,000 a month. Now, I'll tell you, Mr. Seura doesn't report all of his income. Sometimes he gets paid partially under the table. Sometimes he gets paid totally under the table. But he had no shortage of cash under normal circumstances. His wife, Malika, or now ex-wife, Malika, will tell you Henry would routinely spend $700, $800, $900, $1,000 a month fixing up the old cars that he worked on at his house. Another thing that you will be asked to consider, and you'll hear evidence about pertaining to his child support debt, is that he actually helped facilitate institution of that child support debt. He went twice on 2 separate occasions, because they lost paperwork once, to the DFS office on North Monroe Street and provided paperwork to help push that process along, move it along, so that he didn't have to keep having the victim ask him for cash as opposed to just paying through DFS. Another thing that you'll hear testimony about is that Mr. Seura had been through the child support process before and knew exactly how to deal with it. One of his child's mothers, and he does have children out of wedlock, Tamika Steele Hawkins, Clark, I guess she's now married, Clark, will testify on his behalf at this trial. She went further than victim Peters had ever gotten with her child support dispute with the defendant. She actually had him at one point, several years ago, many years ago now, thrown in jail. But he got out, he went to court, he got the child support judgment reduced because, as in this case, Ms. Hawkins waited until her child was a few years old to go have paternity established. And when that happens, a large back child support judgment hits. Mr. Seura went to court. He explained to the judge he'd been buying items and providing cash all throughout the child's life at different intervals. And the judge reduced the judgment, and he never got put back in jail after that. He knew how to do it. That's all he had to do in this case. And that's what he would have done in this case, because he had been making cash payments at irregular intervals during Javante's lifetime. He simply didn't have time to do that before he was killed. The other thing that you'll hear testimony about and be asked to consider in the context of thinking about the motive the state has put before you is that it wasn't just Brandy that was killed. Javante is Mr. Segura's son. The 2 little girls that were killed lived with him. He and Brandy, during a time when Malika Seura and Henry Seura were going through a rough patch, Brandy was one of Mr. Segura's girlfriends. And he lived with her for a while. Those little girls called him Daddy. He took them to school. He helped potty train. Ask yourself, in the context of motive consideration, as you hear the evidence, whether slaughtering those 3 children could possibly have anything to do with child support. Another important piece of circumstantial evidence relates to the time of death. You've seen the cell phone data.
And welcome back, everybody, to the LawNewz Network. I'm your host this afternoon, Rachel Stockman, also editor-in-chief of LawNewz.com, where we've been following many of the cases that you're watching right here on the LawNewz Network. I'm joined by a fellow host and also a guest and contributor, Misty Maris. She's been with us this morning with Allura, and you're going to stick with us a little bit longer. And I think it's going to get really interesting, so I'm glad you're sticking around.
Definitely. I can't stop watching the Seura trial. It's really getting so interesting. There's so many twists and turns here. So,
you know, when we, as trial watchers and as people that plan what you all are going to watch here on the LawNewz Network, we look for cases that are like this because it's not really a clear whodunit. There's so many different people involved in this. There's so many different theories of what happened. There's not really clear evidentiary evidence, DNA evidence linking Henry Seura to the crime. You've got this gangbanger that claims he ordered this hit. There's so many elements to this. And in about 35 minutes, there's a really important hearing coming up that we're hoping to carry live here. Misty, can you tell us a little bit what we think we might expect? We don't know exactly.
Right, we're not exactly sure, but this all relates to the testimony of Santos. Now, this is this gang leader who from behind bars said, I'm the one that ordered the hit on the victim and her children. I mean, this is quite the twist. So in a pretrial hearing, he testified. He testified to that fact that he was the one that ordered the hit. Now, Rachel, you have to remember, in prior statements and testimony, his story shifted. It changed a little bit to what came out at the pretrial hearing. But the judge made an evidentiary decision before the trial started that some of his testimony from that pretrial hearing was going to come in. And that's the how and the why about this alleged hit that was put out on the victim. So now we have Santos, who's set to testify, and swoops in defense lawyer extraordinaire saying, whoa, 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 you're probably going to want to plead the fifth. You're admitting to a murder now.
So what, it's kind of unclear what his motive was for all. There's two reasons. He could be telling the truth and he really did order this hit behind bars, or he was, I mean, what else could be his motivation for wanting to admit to this?
Well,
it's so strange.
You're right, and that's a great question, and that's probably what the defense will focus on. They're going to say, why would you ever say you committed a murder that you did not commit? Why would you possibly do that? But interestingly enough, in this guy's past, the prosecution has some dirt on him, and that's that he's actually claimed responsibility for 2 other murders that ended up not being related to him. So they're obviously going to bring that up. So I think what you have to remember is, and this is something that I'm sure the prosecution will focus on, that the culture of a drug cartel, the culture of a gang is a little bit different. There's a sense of some boasting or some actual wanting to take, I mean, most of us don't want to be held accountable for the death of another person, but that's a little different in this gang prison environment that we're talking about right now. So that's going to be an interesting fact. And I think probably a big part of this evidentiary hearing today will be how much of these incidents from the past are they going to be able to use in response to the testimony being introduced into Santos's testimony, and also the bounds of his Fifth Amendment right.
Right, because he can't just go on the stand and say, I plead the fifth, I plead the fifth, I plead the fifth to everything, presumably, right, Misty?
Presumably, that's limited to anything that would be incriminating. So that's what your Fifth Amendment right is. It's your right against self-incrimination. So something like, is your name Rachel Stockman? I mean, I don't think that's incriminating, Rachel. I mean, like, here's hoping that it's not. So
I know of.
Exactly. So, I mean, those are the types of questions, and the judge is probably going to be setting those parameters at today's evidentiary hearing, because we do know that some of that testimony is coming in. But this is kind of a complicated legal issue from an evidentiary perspective.
Very, but this guy really could be a key witness for the defense if, presuming they're able to get as much possible of his previous testimony before the jurors, because this puts in front of the jurors a whole new theory of who killed the victims.
Yes, and you know that the defense is not under an obligation to set forth alternative
theories.
But it
helps when they do.
Oh, it helps exponentially, because you have the jurors sitting there in their mind, all right, well, if he didn't do it, who did?
So then you have a circumstantial case and someone else that took the stand that confessed, basically.
And think about what this testimony is going to be. So what we know is the judge said the fact that he said there's a hit on this person, the how he delivered that hit, and the why. So when you're talking about the why, he's presumably the testimony is going to say that she was a drug runner, that she stole $90,000 skimmed off the top, and that he ordered the hit from his prison cell, and he said these words. I mean, it's a story that you can believe from a jury perspective, that if you're involved in a drug cartel and you take money from the people involved in that drug cartel, you take money from the leaders, there could be consequences.
Okay, so as we're waiting for this hearing to start in about a half an hour, we'll stream it live here on the LawNewz Network. I wanted to take us back to some other interesting testimony, which also involves an inmate in prison who says he heard something in prison. And this is the testimony of Kelsey Kennard, who basically said he heard Seura rapping, bragging about the killing. So let's take a listen, and then Misty and I, and we love the viewers to weigh in about the credibility of this witness and whether we believe him. So let's take a listen to some of his testimony.
Was anybody else around when he did those raps?
He had several homeboys there that I also told him not to talk to his case about. but I can't, like, it's been a little while ago. It was 2 other dudes there from Florida at that point, and I can't remember their names or nothing, though.
Okay. And so the 2 people who would have been able to corroborate your story about what Mr. Segura said, you never provided that information to law enforcement?
No, I didn't.
And likewise, the written rap that you say would have corroborated what he was saying about these offenses, you sent that off to his wife and also didn't provide that to law enforcement?
I think in my original letter I did. I told them that, because I wrote the courthouse, I told them that they can check my call log, because I not only sent letters to his house, I spoke to his wife. If you go back to 2011, you can see his phone numbers on my list, where I called her several times for him and spoke with her while he was there and after he left.
My question is, you sent the rap that you claim he wrote to his wife, not to law enforcement, correct?
Yes, that's what he asked me to do with it, because he had other mail in there too.
And so all of the corroborative evidence that could have supported what you were saying, the other witnesses' names and the rap, is gone, right?
I sent it to his wife.
My question is, that evidence is gone.
I sent it to his wife.
Okay? And likewise didn't provide law enforcement with the names of people who could have corroborated your story. Is that true?
I sent it to his wife.
Besides the time you've already told us about, when you got a 2-year sentence reduction, has either cooperated with the government or attempted to cooperate with the government to get a sentence reduction for yourself in the past?
Well, I never, his situation, I never ran across nobody like that. But yes, I have cooperated with the government on a high level, and it's never been a doubt about my cooperation.
So you're somebody who's eager to cooperate with the government?
No, I'm not eager, but again, my plea agreement stated that if I have criminal activity knowledge, I must turn it over.
Okay, so over what period of time have you been cooperating with the government, providing information to them about criminal offenses?
Oh, several years now on several cases.
How many cases?
If I can remember correctly, like 3, 4, maybe.
Okay. Been to court to testify in those cases?
Yes.
Okay. Is that why you got the sentence reduction? You came to court and testified against the defendant in that other case?
Yes, sir.
Okay.
Well, he actually pleaded out, though. Once he seen they had me, he actually pleaded out.
How many times have you attempted to provide assistance to the government, meaning reach out and contact, or have your attorney reach out and contact somebody from the government to tell, hey, I've got information about another case for you?
Again, in the federal system, it works different. Once you turn the information over, it might be an ongoing case that they may don't even use you because they might have enough people already, and then it could take years on down the line. So it could take maybe 10 years just to build this case on this certain individual. So it's probably still ongoing cases that I gave information on that they just haven't used me for yet.
My question is, how many times have you either provided information or attempted to provide information?
I can't give you an accurate number on that. It was several cases.
More than 10?
No.
You don't know how many times you've attempted to provide information?
No.
How many times you've provided information that hasn't come to fruition in the form of a motion for substantial assistance?
I can't give you an accurate number on that.
Isn't it true, Mr. Kennard, that the reason you said Mr. Segura shouldn't talk to you about what he was accused of doing, what he was alleged to do, is because you're somebody who takes information like that and uses it to try and put yourself in a better position with respect to sentencing?
No, I just give the government the truth.
No further questions.
And welcome back, everybody, to the Law News Network. I'm your host this afternoon, Rachel Stockman. I'm alongside Misty Maris, who's also a host here at the Law News Network, and she's our guest today. We love having her as a guest. And also Kathy Russin, who is our senior trial producer, is on the line. She's joining us via Skype. And I was just telling Misty, we have such an asset in Kathy because she knows these cases backwards and forwards, every little detail, right, Kathy?
Well, now you're going to put me on the spot when I don't know something.
So I want to get your take first, Kathy. We were just listening to a clip from Kelsey Kennard, who was, I guess you could call him the jailhouse snitch. What do you make of his testimony? Do you believe him?
Okay, so I don't fully believe him. He was a cellmate for like a week with Segura, and in Oklahoma. But his story's so bizarre that it's almost believable. He says that Segura did a rap song confessing, and in the rap song he was talking about how he killed them. So we were talking in the chat room while this was going on about his credibility, and we kind of decided that he could have easily known some of the details he told law enforcement from news reports, because he claims Segura told him how he shot 2 of the people and drowned 2 of the kids, and they were stacked in the bathtub, and it sounded kind of rehearsed, and maybe he had read that. However, there was one point in what he said that struck me as believable, and he said that Segura told him that he'd gone to his girlfriend or ex-girlfriend earlier in the week of the murders and asked her, now the inmate said, and asked her to buy him a gun. Who said that Segura came to her like 2 or 3 days before the murders and asked to borrow her gun that she owned.
Right.
And he was furious. Now, for me, that was one little detail that I don't know the inmate would have gotten that from anywhere else, because we just heard that at trial.
Let me ask you this, Misty, from an attorney's perspective, how much impact do jailhouse snitches have on jurors? In other words, are they overall believed or not?
Here's the big issue when you have a jailhouse snitch. Rarely do you have somebody coming to the table to snitch without some sort of self-interest in mind. Very often, as in this case, you have someone who, guess what, has tried to cut deals at other times because they want sentence reductions, because they're looking for some sort of benefit for working with law enforcement, for testifying against somebody else at trial. So there's always this just cloud over these people because they generally have a self-interested motive. On the other hand, what they really are going to say, though, from a prosecution perspective, is that very often people do share their war stories behind bars. So there is some element of, there's definitely communication on that front.
Kathy, sorry, you were about to say something. Continue.
That came out in cross, that he is a jailhouse snitch, that he's done this numerous times. He shared cells with and reported on them. And that doing it for a sentence. So that did come out under cross.
Yeah, and I think that's a major problem when you have a jailhouse snitch. And again, this is a circumstantial case. So he is one of the prosecution's kind of main witnesses connecting Henry Segura to the crime.
Yeah, not a great person to have all your eggs in that basket in this context, because there is that element of self-interest. Let's think back to the Hernandez case just for a minute. We had a lot of witnesses who would cut deals. They had this self-interested perspective, and that does impact the jury, because they say, especially with this guy in this case, he's done this before.
Exactly. So we are standing by. We're expecting a hearing, and they never do start on time, so I hate even saying exactly when it's supposed to start, but it's supposed to start at 1 o'clock. And this is a hearing, an evidentiary hearing, so that means the jurors are not going to be there. They've been dismissed for the day, and the defense is going to start their case tomorrow. Kathy, any idea, I mean, could we see Mr. Santos potentially take the stand again? Or do you think this is going to be just a quick legal type of argument between the attorneys?
Yeah, I know he's being brought to the courthouse, or he's already there, but earlier in the week they talked about him being brought there. So he's supposed to be in the courtroom. And this was all, a week ago, that he was all ready to testify, and he was going to say exactly what he did, and that he's the one that did this, and it wasn't Segura. And then, like Monday of this week, his lawyer sent an email to the prosecution saying that he has decided not to testify and that he will plead the fifth. Now, that's at court, that's at trial. I don't know if he'll be made to say anything at the evidentiary hearing today. I don't know that he can be forced to say anything, but he has spoken under oath before. So that's why we're really interested in this hearing at 1 o'clock to see what is going to happen with Santos's statements he's made.
Do you think it matters, Misty, if he pleads the fifth during the trial when the defense brings him up to the stand? In other words, if they're able to get into evidence his prior statements that he made under oath, does it really even matter that he pleads the fifth in terms of the defense's case?
I really don't think it does. I think the moment, the mic drop moment for the defense here is getting that prior sworn testimony in. Because it's prior sworn testimony, that was done under oath. So if he were to testify, the purpose of that testimony would be to impeach his credibility. If perhaps his story differed or whatnot, they could use that. If he's not going to and he's going to plead the fifth, all they got to do is get that transcript in, those salacious parts of the transcript talking about this hit. And that's really going to do everything the defense needs.
And we were looking over what the ruling was by the judge in terms of what evidence or what testimony of Mr. Santos can be admitted. And it seems like the crux of what the jurors would need to hear to be convinced perhaps of his story will be allowed in. What the judge is not allowing in is kind of hearsay evidence of what happened after the fact. He just testifies to the fact, I ordered this hit, here's who I told, here's when I did it, and that's enough,
right?
Really.
The how and the why. And I think in this particular case, the why matters almost more than the how. So meaning that he's going to testify, I sent this directive to XYZ to facilitate this hit. Well, the why matters a lot because the why is the victim was involved in this drug ring and she stole money from a drug cartel. That has a lot of impact on the jury.
And to my knowledge, Kathy, have the jurors heard this alternate theory that she was involved in this seedy drug world at all? Do we know that yet?
No. Okay, no, but here's the thing. So when it comes to Santos's statements, the judge would not allow either side to mention, well, obviously the state's not going to, but wouldn't allow them to, the defense to mention Santos in their opening statements pending this hearing. So nothing has come out about him, and they weren't even allowed to try and present it during openings as an alternative theory about Santos. Now, what has come out was with DNA was that there was a DNA hit to a Colombian drug trafficker. Now, and that's what the jury has heard so far. It's just that much. What we know is that Colombian drug trafficker, which I can never remember his name, is who Santos says he hired.
Okay, so as far as we know, up until this point, this alternative theory could be quite shocking to the jurors who are writing this story based on the prosecution's theory of some circumstantial evidence linking him to the scene of the crime at the home that day.
Oh my gosh, this is going to be a huge moment for the jury to hear this. And almost, of course, the prosecution would do everything they can to keep this information out to the extent possible, but it's almost going to have more of an impact, in my view, midway through the trial like this. It would almost be better if it had been mentioned during the defense opening, and then it can be chipped away at just like every other theory is.
See, that makes me wonder, Kathy and Misty, if perhaps the prosecution is going to make another move to totally exclude Mr. Santos' testimony altogether. I assume they will, because that would greatly boost their case, but the fact that they got the judge to agree not to allow it into openings, and now we have this hearing, who knows what's going to happen, right?
Yes, absolutely, and who knows how severely limited. It was already limited pretty significantly as to what is going to come out from that transcript. Could it be limited more? I don't see the judge leaving this out in its entirety, though, because this could be exculpatory evidence. I mean, this could really be a serious, another person that could have committed this crime, and a jury should really hear that. That's my defense attorney hat.
There you go. And I'm going to let Kathy go, because if we don't let her go, we might not know what's going on in all the trials and whether things have started back up in court, and she needs to let us know while we're on air. Thank you, Kathy, for joining us and kind of giving us some of insight, especially when it has to do with Mr. Santos. I want to go back to another witness that Kathy touched very briefly, Tyra Wilkinson. I'm not sure if I'm pronouncing her name right, but she was the ex of the defendant, and she's the one that testified to him wanting a gun and how he acted the days after the murder. Let's take a listen to some of her testimony, and then Misty and I will chat. If during her testimony that you're hearing replayed, we go live back in court. We'll cut out of that and go right live, of course, like we always do. Let's take a listen, though.
Okay, and how long did you live in Tallahassee at that point?
I'd say since and forever. I was here off and on, say about 10 years.
Okay, so you would have been living here around 2010, November 2010?
Yes.
Okay. When you lived here, did you know Henry Seura?
Yes.
Okay, and how was it you knew Mr. Seura?
When I first met him, or how long?
Yeah.
Oh, I first met him in the neighborhood when I was in middle school.
Okay. At some point, did you and Mr. Seura kind of start dating a little bit or something along those lines?
Yes.
Okay. And it's my understanding you went on a trip with him over to Savannah?
Yes.
And that ended badly?
Yes.
Was that the last time you and Mr. Seura were together, I guess?
No.
Okay. So y'all made up after that and started talking some more?
Yes.
Okay. Whenever you talked to him, did you talk to him regularly on the phone?
Yes.
Okay. Did you know him to have more than one phone number?
Yes.
Do you remember what those phone numbers were?
No.
Okay. If I told you one of them started with a 509, would that sound right?
Yes.
Okay. And another one was a 408-8669?
Yes.
Okay. Now, which one of those, the 509 or the 408 number, would have been his regular number, I guess, if you will?
I guess the 509.
Okay. And then, did you have any conversations with him on that 408-8669 number?
Yes.
Okay. Was he using that number around the time of the murders? You know why you're here, right?
Yes. He got that phone when I was with him, I think, because he told me to call him on that one because his girlfriend be checking a bill or something.
Okay. Now, but he continued to use it? Did he continue to use it after that?
After.
Did you call him on that phone? Did you call him on that 408-8669
Oh, yes.
phone? Okay. At some point after the murders, did he tell you he got rid of that phone?
He told me don't call him on that one no more. He said he got rid of it.
Okay. About how long after the murders did that happen?
Immediately after the murders, because I didn't know about the murder, but he told me call me on the other phone. He said he'll call me from a different phone.
You never learned of the murders?
On Tuesday morning, I learned of it.
Okay. And at that point on that Tuesday, had he told you already that he was going to get rid of that, to not call him on that 408 number?
He
or
told
was it
me
afterwards?
No, it was probably
If you don't remember, that's fair enough.
probably like that day before, like a Monday or something. It was like probably the day before or something.
Okay, so the day before you found out about the murders, you found about the murders on Tuesday, and then the day before he told you don't ever call him on that 408 number again.
Yeah.
Okay. Prior to, if I told you the murders happened, I know you found out on Tuesday, but if I told you the murders happened the previous Friday, on November the 19th. So the Friday before the Tuesday, you found out on Tuesday, the immediate Friday before is when the murders would have happened. Does that sound about right? Maybe.
Repeat that. I'm lost.
My understanding is you found out about the murders on the Tuesday. That's when you found out about it, correct?
Correct.
Okay. Did you find out the murders actually happened the Friday before that is when it actually occurred?
I don't know when the murders. I was in Orlando. I don't know when it happened.
Okay, what were you doing in Orlando?
I was there for the Classic weekend for
Florida A&M football game?
Yes.
Okay. Prior to that weekend, did Mr. Seura ever come and talk to you about getting a gun?
Yes.
What did he say?
He asked about my gun, and I told him that can't happen. He asked to use mine.
Okay. When was that?
That was when I was home getting ready to. I was getting myself in my apartment ready to go to the game.
Okay, so you're talking about right before that weekend.
Right before that weekend.
When did you leave to go to the game?
I think I left Friday morning.
Okay. So just before Friday morning, you're getting ready. So basically Thursday night, was that when you were getting ready?
I think Tuesday or Wednesday.
Okay.
It was like in the evening, like Wednesday or Tuesday. I'm not sure exactly which day it was.
So Tuesday or Wednesday before you go to the football game is when he asked you about borrowing your gun?
He popped up. He popped up. He was red and balled up. And I was trying to ask him what's wrong, but he never said what was wrong with him. He didn't say why he was. I never seen nobody that mad. He was just real mad. And I didn't know why he was mad. He never said why he was mad.
So you saw him in person then? It wasn't on
Yeah, I
the
saw him in person. He popped up.
Ms. Coxon, you got you've been convicted of 2 petty thefts, as I understand it.
I remember one, but yes.
Okay.
Yes, I was.
All right. That change anything about your testimony today?
No.
So on the Tuesday or Wednesday, you meet with him. He's angry. I think you described him as balled up. What did you describe him as? You said he was angry. I think you said something like balled up. Or...
Oh, yeah, he was real red and intense and mad. He was just mad.
Did he tell you what he was mad at?
He didn't never say what he was mad about.
Okay. When he talked about the gun, what did he say specifically? Do you remember?
He didn't talk about it. He just asked me to use mine, and I told him if I find something, because I thought somebody was probably messing with him, and I said, if I find something, I'll let you know, like a throwaway gun or something. You don't want to use nobody's gun if you're going to do something crazy, if it's not yours.
Okay. So you had a gun.
Oh, yeah.
And you said, no, I'm not going to give him yours, but you said if you ever found one, you let him borrow that.
Yeah, if I find out anything,
okay.
Let him know about it.
Mr. Segura that we've been talking about, do you see him here in the courtroom today?
Yes.
Can you please point to him and indicate the color of clothing he's wearing, please?
Blue and yellow. Blue and yellow shirt.
May the record please reflect she's indicated the defendant, Mr. Segura. All right, thank you.
Cross. Your Honor, may we approach there, please? All right.
And welcome back, everybody, to the Law News Network. I'm your host for this afternoon, Rachel Stockman, also editor-in-chief of LawNewz.com. As I always do, want to put a little plug into our website where we stream the network. Also has many articles on trials going on across the country, even ones that we're not broadcasting right here on the network. I'm joined by my guest who's been here all morning and into the afternoon, Misty Maris, who's also a host here at the Law News Network, and she's performing the function of guest and giving us some of her incredible insight on what's happened. We just heard from Tyra Wilkinson, and we're going to hear more of her testimony. Why do you think the prosecution brought her as a witness? I didn't find her testimony all that compelling. Yes, so what, he asked for a gun, so what, he was a little disheveled after the murders. I mean, one of his children had also just died. So what did she add to their case? The fact he wanted a gun?
Yeah, I think that she was not a great witness for the prosecution. She didn't really add too much, as you said. But let's not forget, the prosecution's case is kind of thin.
Right.
And the fact that he asked for a gun is one of the, 4 or 5 major points that they're trying to hammer home in order to get him on circumstantial evidence. So they almost needed her to have this weapon, to show this demeanor and all that, despite the fact that she wasn't really that great at the end of the day. In this case, she was necessary.
So basically it's the pile-on strategy. If we have enough little pieces, maybe they'll believe our story. So I was making a list here really quickly of the prosecution's case, the pieces that they're pointing to. So they have the potential motive that they're trying to put forth about the back child support payments. They have these gloves found in his car, Henry Segura's car. They have the testimony from Tyra Wilkinson claiming that he asked for a gun and was acting weird in the days after the murders. What else am I missing? What else do they have in terms of sealing this case up?
It's funny because I have
You have a list
the same
too?
list. Yes, I've been making this list because as this trial goes forward, I keep thinking to myself, where's the evidence? So you're right, the things you named are true. I think another big piece for the prosecution was that interrogation interview of Segura, where he was caught a little bit at being untruthful. The focus on that cell phone. Do you have one cell phone? Do you have
Right,
two
the cell phone
phones?
records. I'm sorry, that is a major piece of evidence.
And we know because
that the prosecution
we spent
has.
days. We spent days
Right.
laying the foundation and going through the cell phone records, placing him in the vicinity, giving him, the motive, the opportunity, and the ability. So, I mean, that's really what the prosecution's focused on. But what you just said, that's really the crux of their case, and the jailhouse snitch. I mean, those are the...
Let me write that down.
Yeah, write that down. Make sure it gets on
Jailhouse
the list.
snitch.
I forgot the gloves. I'm going to write that down right here. But those are the key tenets of their case. Nothing directly linking him to these murders. Kind of a flimsy motive, I'd say, given that we know a little bit more about some of the victims' activities and some of the people the victim is associated with. And we heard in the defense opening statement, I think this is a really good point about the child support motive theory, this $20,000, that he had kind of worked the system before on that. I mean, rarely do you have your attorney want to come out and say that, but almost he wasn't really afraid of this $20,000. So they really needed this witness, the Tyra Wilkinson, to come out and talk about the fact that he asked for a gun and the fact that he was angry, to fuel that argument.
Absolutely. And again, if you're just joining us here on the Law News Network, it's about 1 o'clock Eastern Time, and we are expected, the court in Florida, the Henry Segura court, the case we're watching in Florida, to begin live any minute now, where we are going to have an evidentiary hearing outside of the presence of the jurors to weigh and discuss the testimony of one of the defense's key witnesses, Mr. James Santos, who actually has already testified in a preliminary hearing to the fact that he was the one that ordered the killings of this family. It's such a tragic story at its heart. The facts are horrible, with the deaths of 3 young children and this mother. Misty, will you stick around a little longer as we play more of the Tyra Wilkinson sound? She was, again, the ex of the defendant, and we were talking a bit about her testimony and why she was so crucial to the case. This is some of the cross-examination from the defense, where they're basically trying to chip away at her credibility.
On the phone a couple weeks ago. Remember, you were in Ohio?
Yes.
Okay, I just wanted to let you know I'm that guy.
Okay.
Have you ever been convicted of any felonies or crimes involving dishonesty or deceit?
I think we need to separate that question out, please, Mr. Gunner.
If it was, I apologize. Was it number 2?
It was a crime of dishonesty. We need to separate out the question, please.
Have you ever been convicted of a crime of dishonesty? And if so, how many? And
I'm not sure what you were asking me. I mean, the petty theft? Yes, I guess.
Have you ever been convicted of 2 petty thefts?
Yes.
Okay, thank you. Sorry, and I apologize if that had already been asked. Ms. Wilcoxon, back in 2010, in November of 2010, what was your phone number back then?
I couldn't tell you that. My number changes all the time.
All the time, but you're able to remember these numbers out of the air?
If you tell me if you say the number that was mine, I can tell you it was mine.
Honestly, I don't know it.
Okay.
I was hoping you would, since you had the memory about Henry's numbers with just the 509 or the 408.
Yeah, if you say one of my numbers that I had, I remember. But as far as just remembering them out the air, I can't do that.
Okay. But your testimony is that Mr. Segura used at least one of the phones that we've heard about to call you on more than one occasion. Correct?
Yes.
Okay. And it was either the 408 number or the 509 number?
No, he was using the 408 number. He wasn't using the main number anymore because of the phone bill.
Okay. But he had in the past used the 509
He
number?
did, but we was in Homicessa, Florida, and the wife kept calling about the bill and that he's still talking to me or something, but so he wasn't calling me on that one anymore.
Okay. Now, at the time, in November of 2010, you were living at 601 6th Street, correct?
And welcome back, everybody, to the Law News Network. Sorry to interrupt the testimony there, the tape testimony. We want to take you live to the Henry Segura case where there's an evidentiary hearing that's going on. Let's take a listen.
Is that correct, Mr. Santos?
Yes, sir.
Either side desire any further inquiry of that?
No, Mr. Pugh be back down in a second. No, not.
Say what?
Mr. Pugh be back down in a second. No, we would not require any further inquiry. No, sir.
All right. Mr. Santos can be returned to whatever authority he's supposed to be returned to. Thank you for being here, Ms. Diaz.
Thank you.
Y'all are excused.
Thank you.
All right, what is the defense contention at this point, Mr. Prince?
The defense contention, Your Honor, pursuant to case law provided, is that
if there is any evidence corroborating an out-of-court confession, even one which doesn't meet hearsay requirements or hearsay exception requirements, which I would submit this one does, under both the former testimony and statement against interest exception, given his unavailability, then the statement has to be admitted pursuant to United States v. Chambers and the defendant's Sixth Amendment right to present a defense. The critical question under the case law provided to the court is whether, like I said, there is any corroborative evidence for the confession, and I would suggest as well that there is evidence of that sort here. One of the pieces of corroborative evidence is the DNA. The court's already...
We don't need to get into argument
yes, sir.
At this point in time, but what I want to clarify, exactly what is it that you think should be admitted?
I would submit that the appropriate way to handle it would be to have a witness read from the transcript of the motion in limine hearing where Mr. Santos testified.
What was the date of that hearing?
The 27th.
What's that?
The 27th, sir.
July 27th?
Yes, sir.
So that's what it is you propose the court accept?
Yes, sir.
Okay. Is the state in agreement?
No, Your Honor, the state is not in agreement as to that, especially in its entirety. If the court does so rule that some of it is admissible, there's certainly a vast majority of that is inadmissible hearsay, attack on character of the victim, and things of that nature.
I wasn't asking for argument, Mr. Fuchs. Just confirming you object.
Oh, I'm sorry.
All right. Mr. Prince, you can present whatever evidence you think would assist the court in making this determination. But let me say one thing. You've mixed three legal theories together. They are separate and have separate criteria. Just mixing them all together is not very helpful. We have a due process argument under Chambers. I've obviously given this some thought. It would seem to me that your fourth criteria is going to be very difficult for you to overcome because the statement is not admissible if the witness is not available for cross-examination, as Mr. Santos is not, and there certainly is some question as to the credibility of that statement, but I think that's the major issue you're going to have to resolve. Admission against interest is a different, admission against penal interest is a different theory. It would appear to me that you're unable to meet that burden because that requires that the declarant be available for cross-examination, which Mr. Santos is not available for cross-examination, so I don't see any legal basis where that can apply. Former testimony requires that the other side have had the same motive for cross-examination. And I've raised these issues to say these are things you're going to have to deal with. Frankly, the court didn't give any thought to Mr. Santos not testifying during the course of that hearing, but the court specifically cut off the state's cross-examination in that case. Maybe in retrospect I should not have, but I did. Because they indicated the only issue before the court is the admissibility of the statement, and credibility was not something for the court's consideration at that point in time. So it seems to me it's going to be very difficult to establish that the state had full and fair cross-examination of that statement, which is what is required for the theory of former testimony. But I agree that there are a series of options of how this could be admitted. I just wanted to make sure let's not get sloppy and blurring the edges on those theories. So you wish to present testimony, Mr. Prince?
I do, Your Honor, and I'd ask for some direction as to how far afield the court wants me or prefers me to go in corroborating Santos' testimony. For example, I have witnesses available that help establish time of death. Of course, if the time of death is later at night when Mr. Seura is shown to be home, that would be corroborative of Santos' statement, but I know it doesn't bear directly on Mr. Santos exactly what he's saying. So I can present those witnesses if the court wants, if not.
I'll rely upon, and you can argue anything that's been presented during the trial so far. Seems that those type of things can be argued largely from the evidence that has been presented. But I think largely we need to focus on direct corroboration of Mr. Santos, and I assume the state will be focusing on basis to impeach that statement. So I don't think we need to get way far afield. But what testimony do you wish to present?
I would present the testimony of Dr. Jesus de la Cruz, Your Honor.
Okay. All right. You'd face the clerk and be sworn, please, sir.
Do you solemnly swear or affirm that the testimony you give in this case will be the truth, the whole truth, and nothing but the truth?
I do.
Your Honor, at this stage, I want to raise the issue that we did file a motion limine regarding his testimony.
Well, I'm going to have to hear the rule on it, so proceed, Mr. Prince.
Dr. Dela Cruz, can you please state your name and spell both your first and last name for the court reporter?
Jesse de la Cruz, Jesse, and capital DE, space, capital LA, space, capital CRUZ.
What do you do for a living?
What I do for a living?
Yes.
I'm a gang consultant.
Okay.
Primarily.
What does that mean exactly?
That means that I travel throughout the United States to testify on gang cases where the individual has been charged or there's an allegation concerning gangs.
Okay. So in criminal cases, you look at various aspects of the evidence in order to make a determination about whether there are indicia of gang relatedness. Is that right?
Correct.
Okay. Can you tell the court first about some of your real world or life experience that has qualified you to speak on those matters?
Well, to start, I was a gang member from a very young age. I got in a street gang at the age of 13 in Northern California. A few years later, when I moved to Los Angeles, I got in a street gang in Los Angeles. At the age of 21, I was sent to the penitentiary in California, and I joined a criminal organization, the Nuestra Familia, in 1973.
Did you have, during the part of your life when you were involved in organized crime, did the gangs or criminal organizations that you were involved in have interaction with Mexican cartels?
Absolutely.
Tell us a little bit about that.
Well, when guys were getting out of prison, from Nuestra Familia, they would go to Tijuana. At that time, the really only cartel at that time was the Felix brothers in Tijuana. Also a little guy named Toñito and Roberto, because the cartels were just evolving at that time. And we made the connection with them to sell drugs, to get drugs from them and sell them on the streets in Northern California.
Okay. What about criminal associates, friends, and family members with whom you had direct interaction? Were any of those people directly involved with or members of Mexican cartels?
Correct. Yes, I had a cousin, and I say had because he got shot by the military in February, I believe it was, in Reynosa, Tamaulipas. He was a member of the Zetas. He had just gotten out of the federal penitentiary, and I called him specifically about this case. And prior to his, having the shootout with the military police in Reynosa, Tamaulipas, where he was killed. In addition to that, I have two nephews that are currently connected with cartels, but they're connected with the Familia Michoacana cartels. One of them was kidnapped by the cartels, and we had to pay a $60,000 ransom because he owed them money, and they were going to kill him, but they liked him, so they just beat him up real bad and allowed us to pay the money so that they would release him, and which they did. We paid the money.
How was that ransom negotiated? Did you have any personal role in that?
No, I didn't have personal role in that particular transaction, but I did educate my sister on how to go about it, right? So my sister would call me and I would tell her what, tell him this, ask him this, make sure you do this and do that. And I also told her that she should prepare to move out of where she lived, because if they ended up killing him, they would probably end up killing them too.
The folks that you've told us about and the specific life experiences you've described, have you had opportunities over the course of your academic career to, I don't know, I would say it's formal as an interview, but question, discuss with these individuals their real life experience within and dealing with cartels?
Absolutely.
Okay. Now tell me a little bit about your academic background.
Well, in 1997, I enrolled in community college. I did the 2 years and transferred to Stanislaus State University in Turlock, California. I obtained a bachelor's in sociology. I went on at the same university and obtained a master's in social work with a specialty in deviance, which was, gangs and so forth and so on, and crime. And then I went to work, and I went back to school in 2010, and I obtained my doctorate in education in 2014.
Okay. And during the course of your doctoral studies, did you focus in part or in total on the interaction between cartels and American criminal street gangs?
Well, I studied gangs in general. My dissertation is on gangs, but initially, my dissertation is on gangs in Northern California. But initially, I was going to look at the differences and similarities between the Maras Salvatruchas and the cartels, the Nuestra Familia and the Mexican Mafia, the Aryan Brotherhood and the Black Guerrilla family, the Cambodians and the Vietnamese gangs, and the Norteños and Sureños. But when I spoke to my, about a year later, when I told my committee chairperson that what I was wanting to do, she said, that's too big of a task. You got to narrow it down. So I focused on Norteño street gangs.
Notwithstanding the specific focus of your dissertation, did you have opportunity over the course of your doctoral studies to look at all of the types of topics you just described in the context of organized crime as a whole?
I reviewed and read. I can't put a number on it. In my dissertation, I have like 15 pages of references that I reviewed, and books that I reviewed, and journals that I reviewed, and many different gangs and many different topics that relate to gangs.
Now, have you ever been qualified as an expert in court, either state or federal, to give opinions about whether particular facts or pieces of evidence are indicative of gang activity?
Yes, I have. I did a federal case, RICO case in Harrisburg, Pennsylvania. I did a Mara Salvatrucha case in Newark, New Jersey. I'm doing 2 cases. One's a death penalty case right now in Salt Lake City, Utah. I'm doing a case right now in New Mexico, the Mexican, the Nuevo Mexico Sindicato, which is a prison gang. I have been qualified in probably 15, 20 counties in the state of California, relating to many different types of gang, African Americans, Asians. I did one cartel case in Modesto, just many different cases, Sureños, Norteños, Asians, all of them.
How many cases have you testified in court for?
I've done approximately 33 to 35 jury trials where I've testified in front of a jury, and I've done probably 5, I think it was 5 preliminary hearings where I testified in front of the judge. I've testified in probably 7 or 8 evidentiary hearings, 402 hearings, as they call them in California. I don't know. I think they call them dauber motions in the federal court. But I've testified probably 50 times overall.
Yes, sir. At this time, Your Honor, I would tender the witness as an expert.
Well, I'll let them argue that as part of their motion to exclude.
Yes, sir. Dr. Dela Cruz, did you have a chance in this case to review evidence and talk with other defense experts, including DNA experts, forensics experts?
In this case?
Yes, sir.
Yes, I did.
Okay. And before we get into the specifics of this case, I'd like to ask you some general questions about cartel tactics. and
I think you
interaction.
need to come up to the podium, Mr. Prince. I'm afraid the court reporter is struggling with this a little bit. I'm sorry. I should have started with that.
Tell me about the interaction between South American supply cartels and some of the Mexican distribution cartels like the Los Zetas cartel.
Well, the connection between them started when Chapo Guzman, actually, Chapo Guzman was the main guy that started it all off as far as the connection between the Colombians and the Mexican cartels, the Sinaloa cartel. And so they made a pact, I guess you would say, a business transaction that they would buy so much at so much of a price, and that happened probably in the 90s, maybe late 80s, and as a result, it has evolved into huge. Oh my God! I'm sorry. Let me turn this off. I'm sorry. I thought I had turned it off. Okay.
As a general matter, does that structure remain in place, that South American drug production groups or families or cartels still funnel drugs into the United States through Mexican cartels?
They do, but there's also, the Mexican cartels have evolved, and they've done, a lot of them produce their own drugs themselves, right? But because cocaine, the coca leaves and so forth and so on, it's grown much better in Colombia, there's still that connection.
I see. And then if you could explain the other side of the equation, how the Mexican cartels will interact or deal with American criminal organizations to facilitate distribution of illegal narcotics throughout the United States.
Well, what they'll do is they'll typically go into a neighborhood or somewhere where they know somebody, and they will contact that individual, and they start dealing with that particular individual who may or may not be a member of a street gang. Now, the street gang itself, the whole street gang itself is not involved in the whole process. It's only this particular individual who then enlists the help of other individuals to distribute and sell the cocaine or whatever drug it could be, heroin, could be marijuana, depends.
In terms of the general rules, I suppose, of doing business with a cartel, if someone is found to have stolen from or lost drugs that belong to a cartel or affect cartel tactics, who all would be held responsible for that financial loss?
Well, this is the way it works. Let's say that I am a cartel guy, and I enlist the help of a young lady or an individual to transport drugs from point A to point B. And she or he gets arrested somewhere in between point A and point B. So, generally speaking, the cartel will kill the whole family. Because they can't get to her, but they'll kill everybody else, and they let her or him know if something goes wrong, your family's going to pay. Generally speaking, that's what will happen. If you're found to be stealing from them, they're going to make an example of you and your family. Everybody's going to go.
When one person brings another person into the criminal organization which deals with a Mexican cartel such as the Zetas, what culpability or responsibility does the individual who brings a person who's later discovered to have stolen merchandise or money from the cartel bear?
He's 100% culpable. The other person has really nothing to do with that individual, right? Because what happened was the deal was made. For example, let's say me, the guy makes a deal with me. I'm responsible, not the person, whoever got arrested, because I enlisted their help. I'm the one responsible.
Okay. In your experience, do Mexican cartels have the ability to carry out violence against individuals, even who may be incarcerated in state or federal prison?
They do.
Okay. Turning then to the specific facts of this case, you indicated you've had a chance to discuss forensic findings with defense expert Knox, correct?
Correct.
Okay. You've also had a chance to review the findings of DNA expert Kevin Knoppinger, correct?
Correct.
Okay. And in the course of those conversations, were you able to identify particular facts or factors or pieces of evidence that were consistent with or indicative of potential cartel involvement in this offense?
Well, there was a number of factors that were brought to my attention, not only by the discovery itself concerning the crime scene, but by the two individuals that you mentioned, the two experts. One was that there was numerous footprints. The other one was that the victim had been beaten or killed or struck with an instrument that had three different surfaces, types of surfaces. And the other was that there was a spade left against the wall, like brand new spade, like a shovel. And those, and then of course I reviewed the viciousness of the crime itself.
Okay. Let's talk about the vicious nature of the offense first. What, if anything, does that indicate to you relative to potential cartel involvement?
Well, taking into account the things that I was told and that I reviewed as far as what the young lady, the victim, was allegedly doing as far as drugs were concerned.
What exactly do you mean by that?
Well, the things that I reviewed and the things that I was told by different people involved in this particular case was that she was supposedly transporting drugs from Brownsville, Texas into Atlanta, and that she had skimmed off the top.
You had a chance to review James Carlos Santos' sworn written affidavit?
Correct, I did.
Okay.
And so taking that into account and the fact that children were killed, right, and the viciousness of the act itself and the way they were killed, right, with the brutality, right, and of course, once again, the footprints that were indicating that there was more than one person, the surfaces of the weapons that was used that indicated to me that there was probably more than one person involved. All to indicated that this was probably a Zeta crime, cartel crime, and there's a reason that I say that, because if in fact she was bringing drugs from Brownsville, Texas, which if she skimmed $100,000, I'm just hypothetically saying if she did, that means that she would have had to have been bringing huge amounts of drugs. You cannot go into Brownsville, Texas and buy drugs unless you're dealing specifically with the Zetas, because they control that area. Okay. You're not going to be able to go there and buy drugs in that amount from anybody that's not connected with the Zetas. The second thing that I took into account was the spade. The Zetas initially were military people. Now in the military, the ace of spade is the death card. So when I called Miguel, who was my cousin, the one that got shot by the military police, I asked him about the spade, and he said that the spade was a calling card from the Zetas, not to let the law enforcement know that it was them, because they wouldn't know, but to let everybody in the underworld know that it was them, and that if they messed with the Zetas, this was going to happen to them or their family.
Did you discuss with forensic expert Knox that there was no blood spatter or blood or hairs of any kind found on the shovel in this case?
That's correct.
Despite the fact that it was in proximity to the victim's body that would have been covered in blood if it was either there or used?
Absolutely. That's why I made that conclusion that it was a calling card.
Okay. You mentioned the forensic expert's opinion that multiple assailants were involved. How does that play into your assessment that this may have been a cartel involved assassination or murder?
Well, you know, in the time that I was involved in crime and prison and all that, I've witnessed 32 homicides, different homicides inside prison. And I found my brother's body stabbed 47 times. And every time these types of crimes, vicious crimes like this, they're always, most of the time, committed by more than one person. So the fact that the drugs, the fact that the spade, the fact that there was all these footprints, the fact of the viciousness, the fact that children were killed, all played into my conclusion that it was a cartel killing.
Were you also made aware of the fact by the defense forensic expert or in discussing the case with the defense DNA expert that foreign female DNA was found under the victim's fingernails in this case? What, if any, significance does a female's potential involvement, or would a female's potential involvement have in your analysis?
Well, oftentimes, like, for example, I'll use my brother, you know, it was organized crime, but it wasn't a cartel killing, but it was organized crime. They sent a woman to knock on the door, right? And so he opened the door, and then they ran in. So to me, it would seem that she would be the one, and she was probably the one, and maybe this Miss Peters knew this particular female, and I'm not sure, I'm just saying, but if a female knocks on the door of a house, generally speaking, they're not going to be as afraid as if a man or a stranger would knock on the door. So usually what they do is they use a woman as the go-between to get in somewhere.
You indicated that was how the kidnapping was committed against your nephew?
No, that's the way they killed my brother.
Your brother, okay. Did you also have a chance to discuss the fact that witness Benjamin Whitfield, who had previously been incarcerated with witness Carlos Santos, said that Santos had admitted that one of the children was killed in front of the mother?
Yeah, I read that.
Okay. Did you also discuss with forensic expert Knox the physical evidence which supported that claim?
Correct.
How, if at all, would that play into your analysis?
Well, once again, the cartels are a type of, they're vicious people, you know, they're sociopathic individuals that have no remorse. They're not typical individuals like a regular street gang. A regular street gang will not do this generally speaking, will not do this kind of crime without ramifications from the gang. But the cartel is a different animal. You know, one of the things they want to do is they want to make sure that they instill fear in people. So what they do is they want to teach lessons, and they do it by killing your children in front of you, like they did here, or cutting your head off. They do different things.
What, if any, significance do you assign to the finding that this Angel Avila's person DNA was located at the scene?
Well, you know, I know that he's a Colombian that used to work with the cartels, and that he got arrested. He lost a whole lot of money according to the documentation that I reviewed. And so oftentimes what will happen, this is an individual that's pretty knowledgeable, not only about what's going on in Colombia, but also in the United States. So he's a very important individual as far as to utilize him. So they could have, and I'm just speculating here, they could have used him, right, to do this in order to save grace for what he had done, lost the $1 million or whatever it was that he lost during the time that he got arrested.
Would a Colombian supply side member of a criminal drug trafficking organization indicate anything to you about the nature of the organization?
Ask me again.
Would a Colombian supply side member of a drug trafficking organization's involvement in an execution like this indicate anything to you about the nature of the organization?
Well, yeah, that it's, I mean, I already know they're violent terrible. I mean, you know, they're very violent individuals that will stop at nothing to to send a message that you're not going to mess with them. That kind of stuff. You know, that they are very that they'll get you or they'll kill anybody that gets in their way. That's who they are.
I have no further questions for the witness at this time. Dr. De La Cruz, let's go back and talk about what your dissertation was actually about.
Okay.
And could you explain to the court what your dissertation actually focused on and what it was limited to?
Well, it wasn't really limited to that. I mean, I did a little research on, you know, but the dissertation itself was on on a street gang, Northern California street gang in the city of Stockton, California. So members from Northern California street gangs, not just in the city of Stockton, California.
So it was limited to gang members, and in fact it was Latino gang members, wasn't it?
Correct.
In the city of Stockton, and that why they were getting pushed into the gang by the school and by the treatment they were receiving at school, by the community and law enforcement. Is that right?
No, what I was looking at is I wanted to determine whether or not they had been motivated or pushed into the gang by the behavior or the treatment of police officers, the community, school, and so forth and so on.
So what you were looking at, why young people were being pushed into the gang by the quote-unquote system.
Correct.
Let's cover a couple issues, sort of get them out of the way. One is, are you being paid for your testimony here today?
Absolutely.
And how much you charge and how much have you billed so far?
I charge $200 an hour and $16,000 so far.
Okay. Now, you ever been convicted of a felony?
Absolutely.
How many felonies have you been convicted of?
I can't be specific, but I got at least 5, maybe 6.
Okay. Now, you said you learned a lot. You said you started at a gang member at an early age, and that was in California. Is that correct?
Correct.
What part of California?
Northern California.
Okay. And went to prison at 21.
Correct.
And how long were you in prison?
I was in prison that time, I don't know, 5 years. I was in and out for the following from 1973 when I got to the first time. The last time I was in prison was 1996. So I was in and out.
Okay. And did you yourself, I'm not talking about anybody you may have been associated with, did you yourself ever have any direct contact with anybody in the Mexican cartel?
Yes.
Who?
One of the Felix brothers from Tijuana, and Toñito and Roberto. I used to go to Tijuana and La Nacha in Juarez, Mexico, and pick up heroin back then in pounds, 2 or 3 pounds at a time.
Okay, so that was in Tijuana.
Tijuana and Juarez, which is El Paso, Texas.
Okay.
I also went to Durango in 1977, 78 with my cousin and picked up a substantial amount of heroin up in the mountains.
All right, and all this would have occurred prior to 1996?
Sure, yeah. 1978, around there.
Now, in doing your background research to form an opinion in this case,
It took you a little while to form an opinion in this case, is that correct?
Yeah, it took me probably 2-3 months, probably, because I had to review everything. I had to talk to people. I had to call people, you know, different people.
And who do you mean by people? You keep saying people, but you're not putting...
Members of cartels in Brownsville, Texas, and through my cousin who lives in Dallas, Texas, right? So he connected me with people in Brownsville, right? So I talked to 2 individuals in Brownsville, Texas, via the telephone concerning the Zetas and what was going on as far as drug distribution. And the reason they talked to me is because of my cousin.
So the research you did was calling people who you believed, you connected through your cousin, who you believed in fact were members of a gang to discuss facts of this case.
No, members of the cartel, sir.
Or members of the cartel.
Yeah, they're different. Gangs are different. But anyway, I didn't have no reason not to believe that they weren't. They were giving me information that was consistent with what I already had read and reviewed in books and the internet and different newspaper articles throughout the nation concerning the brutality and killing that cartels do.
All right, so you in fact did Google searches to read newspaper articles in order to try to form this opinion.
I did.
Is that correct?
Yes, correct.
Now, can you identify any methodology that's generally accepted in the scientific community that would allow you to form an opinion based upon talking to people who claim to be something and doing Google searches on the internet?
Well, it's not scientific methodology, but I use the same approach that the police officers use when they're doing expert or investigations on specific gangs or whatever. You know, there is no, especially when it comes to the cartels, there is no scientific data right now that really explains who they are, what they are scientifically. And because it's dangerous for the researcher, especially the researcher that doesn't know what I know. It's dangerous for them. So there is not any scientific methodology per se that I could point to and say, okay, this is the way they do it, the scientific community. But me personally, as I stated, I do the same thing that police officers do. I contact people in the community or in communities that I believe are involved or could be involved or could connect me to people, right, that could give me the information needed.
You've talked a lot about California, especially California 20 or 30 years ago. You've also talked about contacting people, your cousin who was killed, to talk to him about it. Was there another cousin in Dallas, or
there's two more nephews, not cousins.
Okay, that you contacted them,
yeah.
And you said somebody connected you. I thought you said a cousin or somebody or brother had connected you to somebody in
Brownsville.
Brownsville.
They're nephews.
Their nephews.
Had done out of Dallas. I also have a nephew in Houston, Texas, but he's in the penitentiary now. That's involved with the cartels, but I didn't talk to him.
And did you talk to anybody in Tallahassee about gang membership here?
Well, I've done research as far as the crime situation in Tallahassee.
And how have you done that research?
Well, I looked. They got plenty of articles. I know they got 5 killings between June and now, 16 shootings. And what I found is that none of those shootings.
And when you say articles, do you mean you Googled it and read the newspapers?
Well, newspapers. I mean, you know, I seen the news. Actually, I seen the news last night, actually, when I got here. And they were talking about a community group getting together, talking about this violence that's been occurring in the city of Tallahassee.
So that's the extent of your research as to the gang stuff in Tallahassee? You looked at the news last night?
Well, I'm not concerned with gang stuff in Tallahassee. I'm concerned with the cartels and the part they played in this particular crime.
Well, how do you know the cartels are even associated with the city of Tallahassee?
I didn't say they were associated with the city of Tallahassee. I never said that.
Have you ever specifically being asked to do what you're doing, what you're being asked to do in this case, have you ever just done an evaluation by looking at a crime scene and saying this was a gang hit?
Have I ever looked at a crime scene and determined that it was a gang hit? Is that what you're asking me?
Yes.
Yes, I've done that.
Have you done it? Have you done it for Mexican cartel?
No, this is the first time.
And the cases you did testify into that the looking at the crime scene saying it was a gang-related crime involved street gangs, didn't it?
No. One of them involved the Nuestra Familia. I'm currently doing a triple homicide in Modesto, Stanislaus County, which involves the Nuestra Familia. So it's organized crime as well. And the Blood Nation, which is organized crime in Harrisburg, Pennsylvania, RICO case, and the Mara Salvatruchas, which is a criminal organization, not a street gang, in Newark, New Jersey. So I've done numerous gang cases where it's been organized crime.
Now, you're basing the fact that the spade is the death calling card based upon something your deceased cousin told you when you talked to him, is that right?
Well, he confirmed it. I had already heard about it.
How'd you hear about it? You read it on the internet too?
No. I know a lot of people. I'm like, I can go into a community, just about any community, not in Tallahassee because I just got here last night, but I can go in just about any community and connect with individuals who are currently involved in criminal activity, gang activity, and they will talk to me, not about the crimes or gang, what they're committing at that particular moment, but they'll tell me about what's going on. So that's the way I learn and keep abreast of what's going on.
And you're basing your determination that Miss Peters, that's the victim in this case, if you did not know that, she and her family were killed because she allegedly was moving a large amount of drugs, and all this is based upon what Mr. Santos put in the letter?
No. It's based on the viciousness of the crime, the footprints in the crime, the different weapons that were used allegedly in the crime, the fact that she was transporting drugs, the fact that they killed kids. All these factors play into my opinion.
Do you know who went in and out of the crime scene?
No, I don't.
Do you know whether or not that people walked across the threshold where her body was laying through the blood and stuff? And
I don't. I'm going by what the forensics reconstructionist told me, that those footprints were there prior to you folks going into the crime scene. Not you, but the law enforcement.
Right. So you're basing this upon something the forensics examiner told you what the crime scene looked like.
That's one of the elements. There's about 5 or 6 elements that I'm basing.
Let's just focus in on this one. So you have somebody who says that the footprints that came in were there before law enforcement entered.
Correct.
But you didn't make that determination, did you?
Well, of course not.
And when you were asked about, I think at the time I did the deposition of you back in January of this year. Do you recall it?
Yes, I do.
You indicated you had testified something like 28 times. Is that correct?
Probably, yes, at that time. I've testified numerous times since then.
You always testify for the defense. Is that correct?
Well, I'll testify for the district attorney if they ever call me.
If they ever call, but so far you've only testified for the defense.
Well, I've offered my services to the district attorney, the elected district attorney in different counties, And I explained to them that I would be willing to train their assistant district attorneys to know what makes a gang crime and the elements of a gang crime, but they have never called me.
Yeah, nobody's taken you up on the offer, have
No, they haven't.
Now, one of the things you're also assuming is that there is DNA of Angel Avila at the scene. Is that right?
No, I never said anything about any DNA of Angel. That gentleman that you just mentioned, I forgot his last name, but I never said anything about his DNA.
You were asked by Mr. Prince. Is that something you?
Oh yeah, okay. The report that you're talking about, the Colombian guy.
Yeah.
Yeah, I did.
Okay. And so you're taking that on faith as well, aren't you?
Well, yes, I didn't do the test myself.
And you're basing on the fact that there may be a woman's, an unidentified woman's DNA at the crime scene because I think you said that because in your brother's case, but he was killed by organized crime, not the cartel, that a woman came up and knocked on the door.
I'm basing it on that. Is that what you're saying?
Yeah.
No, I'm basing the fact that that's the way they work usually, whether it be cartels, organized crime. Cartels are organized crime, by the way. So, that's the way they usually work as far as trying to get their victim to open the door.
Is woman one of the killers too, or did she just get you in the door?
Well, the woman that was involved in my brother's murder was not a part of the killing squad, because it was a squad.
Have a moment, Your Honor. Yeah, I thought I did. And have you ever reviewed a crime scene where you saw a spade or a shovel?
I have not.
And so this was the first time, and you based that upon some stuff you read plus what your cousin said.
Well, he was a Zeta, so I pretty much took him at face value, and the material that I read was credible.
How'd you determine it's credible?
Well, because it came from a journal, and it came from well, most of the time they're pretty credible. Okay. I just took it to believe. I believe that it was credible.
All right.
Okay.
Thank you.
Redirect.
No redirect, Your Honor.
All right, you can step down.
It's not the defense. We call Benjamin Whitfield.
Yeah? Benjamin Whitfield?
Yes, sir.
Is he in custody?
No, he's not.
Somebody will need to get him?
She's getting him, yes, sir.
Okay. Come on up here, please. Face the clerk and be sworn, please.
Do you solemnly swear or affirm that the testimony you give in this case will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Have a seat. Slide at the microphone, please, sir.
Mr. Whitfield, can you please state and spell both your first and last name for the court reporter?
My name is Benjamin Franklin Whitfield, Jr.
Mr. Whitfield, were you incarcerated with a man named James Carlos Santos in Florida State Prison in 2011?
Yes, sir.
And how did you initially meet Mr. Santos?
I was put in K Wayne, and he was next door to me, and I was in K1128. He was in K1129.
Okay, so you were in close physical proximity to each other within the same.
Just position next door, side by side.
At some point, did you establish an acquaintance type relationship with Mr. Santos?
Yeah, we started conversating after a while, maybe after 2 or 3 days or something like that.
Okay. Did Mr. Santos ever talk to you about his involvement in the 2010 murders of Brandy Peters and her children?
Yeah, when he first started talking to me, he just said he asked me did I know anything surrounding that case and stuff, and but he didn't. He tried to portray it like he didn't know anything about it, and then but as time progressed, then he started telling me more stuff about it and about his involvement in it.
What did he tell you his involvement in the murders was?
That it was something about a drug debt, and he was in communication with her while he was at FCI over off Capitol Circle, Federal Correctional Institution, and he was using, I guess, some type of email system or something they have set up for federal prisoners over there at FCI.
Okay. Did he eventually admit to you that he ordered her and her children's murders?
Yes, sir.
Okay. Did he tell you about any of the details of how the murder was carried out?
He told me that she had some dishes that supposed to been I think these dishes was made by Tiffany or something like that, and he said that she had, it was supposed to been 3 computers in the house, and he said that they had them when they came and committed the murders of them Brandon and her 3 kids, that they took one of the computers. I think that might have been the computer. I don't know for sure that he was communicating with her on.
Did he say specifically who he ordered to carry out these murders?
No, he just said.
You said you started talking about something about dishes, and
yes, sir.
You didn't follow that through. What were you saying about
dishes? Saying about some dishes that she had that was supposed to be Tiffany dishes that supposed to been worth like $3,000 or something. It's him and somebody supposed to have purchased for.
You're saying the people that committed the murder took those?
No, he's saying that they supposed to took the laptop.
Took a laptop.
One of the computers that he was communicating with her. I guess it might have been one that he was emailing her with.
Okay. So he was just saying he had purchased them for her at some point.
Mm-hmm. Yeah, purchased her I think like a vehicle, and supposed had got her a passport to go to Colombia, stuff like that.
Did he say anything about one of the children being killed in front of Miss Peters?
Yes, I think he told me about I think the little boy was supposed to have been killed in front of Miss Peters first, and then the two little twin girls.
Okay. How long did you remain at the same correctional complex as Mr. Santos?
I think we was side by side maybe for maybe about 3 weeks, a month and a half.
Okay. And you came forward and shared this information with Florida Department of Law Enforcement agents in, is it late 2016 that took place?
Yes, sir.
When you were almost at the end of your sentence, correct?
I was about let me see this. Yeah, I think I had probably about 2 more years, a year and a half, something like that, left for my sentence.
Without gain time, you're saying?
Yes, sir.
Okay. And you've since been released from state prison?
Yes, sir.
Okay. Why was it that you decided to come forward with the information that Mr. Santos had shared?
Because this gentleman here, Mr. Henry Seguro, they said that he wasn't the one that did it. So he was trying to figure out a way to help him, but he didn't want to help him, and then implement himself. And so I just, and me being being wrongly accused myself, and I didn't want to see him lose his life like that.
Thank you. No further questions at this time.
Yes, sir.
Have you ever been convicted of a felony or crime of dishonesty, Mr. Whitfield?
I've been convicted of a felony.
How many times?
Let me see. Like 2 times. Well, 2 different. I've been in prison incarcerated 2 different times.
Okay, incarcerated 2 different times?
Yes, ma'am.
And you met Mr. Santos in prison?
Yes, ma'am.
And that was in 2012?
Yes, ma'am. That would have been in 2012, like May. I think I met him. I know it was like around May, June, July 2012.
And it sounds like he told you about some pretty gruesome murders he said he committed, right?
Yes, ma'am.
A woman and her 3 young children.
Yes, ma'am.
Getting killed in front of her.
Yeah. He told me that the little boy was supposed to be killed in front of her. But he didn't say anything like about the 2 girls. But he just said that it wasn't supposed to have been a lot of blood in the house, and that
there wasn't much blood in the house.
It's supposed to not been like a lot of blood or something like that. And, but I know it's supposed to they supposed to be mutilated or something like that. And he said that they had that TPD. They didn't know about how actually the murder had happened. So I think they took and reconstruct the house like in a warehouse or something like that. And they had took out pipes and different stuff, something like that. They had said, I don't know.
So he said that a little boy was mutilated?
No, he said that they was supposed to have been mutilated or whatever.
I didn't quite understand.
Yeah, I didn't.
Like mutilated, decapitated, or something
Say
like
to the mic.
Like mutilated.
And you said decapitated?
Like I said, like mutilated. However they was killed, he said something like about there wasn't much blood. That's what he had said. And that the little boy was killed in front of his mother, and that when the body was found, I think the first one that was found, like the door was left open. Or something like the first one that was supposed to be found was the little boy. So when she opened up the door or whatever, he was supposed to be the first one they supposed to find.
Okay, so he said that. What do you mean when you open the door? When you open the front door of the home?
Yeah, the front door of the home.
So according to James Carlos Santos, the little boy was killed in front of his mother.
Yes, ma'am.
He was mutilated, and when you first opened the front door of the home, his body was the first one that you saw.
No, what he told me that the little boy was killed in front of his mother, but he didn't actually say how he was actually killed. But then, later on, he had told me that it was supposed to be they're supposed to be mutilated, maybe killed in the something like killed in the bathroom or something. I don't know for sure.
Okay. And he said that the little boy's body was found when you first opened the front door of the home?
Yes, ma'am.
That was the first one that you saw?
Yeah, that's the first one they're supposed to have found.
Okay. Anyway, though, he told you about a pretty gruesome scene, a woman and her 3 kids getting killed, right?
Yes, ma'am.
And even after hearing that, though, you waited for 5 years before you ever told anyone about this. You waited until May of 2017.
Well, DOC, being in prison, is a very dangerous place to be giving up any type of information.
Well, you were still in prison, though, when you gave this interview, right?
Yes, but I was the situation that I was in at FSP is it's like Rayford is like one of the most dangerous prisons in DOC in Florida. So, and it wasn't I want to go ahead on and say something then, but it's like I started hearing other little stuff concerning the case, by other people talking about. So I just went ahead and I want to make sure that he hadn't already. I just tried to find out if the case had already been through. So I didn't want to die on death row, because I know Governor Rick Scott, he supposed to have changed the death row the policy for execute inmates from instead of sitting on death row for 20, 30 years, it's like 5 years. So I didn't want him to die on death row.
Okay, so you waited so long to say something because you were scared of something happened to you in prison.
Well, it wasn't wouldn't been very safe to do so.
Okay, but you believed Mr. Santos that he put out a hit on this family.
Yes, ma'am.
Yeah, but you're not afraid of him sitting here right now testifying against him? You're not afraid that he's going to do the same to you?
Well, I just say it like this right here. I'm a Muslim. I worship Allah, and you know, if Mr. Santos, if he wants some problems or anybody wants some problems, then I could have. I just say it like this here. It won't be in his best interest to put out a hit on me.
Okay, couldn't Allah protect you in prison just like he could protect you now?
No, the law can't protect me in prison like I can be protected now.
Let's talk a little bit about your mental health history. Can you tell us about that?
Yes, ma'am.
Okay, go ahead.
I have been in DOC, and I was in different mental health facilities in DOC for going on the past 11 or 12 years.
What specifically were your diagnoses or your issues?
Schizophrenia.
Anything else?
And antisocial personality disorder.
What do those mean? What kind of behaviors do you exhibit with those type of diagnoses?
Schizophrenia is like it's like different forms of schizophrenia. Like sometimes like you feel like you have I guess like different powers. Like that's like one form of schizophrenia. Then you got what's called antisocial personality disorder. That's where like you like I'm kind of like a person. I like to be to myself a lot.
Okay.
I don't go out of my way to try to make friends.
Okay. As far as the schizophrenia, what type of powers are we talking about?
It's just like it's just like you, like for me, my situation is like reincarnation. I read a lot of books. I do a lot of meditating and stuff, and like on reincarnation, and I know that everything happens for a reason, and so, and like that's and like I don't want to see him to die in prison for something he didn't do, because he explained to me that he wanted to be able to help him, but he just didn't know how to help him. So, but he was gonna like let him. I guess he was gonna let him die in prison, let him die in the electric in the death chamber or whatever. So I wasn't gonna let it go down like that.
What about Baker Acts? Have you ever been Baker Acted?
Yes, they had me Baker Acted because they want to try to discredit like this testimony I'm giving to you today.
Okay. When were you last Baker Acted?
This was like a couple of days. Anyway, it was the first time was like around when I was let out of prison, Wednesday, May 31st, 2017.
Okay.
And then this second time.
And that was your first time ever being Baker Acted?
Yes, ma'am.
All right. And then how many times have you been Baker Acted since then?
Been one time. That was like on August the 4th this year. Same thing. They just want to try to discredit me. They try to make it look like I'm just paranoid, I'm just delusional, I'm just
What
lying.
specifically were you doing when you were Baker Acted?
I had gave a statement that to law enforcement that they was this little rapper, they call him Lil Boosie, they was planning on having an uprising against law enforcement. They want to kill off all the law enforcement, all the white people, all the first responders, all the judges, all the attorneys, all the military and stuff like that, and it's something they was planning to do.
And that was a rapper that was doing it?
And they still planning on doing it.
Okay, and how did you get that information?
Because they try to like to communicate with me like over the like the radio and stuff like that, and then I have my nephew, a so-called gang member, in my house.
Okay, so there were messages that you believed you were hearing in rap songs that caused you to believe that certain people were being threatened by this rapper?
No, it's what it is that they got this like this little game called Xbox, and so they got like this I guess like satellite radio hooked up to it or whatever, and so then what they was doing is trying to communicate to me to be a part of this little like F the police and stuff like that. But I have family that's in law enforcement, so I didn't want to have no parts in it. So I went ahead and contact TPD, and I had them to come and pick me up.
Okay. So through the Xbox and through the satellite radio, the rappers were communicating with you, and you went and reported that to Tallahassee Police Department.
Yes, I reported it to Tallahassee Police Department because it's also I know about it's other things that's that they have planned. It was supposed to be around this movie that they got that post came out now called Detroit. And they was planning on having an uprising around that movie Detroit that came out on August the 4th. And something about like they had to call it like National Guard, something that supposed to happen, but it was a movie that supposed to correspond with this uprising against law enforcement.
Now, when you and Mr. Santos were together in prison, were y'all in a specific type of ward there, like a mental health ward, or?
No, it was just a regular CM. I think it might have been CM2, CM1, CM2, something like that.
Okay, had you been in a mental health ward in that prison at some point, or were you put in there at some point?
No, not at that prison.
Okay, what about Mr. Santos?
No, not at that prison.
Did Mr. Santos at any point tell you about his mental health issues?
I didn't know he had it. He didn't tell me anything about it.
Did he tell you about other murders he'd committed?
No, he didn't tell me about any other murders he committed. He just
this one?
He just told me that the little boy was supposed to be some guy named Kilo, son, some drug dealer named Kilo, and it wasn't even supposed to be like his son or whatever.
Okay, thank you. That's all.
Supposed to be like Kilo, yeah. All right.
Redirect. No, Your Honor. You can step down.
I'll step down.
Yeah.
Okay.
Next witness.
It's time the defense would call C.C. Timmons.
Folks, you're listening to the Seura trial out of Tallahassee, Florida. This is Aaron Keller with you here at the Law News Network for the afternoon, and some quite unbelievable testimony in the minds of many people in the chat room and here at the Law News Network about whether or not another inmate in prison at one point confessed to the murder for which this particular defendant is sitting in the defendant chair. We just listened to one person who was incarcerated with him say that another person confessed, but that same person also said that he thought that rappers were trying to communicate with him through the Xbox and through satellite radio, and reported as such to the police department there. I can't say that I disagree that the jury wouldn't believe this person even if they heard him. So again, the defendant has a right to press for an evidentiary hearing here, and that's what he's doing. This is outside the presence of the jury, the judge just weighing whether or not these witnesses should go in front of the jury. We've got another witness taking the stand. This is the victim's neighbor.
Ms. Timmons, you were with Brandy Peters.
Start by giving us your name again, please.
Cicely Timmons.
Could you spell your first and last name for the court reporter?
CIESLYTIMMONS.
You were with Brandy Peters on the 19th, correct, during the day? Were you with her when she received a letter from a James Carlos Santos that day?
She came to the house after
She brought it to you at the house?
She came to my house with it after she had read it
Okay. You knew Brandy pretty well, correct?
for about 6 months.
You knew her, you knew what she looked like if she was scared or concerned about something? Did she, at some point when she came over to your house, discuss that letter with you?
Yeah.
Okay.
She was scared when.
Did you see the letter?
Yes.
May I approach the witness, Your Honor?
No.
For purposes of this motion hearing, I'll identify this as Defense Exhibit 1. Do you recognize a copy of this envelope? Postmarked November 17th, 2010. Is that the letter that Brandy received on the 19th?
Yes.
Did you have a chance to look at that envelope at the time?
She came to my house with it and I read it.
Did you read it?
Yes.
And what it states on the letter accurately reflects what you recall at the time. Word is bond, bond is life, and a man should give his life before his word fails. Say what you mean and mean what you say. Death before dishonor. Dear Mr. Mailman, if this letter happens to get lost, just send it to heaven, because it's going to an angel. I thank God for you and ask that he look after you and our 3 angels. That's what it said on the outside of the envelope?
Yes.
How did Brandy appear upon reading that envelope?
She was scared.
Are you scared?
Yes.
Who are you scared of?
Carlos Santos.
No further questions for the witness at this time.
Right.
Ms. Timmons, prior to receiving this, you said you'd known Ms. Peters for about 6 months at that point?
Yes.
Prior to her receiving this, isn't it true she'd only really been known Mr. Santos for maybe even a month, not very long, 6 weeks, something like that?
From my understanding, that's the understanding that I got from it.
Okay. Didn't know him before all that?
Not that I know of.
Showing you the letter that was written here. Doesn't it also say send me pictures? Given all of that, Brandy, isn't it true that Brandy's concern wasn't so much of her being killed or dying, but more along the lines of being involved with this guy, Carlos Santos, who wants to marry her and all that kind of stuff?
Well, once she was scared about the letter, but before that, I mean, she was just really trying to find out who he was, as far as I know.
So she was looking to figure out who he was at that point?
Yeah.
Had no idea who he was?
She didn't seem to know who he was, but when she got a letter, she was scared.
And that's because the letter talks about weird stuff, weird statements and things like that. Fair to say?
Yeah.
Okay. Kind of freaked out, kind of like you would if you were on a first date with somebody and then you try to get out of it real quick when they're a little weird, right?
It was crazy.
Yeah. Fair enough. All right. Thank you, ma'am.
Free to read.
Ms. Timmons, Ms. Peters had prior dealings with Mr. Santos. That's simply not something she discussed with you.
No.
Nor did she discuss with you any drug trafficking activities by her, correct?
No.
Thank you. No further questions at this time.
You can step down. Go ahead, next witness.
Defense would call Lakeisha Garland.
What was that name again?
It's Lakeisha Garland.
G-A-R.
L-A-N-D, I believe.
Sorry, Your Honor. Can I step out and go to the restroom real quick?
All right, we'll take a few minutes. We'll take about 5 minutes.
Thank you.
Okay, folks, welcome back to the Law News Network. Aaron Keller along with you for the afternoon, and we're in the middle of a 5-minute break in the Henry Seura case in Florida. He's a defendant who's facing 4 first-degree murder counts and a possible death penalty if he's convicted on those counts related to the deaths of his girlfriend, her 2 twins, and an even younger child who was also the defendant's son. We have listened to a series of witnesses parade back and forth across the witness stand in the last few minutes. This is an evidentiary hearing. The jury is not there to hear this. The judge is trying to weigh whether or not these witnesses have enough to offer to try to get to the jury. I want to go back, though, because the defense's tactic here is clearly to try to point the finger at some other people. There's inmates testifying that there was another inmate who took some responsibility in these murders, and that particular inmate refuses to testify. He's pleading the fifth. But the defense is trying to call all the other people who were in prison with that inmate and other people who thought that the victim was afraid of that inmate to try to take the blame away from the defendant. I want to go back, though, and listen again to one of the police investigators who said that part of the reason that they're going after this particular defendant is because they believe that one of the several phones he had was in the area of the crime when the crime was committed.
The parking lot of the church that is behind Miss Peters' residence, and it's actually if her residence is right here. So we're real close to her residence, but we're also going up the hill a little bit now. So we're a little higher, we can see out a little better. So we were curious what cell sites we might communicate if we were north of her residence.
Okay, and did you do the cell tower and distancing analysis on this?
We did, and we saw here our 847 and our 849, which we've seen in other records. We have our distancing information here, which most are consistent. We have a couple that fall short. Again, as we've seen previously.
Okay, let me stop you right there. Those fall short, and I think if we go back to the 408, there's actually one that went well past.
Yes.
The area that it was previously indicated. Is that, and I think there was actually a phone call that was, or some sort of data session that were like 7 seconds apart that were substantial distance apart. And I guess I'm going to call them a flyer because you'd have to be in a plane to fly that far, that quick. Are things like that, these flyers, are they, did you find them both in your test phone as well as the analysis of the 408 number?
Yes, absolutely. So here is our test phone. This is our data. I know exactly where I was. I wasn't flying at the speed of light one direction or another, but these are the distances that we received. So we definitely saw that, you know, our closer cell sites were usually more accurate. As we started communicating with cell sites almost out of the county, then our reported distance could be off a little bit. But we do see that we have a couple of distances a little short, a couple of distances a little long.
You got a lot of experience analyzing things. Are these flyers, if you will, something you normally see?
It is. We might look at, and we use the distancing data a lot to locate people, missing persons, wanted persons, those kind of things. And if I look at a report and I see a period of time where I think, you know, someone may be asleep or, you know, at their house and there's 20 events and 18 of them are nice and consistent and there's a couple that are, you know, a little long, a little short. Just as a matter of practical analysis, I would eliminate those and I would look at what is most consistent, and that's the area that I would go and look for this person because I knew that every once in a while we do see those that represent a little short or a little long.
Okay. So essentially, if I understand you correctly, then even though you get those, you still have to look at everything as a whole, but your experience has shown you that those things happen on occasion.
Sure. If I'm looking for someone, I'm going to the average. I'm going to where, you know, they're most likely to be. If I'm going to say where someone may or may not have been, then I have to look at what the possible error of the data could be.
Okay. Next location, Hampton Drive. What's the significance of that?
This is just the entrance to her neighborhood, to Miss Peters' neighborhood. So this is directly off Tram Road. You can see we're just right here in. There's a little parking area. Miss Peters' residence is here. So again, we're very close to her residence. We're a little bit further down that hill. And again, we just want to see, hey, if we're this close to her residence, what does our information look like?
And I think we previously talked about an exit being up there at Paul Russell Road. Does that mean there's 2 entrances and exits to the neighborhood?
There are 2. There's one that comes out right here on Tram Road, the main entrance to the neighborhood, and then you can exit Jim Lee Road up to Paul Russell.
All right, so the north and the south entrance.
Correct.
Okay.
By vehicle.
All right.
So we saw our cell sites here. our distancing, and our additional distancing. So everything that we have, again, a little bit short of where we actually were and shorter than the other data that we had seen.
All right. Next, it looks like you went to the location at 908 South Front.
We did. This is Ms. Peters' residence, and we did events both inside and outside the residence. And these first ones here are ones that we did in the driveway outside.
Okay. And did you do the cell tower and distancing analysis?
We did. We saw our same 847, 849 that we've been seeing in other records. We have our distancing, and again, even here we have one from this further away cell site that comes up a little short, one a little long, but if we look at the bulk of the data, we can see that it's much closer to the other data that we had seen previously.
And looking at this, I know that we talked previously about that line for the segment, and this one appears to be hitting off two different sectors. Again, we're outside the home, correct?
That's correct.
All right. And because on that line, essentially, is that why we're looking at two different sectors? Like
Yeah, let me see if I can make this work here. So we had talked previously about the sector break, and that somewhere between Sector 1 and Sector 2 is where we would expect that phone to start transitioning from one side to the other. And we can see that when we were at the entrance or to the neighborhood, we were more over here, and most of our data was with this one. Here, we're a little bit closer to that transition line, so we can understand that the handset may be trying to make a choice between which side of that it sees the best. And knowing that it's not in a real good spot is why it looks to that one that's even further away. Because even though it's further away, it's more in kind of the sweet spot of that sector, so it may want to communicate with it more often.
And I think thinking back to the 408 analysis, it was not hitting off of both these sectors. It was only hitting off one, correct?
At different parts of the day, it communicated with both sectors, and sometimes it was just the Sector 1 or the one that's more facing towards the north.
Okay. All right. So what's the next location?
So the next location was actually inside of her residence. We went into her residence, it was still vacant at the time, and created a series of events in the living room.
All right. Did you do the tower and distance analysis?
We did.
We're going to break away from that clip of the police talking about trying to pinpoint the defendant's cell phone near the scene of the crime when it happened, because there's another witness on the stand. This witness says that the victim came to her house with a letter from Santos. At least, well, I think that might have been the last witness. Let's listen into this one.
Ms. Garland, can you please state and spell both your first and last name for the court reporter?
My name is Lakeisha Garland, Lakeisha Garland, Garland.
You knew victim Brandy Peters?
Yes.
How long did you know her for?
She was my neighbor. I moved into Swakoko Villa 2007, 2008, till up to the time of her death.
You remained friends with her up to the time of her death?
Yes.
Okay. Did you have a daughter that was about the twins' age?
The twins were a little older. The twins were older than my daughter.
Okay. Was your daughter friends with the twins?
Yes.
Okay. They used to play together and things of that sort?
Yes.
What about you and Brandy? Were you two close as well?
Yes.
Okay. Did you remain close all the way to the time of her death?
Yes.
Okay. Back when you and Brandy were neighbors in 2008, were you aware of her reputation in the community for being involved in drug trafficking and with drug traffickers?
Yes.
And what was her reputation in the community?
That she had her own drugs she was selling to the community. Of some who were the people, I didn't know. I just knew that she had her own until the time she got with the boyfriend, Kalo.
And what happened at the time she got with Kalo?
He then wanted her to be part of drugs with him, even though Brandy had her own.
What about your own personal knowledge? Did you ever personally witness Brandy engaged in drug sales, cocaine sales?
Yes.
How frequently did that go on?
She had a few people come to her place, and some she'll go off and meet. She wouldn't really want too many people to come to her house.
Okay. What about after she moved? Did you remain aware of her reputation in the community for involvement in drug trafficking?
Yes.
And what was her reputation after she moved?
She knew that some people wanted to get on with her, but she would never let nobody get involved with the situation that she had going on. And she would never invite them to her new place where she was living at. She would always drive off and meet them.
Did you know anything about her having a debt, a drug-related debt?
I heard about it, but her speaking of it word of mouth, no. I just knew that she had a cousin that wanted to get on with her, that wanted to help her with it. She just would never involve him with it. She told him she just didn't want him to get involved. She only wanted to do it on her own.
Okay. When you said that you had heard about her drug debt, that was not from her. That was other members of the community that knew Ms. Peters. Is that correct?
Yes.
Okay. No further questions for the witness at this time.
Cross.
You talking about you were neighbors with her before she moved to the address on Saddle Creek Run?
Yes.
Okay. So back on like Holton Street?
Yes.
Okay. Fair to say, unfortunately, that's a neighborhood that there's more than one person in there that's selling drugs and stuff like that.
Mm-hmm.
Okay. Miss Peters, in selling these, if she is in fact selling drugs, you said she had a couple of people over there a couple of times, correct?
Yes.
Okay. At any point was she coming out with large suitcases full of narcotics and selling big amounts?
No.
Okay. You're talking about small street level, $20 or something like that?
Yes.
Okay.
Because she would always let them come in-house, not outside.
Okay.
It would never be nothing done outside.
And then when she moved away, she didn't ever want to invite anybody back to her house for any of this stuff, right?
She would never invite nobody to her new place, no. She would always go off.
Kind of distancing herself from all
Yes.
that. Getting out of it.
No, she actually would drive off in her car to meet people for the sales. She would never invite them to her new place.
In Tallahassee?
Yes.
Okay. All right. Again, talking about very small levels of stuff, not big suitcases full that you see on TV and stuff like that, right?
Well, I never seen her of us moving distance. I never seen her do it from there. So I couldn't say from Saddle Creek if she was moving it from there.
Okay, so you're talking about back in 2008 then, when you saw most of it?
Yes.
Okay. After that, you really don't. You just heard of word of mouth.
Yes, but I knew that she still word of mouth, would never invite him to her house. She'll go off and serve away from, because she would never want nobody to come to her new place.
Okay. All right. Thank you.
Redirect.
Yeah, she ultimately was, to your knowledge, involved with Kalo's drug trafficking activities, correct?
Yes, plus her own.
Plus she had her own source of supply.
Mm-hmm.
And Kalo ultimately was caught and sentenced for possession and distribution of large quantities of cocaine, correct?
Yes, but he also, he came to her for some help. Because he told her he hadn't messed up and he needed some help from her. And that was the last conversation. I was around with him, with her.
I understand. No further questions for the witness at this time.
So when did she move away from Holton Street?
2008.
What?
2008.
So it'd been a couple of years that she'd been moved away.
Yes.
How much contact were you having with her between 2008 and 2010?
It was like on and off.
Beg your pardon?
It was like on and off.
Phone calls?
Phone calls. She'll come over to my place. I would. We also. She had a birthday party for Vontae.
She had a what?
She had a birthday party for Vontae, so we went to this birthday party that she had for him. And it was just like she mainly would come to my house, to where I moved at.
How many times had you been to her new house?
I haven't been to her new place because she had Vontae party at a park.
So you've never been?
No, Brandy always came to my house.
All right, you can step down. Next witness.
Your Honor, I want to again ask the court for a little direction on this. I do have additional witnesses, and those witnesses have not presented their testimony during the course of the trial yet, but they don't bear directly on Mr. Santos. They only relate to time of death. And so I can either proffer that or call them to testify about that, whatever the court prefers.
I don't see where time of death is a big issue in this.
Well, only to the extent that it corroborates Mr. Santos' claim that multiple people were involved and that they committed the offense, as opposed to Mr. Segura. It's circumstantial. It's not direct corroboration. It's circumstantial corroboration of his version of the events.
I mean, you present what you want. I make my ruling. I don't think it's significant, but that's up to you.
Yes, sir. The defense would call Marquis Davis. Step up.
We are waiting to see if another witness gets called in the Henry Segura case out of Tallahassee, Florida. We've had a series of witnesses that the defense would ultimately like to call to the stand. And we might not have any more witnesses this afternoon if things go as planned. I think I heard the defense ask for a continuance there, and then I think we're going to lose the feed in just a second if anything is telling me anything based on the delay here. So this might be the end of the day in the Segura case. They sent the jury out of there. The jury, I believe, was allowed to go home even, and you know, they are, well, let's wait for just a second here and see where things go. We might have another witness up on the stand in a second. If we just hang on here and see where things go in courtroom. Again, the defendant there facing 4 first-degree murder charges related to the death of his girlfriend and his girlfriend's 3 children, only one of which was the defendant's child. I'm not sure whether what we're getting out of the courtroom right now is an actual feed or whether it's a replay from something earlier, but let's listen in.
We direct your attention to the evening of November 19th, 2010. Do you recall seeing the twins and Javante that evening?
Yes.
And what were you cooking that evening?
Oxtails, macaroni and cheese.
Okay. At some point, did you direct Cece to see if Brandy wanted some?
Yes.
Did she respond to that text?
Yes.
Okay. And did she want any or no?
I sent a plate.
Okay. You sent a plate over?
Yeah.
What about the kids, Javante, Tamaya, and Tanaya?
They ate at our house.
They ate at your house? Would that have been before you texted Brandy, or had Cece text Brandy, or afterwards?
It was like during the time they were eating.
During the same time?
Yeah.
Okay. At some point after that, did you decide to take some stew over to your father's house?
Yes.
And about what time did you get back from your father's house?
Around 8:30.
Okay. When you returned back, did you see a vehicle in Brandy Peters' driveway?
Yes.
What kind of vehicle was it?
SUV.
Okay. Had you seen Henry Segura's truck before?
Yeah.
Okay. In the SUV you saw, what color was it?
It's dark blue or black.
Okay. You'd seen Henry Segura's truck before, right?
Yeah.
It had distinctive characteristics?
Yeah. It was an older model pickup truck.
Okay. It has spoiler and fat tires and all that on the back? Did you recognize the vehicle that was parked in Miss Peters' driveway as being a different vehicle than Mr. Segura's vehicle?
I hadn't seen it before.
You hadn't seen it before?
No.
Okay. I have no further questions for the witness at this time.
Ross.
You said you took some dinner to your dad?
Yes.
Where does he live?
He lives on Bermuda Road.
Where?
Bermuda Road.
Where's that at?
It's 1 street over from North Florida Christian School.
From 1 street over from North Florida Christian School? So you're talking about over on the north side of town, almost out of town?
Behind Tallahassee Mall, yeah.
Okay. And you said that the kids ate at your house around the time you sent that text message?
Yeah.
And then you came back around 8 o'clock?
8:30ish.
Okay. Now, Mr. Davis, you never told law enforcement this information, did you?
No, I didn't.
Yeah, law enforcement was there, interviewed your stepson, interviewed Cece. Obviously, are all over the place during all this stuff, and you never once came forward and said, "Hey, by the way, I might have some information."
I mean, I was there. They never interviewed me.
Didn't tell them, did you?
No, I didn't just come out and tell them, but they never interviewed me. I was there, but I was working a lot at the time too.
And this is now 7 years later is the first time you're telling anybody other than the defense this, right?
No, it's not the first time.
You ever told law enforcement before?
No, like I said, no one ever interviewed me about it.
Never told state attorney's office, anybody, have you?
No.
No further question.
Redirect.
No, Your Honor.
What time was it when you fed the children?
Was around, probably got through cooking around 7:30.
Around 7.
Yeah.
So you weren't gone very long.
No, I just went and took my father something to eat and came straight back.
Okay. And how long was the SUV there?
I'm not sure. Once I got back, I went inside and I didn't
Just saw it
go
one
back.
time?
I saw it going
Went
in the house.
inside?
Yeah.
All right, thanks, sir. You can step down. Your next witness?
It's time the defense will call Officer Candace Jernigan.
Come on up here, please. Would you face the clerk and be sworn, please?
Do you solemnly swear or affirm that the testimony you give in this case will be the truth, the whole truth, and nothing but the truth? Yes, I do.
Have a seat. Side of the microphone, please.
Officer Jernigan, can you state and spell again your first and last name for the record?
Candace Jernigan, Candice Jernigan.
And I just want to clarify briefly, you were one of the officers who responded to 908 Saddle Creek on the morning of the 20th, correct?
Yes, sir.
And had an opportunity to interview several witnesses who were present on scene.
Yes, sir.
At some point, did you have a chance to talk to Monica Peters?
I did.
Did you talk to her about her last communication with Brandy Peters?
Your Honor, hearsay.
Well, my response, Your Honor, would be that it's a motion hearing, number one, but number two, that witness, Monica Peters, testified.
Look, I'll overrule it for now. We can argue about this as part of the ruling.
Yes, sir. Yes, ma'am. Go ahead.
Can I refer to my report?
Yes, ma'am.
Okay.
For your reference, I'm looking at page 4 of 7, this second to the bottom paragraph there.
Okay.
Did Ms. Peters indicate that she had talked on the phone with Brandy Peters at 10 o'clock p.m. on the night of the 19th?
She said approximately 10 p.m.
Thank you. Did you also have an opportunity to speak to Shayna and Darius Mount?
I did.
As well as Leon LeVar Scott and Dahana Nelson Scott?
Yes, sir.
I want to ask first about Dahana Nelson Scott. Did she tell you that when she arrived home at 11 p.m., she saw a white SUV in Ms. Peters' driveway? A suburban-like vehicle?
Let me find that. I'm sorry. Between 10:50 and 11.
Okay. And she said that she saw that vehicle there when she arrived home?
In the drive.
Yes, sir. And her husband, Leon Scott, he saw the same vehicle when he same vehicle in Brandy's driveway when he arrived home at about 1 o'clock. Is that right?
Let me see. Do you mind if I read it for a second?
That's
Read
fine.
that? Okay. I don't recall documenting anything about him seeing the vehicle, just that she had seen it. I don't recall him saying.
Okay. Now, at some point, Ms. Scott told you that she actually called the police because the dog, who was in the backyard immediately adjacent to Brandy's house, was barking out of control, correct?
Yes, sir.
Okay. And that would have been 1:30 in the morning, is that right?
She said she looked at the clock. It was 1:30. She said her clock was fast, so she believed it was around 1:20.
Okay. No further questions at this time.
Cross.
No problem.
All right, you can step down. Next witness.
This time, Your Honor, the defendant is called Darius Mount.
Come on up here, please, sir. Come on up here, please, sir. Stand up here if you would for a second. We're going to put you under oath. Face the clerk and be sworn, please.
Yes, sir.
Do you solemnly swear or affirm that the testimony you give in this case will be the truth, the whole truth, and nothing but the truth?
I do.
Well, have a seat. Slide up the microphone, please, sir.
Mr. Mount, can you please state and spell your first and last name for the record?
Yes, my name is Darius Mount. That's Darius Mount, Mount.
Where did you live in November of 2010?
3574 Jim Lee Road.
Okay, so you were about 50 yards down from Brandy's house, correct?
Yes.
Okay. At some point that night, did you and your wife Shayna hear the dog over by Brandy's house barking?
We heard what I would call excessive barking coming from that direction. I didn't know if it was their dog or not, but definitely heard what I felt like was out of the ordinary.
Out of the ordinary to the point that the police were at some point called?
Yes, they were.
Okay. Do you remember what time you heard that dog barking at?
No, it's been so long now, I probably need to have my memory refreshed, to be honest with you.
May I approach the witness, Your Honor?
You may.
If I let you review a police report which reflects your initial statement, would that refresh your recollection?
It absolutely would.
Just read that to yourself.
Okay, starting here. On scene.
Just read it to yourself.
Oh, okay, sorry.
Does that refresh your recollection?
Yeah, the first part, yes.
Okay. At what time did y'all hear the dog barking and finally decide to call the police?
It would have been probably maybe about 10 minutes before I actually called. Maybe about 10 or 15 minutes before I actually called.
Okay. What time did y'all actually call at?
The time that was stated was like between, I would say about, what was it, 1:30 or something like that?
Yes, sir. No further questions for the witness at this time.
Cross.
No question, Your Honor.
All right, you can step down, sir.
All right, thank you.
Next witness.
No further witnesses at this time, Your Honor.
Okay. State, wish to present testimony.
Your Honor, do you want me to make the emails
separately provided as part of the record for this hearing, or just rely on the ones that I've already given the court?
Well, I think we need to make them part of the record, because what you gave me yesterday is much more than what was in your motion.
Yes, sir.
I think some of that may be relevant. And we probably ought to resolve that as part of this part of it, since they're kind of related.
Just to be clear, I think that it'll be easier than just the way that packet was assembled and the way that it came. It included additional emails from Mr. Segura's email address. The email packet that I have here is just emails from the account that witness Santos previously testified he was using to communicate with victim Peters. The emails are numbered. Only 2 of these emails would I intend to introduce into evidence if the court grants the motion. It's the email that's identified as email number 8, which is on the 3rd to last page, and then email number 13, which is on the last page.
Let me see what you got. I'm not sure I'm clear on that.
The emails there are chronologically ordered as opposed to how they were in the packet that I gave the court, which is the way we got it, because that packet, they were redundant. Every time a new email was sent, it would list all of the prior.
This would be for purposes of this hearing, Defense Exhibit 2?
Yes, sir.
For purposes of this hearing, the state object to Defense Exhibit 2?
Not for the purpose of this hearing, Your Honor.
Okay. If you'd mark that note, please. And Defense Exhibit 1, remind me what that was?
That's the envelope that was discovered from the victim's home. It's already in evidence as part of State Exhibit 98. There's a copy of it in evidence for this hearing.
Okay. I'll admit it for purposes of this hearing. Okay. If you face the clerk and be sworn, please.
Do you solemnly swear or affirm that the testimony you give in this case will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Have a seat. Side of the microphone, please.
Good afternoon, sir.
Good afternoon.
Can you please announce your name for the record?
My name is Joshua Ruley. That is spelled, last name is spelled R-U-E-H-L-E.
Okay. And where do you work?
Work for the Italian.
I missed your name, sir.
First name is Joshua, J-O-S-H-U-A. Last name is Ruley, R-U-E-H-L-E. And I'm currently employed by the Tallahassee Police Department.
What are your duties there at Tallahassee Police Department?
Currently a sworn investigator.
Okay. As a sworn investigator, do you also have involvement with gang activity specialists?
In my previous assignments at the department, I've had worked gangs, and I still do have times come into work and assist with gang-related issues.
In order to work your previous assignment and then your occasional one now, to work with those gangs, did you have an occasion for specialized training, experience, and things like that?
Yes, I did.
What are they?
I've taken basic, advanced, and intermediate classes. I've attended at least 7 different workshops put on by the Florida Gang Investigators Association, which puts me at in excess of 300 hours of specialized gang training.
As I understand, I guess a lot of the gang membership aspects, and I don't mean membership being the members of the gangs, I'm talking about the law enforcement memberships. There's a lot of communication between different agencies throughout the entire state, in fact, throughout the country.
That is correct.
Okay. My understanding is there are regular gang conferences and stuff where everybody gets together and talks about gang activity throughout the course of Florida and things along those lines.
That is correct.
Okay. Did you regularly attend those kind of meetings and things like that?
Yes, I did. I attended those as a attendee, as well as worked as a regional director to help put one of those on. I've been to approximately 7 different conferences over 7 years.
During your experience there as involving the gang investigations, did you become aware of a gang out of Chicago called the Vice Lords?
Yes, I have.
What is your generalized knowledge of Vice Lords?
My generalized knowledge is they are a recognized gang that did start in Chicago and spread throughout the United States. They are part of one of the nations that I'm familiar with, but my first experience has been very minimal to no activity within Tallahassee.
Okay. Again, let's talk about that if we can. That my understanding is, again, that there are multiple different communications between the agencies regarding gang activity. Why is that so important?
Gangs move from place to place, state to state. They share, sometimes they share their method of doing things. So we want to know who's moving around the nation as well as who's becoming active in certain areas.
As a law enforcement agency, would you regularly report certain kind of gang activity if you were identified a member of a gang into some sort of database or something like that?
Yes, we do have databases, yes, sir.
Okay, and are those databases shared with other law enforcement agencies?
Some of those are, yes, sir.
And other law enforcement offices, agencies would have similar rules and regulations where they would do the reporting and sharing information?
That is correct.
As your knowledge in the gang activity, do you have any knowledge of activity of the vice lords in the city of Tallahassee at any time?
Active, no. Not from the other side. There's two people who were local who tried to say that, but there is disproven. They cannot prove any true links to them. It was more of a parroting, I believe.
It's more of a what?
A parroting, or if they saw that or learned it from somewhere else, but they were identified truly as a local hybrid gang member that had no ties outside of Tallahassee or no true ties to a nationally known gang.
And who would those be?
I believe one's last name is Farmer, and Joshua McKinney is the other one.
Okay. At any point, did you have knowledge about Carlos Santos being involved here?
No, I am not. I do not.
Do you have anything knowledge about Carlos Santos being involved in the vice lords at all?
No, I do not.
Okay. And again, would you have that knowledge if he was reported?
Yes, I would.
Okay. No further question.
Cross.
No cross, Your Honor.
All right, you can step down, sir.
Thank you.
Next witness.
Your Honor, this time state would call case in order.
Welcome back, folks. We've got another brief pause in testimony while the court gets another witness ready. We just had a police investigator on the stand saying that he's not aware of any ties between his community and a national gang called the Vice Lords. Before that, we had a neighbor of the victim on the stand saying that he heard a dog barking at about 1:30 in the morning, and the commotion didn't die down, and that's part of the reason the police were called to the scene where the 4 victims were found. Let's listen in to this next witness.
Jason Newlin, Jason Newlin.
And where do you work?
I'm an investigator at the State Attorney's Office.
Okay. And how long have you been a law enforcement officer?
Going on 15 years.
And how long have you been with the State Attorney's Office?
Going on 8 years.
Are you also essentially cross-sworn with the United States Marshal Service?
Yes, I am.
Okay. And your duties at the State Attorney's Office, did you become involved in an investigation regarding the death of Brandy Peters and her children?
Yes, I did.
And during the course of that investigation, did you have occasion to have contact with Mr. Carlos Santos?
Yes, I did.
Okay. When did you first have contact with Mr. Santos?
First time I ever interviewed him was October 18th, 2012.
Whenever you were talking and interviewed Mr. Santos, did you ask if he knew anything, had any knowledge or anything having to do with the death of Brandy Peters?
Yes, I did.
And was he able to give you any information at that time?
He told me that a guy named Leon Smith out of the Vice Lords out of Chicago killed Brandy Peters.
Okay. And did he say anything about what his involvement, being Mr. Santos's involvement, was in that?
No, he did not. He just said he heard it.
He had heard it?
Correct.
Okay. Did he give you any information about where he heard it from?
Just through his secretary. He wouldn't give me her name.
Okay. Throughout the course of this investigation, have you had many dealings with Mr. Santos?
Yes, I have.
And if you can, tell the court what those dealings are, what we're talking about.
Again, I interviewed him in June 18th, 2015 at the Leon County Jail. There were several of us present at that one. Mr. Santos just went through how he knows Brandy, that he met her through Kalo. Met her right before she had the youngest son. Thought Kalo was the youngest son's father. Told me he knew her for 6 to 8 years. Said he met her at the Wendy's parking lot in Tallahassee, and he said, Kalo said she would do business for him, so he told me he'd been in prison since 2004. Said he stayed in contact through his Mexican friend Carlos. He couldn't give me a last name of Carlos. Said Brandy owed people money. Last time he saw Carlos was in 2001. Said she did business with a friend of his named Terry White. Said she kept coming up selling dope. He did tell me his secretary's name this time was Selena Alderman, that she communicated with people. Says he met Kalo in 2000, paid Brandy between $8,000 and $20,000. Said Brandy drove nice cars and wore designer clothes.
Now, given the fact that you were involved in the homicide investigation, first of all, I'll start with the nice cars, nice clothes.
Yes.
You seen the crime scene photos?
I have.
Evidence of nice cars, nice clothes?
I have.
Is there any evidence of nice cars or nice clothes on Ms. Peters?
No, there's not.
That'd be an inconsistency you were able to identify as it relates to Mr. Santos' statement?
Yes, it was.
Okay. During the course of the investigation, did you learn that Mrs. Peters was actually on some sort of substitute income by the government?
Yes, I did.
Okay. Again, be inconsistent with the amount of money that Mr. Sharp or Santos is saying that would happen? You would pay her?
Correct. It was very inconsistent.
Okay. Do you have any other follow-up investigation that Mr. Santos gave you regarding information or whatever you could follow?
In the rest of that interview, Mr. Santos started talking about a murder that he committed in Paducah, Kentucky. We actually stopped the interview because there was a defense attorney present, so we informed him of his rights, and he continued to talk about a murder that he committed in Paducah, Kentucky, which was later confirmed to have never occurred.
And in fact, Mr. Santos, a couple weeks ago on the stand, admitted that he lied about that murder, correct?
Correct.
Did he also talk about another murder that he was involved with regarding a law enforcement officer in Atlanta?
Through another investigation, yes, I discovered where he was the subject of an investigation into the homicide of an Atlanta police officer in 1999. He was interviewed by the FBI in 2000 while incarcerated in Las Vegas. They realized that he actually admitted to committing the murder and said he was in the shootout with the police officer, but when they realized he was actually in custody at the time of the homicide, they couldn't charge him for that one either.
Okay, let me understand it. He says, I was involved in the shootout with this law enforcement officer, and that's actually a true case.
Correct. There is a true case. Officer Kinchin, Deputy Kinchin, was killed.
Okay. But during the course of the investigation, and you weren't involved in that investigation, correct?
No, I was not.
Okay. My understanding is the Federal Bureau of Investigations and Georgia Bureau of Investigations were involved.
Correct. And other local agencies. And
you talked to the agent that was involved in the FBI agent that was involved in that?
Yes, the one that interviewed Santos. Well, he was Otis Jackson at the time, actually.
Okay, so he went by a different name at the time?
He had a totally different name at the time, yes.
And that was what?
Otis Jackson.
Okay. And during the course of that discussion with the FBI agent, as well as, I assume you got some documentation that showed that Mr. Santos was actually incarcerated during the time of that homicide?
Yes, I did get a judgment and sentence from Nevada that had Mr. Santos sentenced to prison in 1997 with a release date in 2000.
That judgment and sentence, that give any indication about possible mental illnesses of Mr. Santos? Mr. Jackson, I guess.
That Mr. Jackson at the time was schizophrenic.
Okay. At some point, did you talk to or ask questions of Mr. Santos regarding Angel Avila?
Several times, actually. I went down on February 3rd of 2015 after we received a sworn statement. Actually, let me go back to the one in June 18th of 15 where we interviewed him. We actually produced a picture of Angel Avila that we've received from the immigration A file.
Now, who was there at this meeting? You're saying we?
Myself, Chuck Hobbs, John Epstein, Mark Lewis.
And my understanding is Mr. Hobbs and Mr. Epstein were actually on the defense team for Mr. Segura.
Correct.
Okay, so this was in furtherance of the Henry Segura, I guess, preparation for trial or whatnot?
Correct.
Okay. And, okay, so you showed a picture, or had a picture there of Mr. Avila?
We did.
And you showed it to Mr. Santos?
Correct.
And did he indicate he knew Mr. Avila?
He'd never seen him before in his life.
Did he say anything about knowing Angel Avila, the name?
No, we showed the picture first without giving him the name, and then we got into asking him if he'd ever heard of Angel Avila Quinones. He said, I know a Quinones, but I don't know an Angel Avila Quinones. No.
Okay. All right. Was there subsequent interviews? I think you were talking about other interviews.
Yeah, we did. I did another one. I say February 3rd of 15. It was February 3rd of 2016, where I actually had to go interview him at Tomoka CI after we received a sworn statement from the defense in this case.
Okay. And in that one, I believe Mr. Santos changed his information and said that he now knew Angel Avila.
He did, yes. He changed it to say he now knew Angel Avila, that he met Angel Avila somehow in the late 90s, early 2000s when he was incarcerated. But he told me he met him in Texas. He actually told me that that was not him that was arrested in Las Vegas on the case. That was not him that was interviewed by FBI in Las Vegas. He's contesting that entire conviction.
I'm sorry, Mr. Santos / Mr. Jackson says that he wasn't the one that was out there.
Correct. He says it was not him.
Okay.
He challenged me to prove it. He tried to tell me he used aliases, which is why I asked him if you were Otis Jackson at one time. He said, yes, that was an alias I used, but that was not me in Las Vegas. He said he would use aliases because this was confusing. To get a visitor on your list, you have to be a relative. So he would use aliases to create names and get visitors on his list. I couldn't follow what he was trying to tell me, which is what he tried to say, how he met Brandy and why he somehow moved to Tallahassee. I'd have to play that's literally how it came out to me. I was confused. I didn't understand what he was trying to tell me.
So he's saying he got moved to Tallahassee in some way to help him meet Brandy?
Correct. To get back to Brandy. It was confusing. I couldn't follow what he was trying to say.
Okay. So. Based upon the information of him providing regarding Angel Avila, did you go back and get access to or have a file sent to you from from ICE, the agency that controls the
Yes, the federal government, several different branches, but mostly was the U.S. Marshals helped me get an ICE file.
What is an ICE file?
It's an immigration file. The file contains the deportation status of Angel Avila. I also did a migrant movement status request on Angel Avila to figure out anytime his passport was checked, anytime he came in and out of any country.
And when is the last time, based upon that information, when is the last time that Mr. Avila was present in the United States of America?
He left in 2009. If I had the document in front of me, I could tell you the flight number and the time he landed in Bogota, Colombia.
So the information you provided, I not only said the date, but gave the actual flight and and everything about that.
It comes with a 10-print card. It comes with a photograph. It comes.
What's a 10-print card?
Fingerprint card.
Okay.
It comes with the photograph of the subject. It puts the date and time and the flight number for the flight that he leaves on from America, as well as the the time that he lands at the country of the destination. And he left from America and landed in Bogota, Colombia. Through the migratory movement status, we found where Mr. Avila had moved to Italy. We reached out to the Italian authorities. They made contact with Mr. Avila, who provided them with his cell phone and email address, and we contacted him, and we actually interviewed him twice via the telephone and sent an FBI agent and met him in person at the embassy in Rome.
Why would you have to send an FBI agent versus asking Mr. Avila or flying him back here?
The Italian rules are a little different. We can't bring him back because of his conviction. We would have to put him in custody to bring him back.
So he can't enter the country?
He can't enter the country correctly, no.
Okay. Did he cooperate with law enforcement?
He did. He spoke with us twice. He gave us his schedule to allow us to know which time to call him. And then he agreed to ride on a train from Trieste, I don't know how you say it, Italy, on a 4-hour train ride down to the embassy, where he met with Special Agent Pat Sanford at the embassy and interviewed for several hours.
One moment. No, everybody.
Ross?
Very briefly, Your Honor. Regarding your June 18th, 2015 interview with Santos, when you and Mr. Hobbs and Epstein and y'all went and talked to him, is it your testimony that he didn't have any information at all about Angel Antonio Avila Quinones?
He denied knowing him and denied knowing the photograph of him as well.
Who did he say Quinones was to him?
He just knew somebody named Quinones. I don't have specifically who it said he was.
May I approach the witness, Your Honor?
You may.
Let the record reflect I'm showing the transcript of that interview.
Do you want me to read it?
You don't have to read it.
Okay. Yeah.
So he actually did tell you during that interview that the Quinones he knew was a drug trafficker, correct?
Correct.
Who brought drugs through Mexico to Atlanta, correct?
He was a Mexican that trafficked drugs through Atlanta, yes.
The interview that you conducted with Mr. Avila, isn't it true that the very first thing that was explained to him during the phone interview was that there had been a mistake with the DNA?
Yes.
Okay, no further questions.
Pretty direct.
No, Your Honor.
Is somebody going to talk about what Avila said?
Mr. Newland, can he conduct that part of the interview, Mr. Newland?
Mr. Avila said he's been to America twice. Once was prior to the time when he got arrested on the boat. That was the first time he was in America was because his boat broke down. He left immediately. The second time was when he got arrested. He was arrested in the Pacific Ocean for trafficking drugs. The only reason his case was tried in Florida was because the federal system took that case and moved it to Florida. He was initially sentenced to, I think it was 30 years in prison, and then his sentence was reduced to 10 and he was released. Once he left the country, he went straight back to Colombia. The lady he was married to at the time of his arrest actually moved to Italy. So when he got out, he moved back over. He found her, went and has lived with her ever since. He checked in with Italy with the Italian authorities. He actually has to do that on a regular basis because of his visa. He left Italy one time in 2013 to go back to Colombia to help a relative build a house for a couple of weeks, and then he went back to Italy and he's been there. He works almost all day, every day. He was a student. He still is a student. He's a baker and he's a maintenance worker. He provided me with certificates with documents of paying his rent routinely, with his schedules of employment, with his class schedules, as well as record certificate to say all of through 2010 he was attending class and working in Italy.
Did you go back also and look at as I understand it, the federal government, when they sentence somebody, they have to put forth a factual statement about what transpired for someone's sentences. Did you go back and look at the one for Mr. Avila?
I did.
And did you confirm at least what he was telling you about what was his arrest and the nature of his arrest?
Yes, I did.
And did that confirm that, in fact, he was arrested in the Philippines by the United States Coast Guard?
Correct.
And then transported back to the United States?
Correct.
Other than that, had no involvement or nothing going on in the United States other than that one time that the boat broke down?
He said he would never come back to America. He has no desire to ever come back over here.
So when does he indicate he was last in the States?
When he left on the plane, I believe it was out of Louisiana and landed in Bogota, Colombia in 2009.
Any cross? Sprint?
I suppose so, yes, sir. All right, so with respect to the offense characteristics, the nature of the offense he was arrested for was nearly $100 million worth of cocaine, right?
What he told us was he was on a boat that contained 5 tons of cocaine. He actually did not know the captain of the boat that he was on, but he went down for it.
He was the captain, correct?
I don't know if he was a captain or not. He may not have known the owner or whoever sent it was, but he didn't know.
Have you read the statement of facts relative to his federal case?
Just the fact that it was 5 tons of cocaine.
Didn't they call those cases, there was a series of them, the ship captain cases?
I have no idea.
Okay. Now, when he got back to Colombia, he claimed to be broke, right?
I don't know.
You don't remember that?
That he was broke?
Right.
He'd been in prison for 10 years.
Right. And his wife was working as a tutor or something in Italy, right?
She'd moved to Italy, yes.
Working like as a tutor. It's not like she was a
I
CEO.
I don't recall exactly what she was doing.
Okay. Somehow he gets the money together for a transatlantic flight over to Italy, correct?
I don't know how he got to. I know he flew to Italy.
Mm-hmm. At some point, his passport was stamped as having been in Spain as well, right?
I think if it was, I'd have to look back at the emails between me and the U.S. Marshals. I know it got stamped twice. I do know that.
And he claimed to be unemployed when he first got to Italy because he couldn't get a work visa, right?
Correct.
And again, his wife was still doing whatever she was doing to make ends meet. But he got another round-trip transatlantic flight back to Colombia within short order, correct?
Probably 3 years later.
Mm-hmm. Now, the records that you referenced regarding his class schedule, those weren't like daily sign-in sheets, correct? It was just, this is his class schedule, this is his work schedule, right?
I'd have to look at him to see again.
No further questions.
Redirect. Later. All right, you can step down. Very next witness.
Your Honor, we can pause for just a minute. I just got some information about a potential other witness.
Say what?
Can we pause for just a minute? I got some new information on a potential new witness that is really new regarding Mr. Santos.
What do you want to do?
Take a 5-minute break.
5-minute break, Your Honor, please.
Okay.
Thank you.
Yeah, just leave.
And welcome back. The witness on the stand is a state's attorney's office investigator who really seemed to deflate so much of the defense's case very, very quickly. This particular individual who the defense is trying to say was the person who claimed responsibility in the crime, this last witness said has a history of claiming responsibility for crimes he could not have ever committed. This witness was an investigator with the state's attorney's office. His name was Jason Newland, and he said that this person that the defense is really trying to throw at the jury at one point confessed to a crime in Paducah, Kentucky, which never even occurred, and also claimed involvement in another crime, I believe he said involving the murder of a police officer, but he was in custody when that happened. So apparently this guy that the defense is trying to say may have been the real killer has a history of confessing to crimes that he didn't commit. Julie Rendelman, LawNewz trial analyst, former prosecutor, current criminal defense attorney, person of multiple titles.
You don't have to name them all each time.
Yeah, so, you know, I've heard of people doing this before. I mean, is that the thing to do if you're incarcerated, to just start telling everybody that you were involved in every crime under the sun?
No, I think I heard that there may have been some type of diagnosis of him as being potentially schizophrenic. So, you know, no, that it's not the norm to confess to multiple crimes, especially if it's impossible that you did them. But certainly this is a huge undercut for the defense's position in wanting the jury to hear that. And quite honestly, if I were the defense, I'd be thinking twice as to whether or not I'd even want the jury to hear any of that, because you know, I don't want the jury now to think that I'm pulling something over on them. So, you know, if the jury were to hear that he confessed, but then confessed to all these other crimes he couldn't commit, the jury's going to be like, why is he testifying? And then that may undercut the defense's case.
Okay, so, you know, this is all happening outside the presence of the jury. They've had all these evidentiary hearings with all these neighbors and all these other people that apparently the defense wants to put on the stand. What's the purpose of the evidentiary hearing, and do you think there's a chance the jury's ever going to hear any of this?
I think it's possible they won't hear it. I don't know whether the judge is making a determination as to they're going to hear it, but who they're going to hear it from and what they're going to hear, or whether he's deciding whether they're allowed to hear it at all. One would argue that, you know, what the witness is talking about right now goes more to the weight of it and not whether or not it's admissible, because, you know,
put it in, and then with the side note, and the prosecution can certainly cross that witness about all the other times he admitted to something that it didn't happen. Although there are some hearsay evidentiary issues that are kind of coming into play.
I'm trying to unravel the evidentiary issues along with you right now here, and I'm remembering back to the old relevance one, which is the threshold inquiry. You know, if it nudges the case one way or the other, it's relevant. You know, whether or not vanilla is the most favorite flavor of ice cream has nothing to do with this case. That goes out.
Right.
But this stuff is all relevant in a way, but judges can also exclude if the probative value is just not there, if the relevance isn't really clear, if it's just going to cause undue confusion or waste of time.
Right.
Okay, I'm wondering if this stuff just gets so confusing and is such a waste of time. Okay, so let's play it out here. Let's say the defense is saying, I want to get this guy on the stand because he said to some other people in prison that he was involved in these murders. Okay,
Right.
Well, first of all, the guy who's apparently said, I'm pleading the fifth, I'm not doing anything.
Right.
Okay, he doesn't want to admit that he either did or didn't say it, or that he was or wasn't involved. So wipe that off the table. Then you got hearsay issues. So even if we wipe those aside and say these people are going to be allowed to testify that he did say it, what's the point if then the police are going to get up there and say this guy has a history of confessing to crimes that there's no way he could have committed because he was in jail or prison when they happened.
So you can, and as a defense attorney, you may think that's helpful because confusing the jury is sometimes a good thing, because when you confuse a jury, they're less likely to be able to focus on kind of the issue at hand, which is whether or not the defendant on trial is the person that's responsible for what happened. At the same time, you can also turn off the jury if you're throwing evidence at them that is so clearly shown to be false. Keep in mind, in this case, you know, the defense has things to work with. They have evidence that the DNA does not belong to the defendant. Instead, it belongs to potentially other individuals. So they have things to work with that kind of works in their favor. It's a question of how far they want to push it. And sometimes as a defense attorney, you can push it too hard and the prosecution and the jury kind of goes the other way because of that.
I could see that happening here too. If they have to sit through all of these witnesses and all of these accusations that somebody else was really involved, and then the police officer gets up in the stand and says, well, wait a minute, we looked into this guy.
Exactly.
None of this stuff makes any sense. If I were on the jury, I'd be sitting there looking and saying, why did you just waste my time with this? I mean, I don't believe that guy.
Right, and it starts to, and then it starts to question every single other witness that either the defense called or the cross-examination that the defense did. So you know, you have to be kind of careful in weighing your options as a defense attorney. Just because it on the surface seems like it's going to help you doesn't necessarily mean you have to go for it if it's not going to help you in the end.
Yeah, I'm also wondering, okay, well, maybe the jury should be making this call, but I'm wondering if it's even going to get to them because you've got all the hearsay issues involved.
No, it's hearsay issues, and then I guess on top of that, it's a question of, is there any veracity, I mean, you know, to this individual making the statement, especially when we know for a fact that that at least on 2 occasions, he clearly couldn't have been involved. I thought that there was some connection between the person that made these statements, this other individual that is claiming to have hired this hit, and the girl that was killed. But maybe I'm wrong. I thought there was some evidence other than his statement that linked the 2 of them to each other.
There's some evidence that she was potentially involved in some kind of drug activities, and some other people who said that she may have been afraid of him, if I'm remembering this properly.
Or at least afraid of the cartel, and I think that was I think she texted about that, I think, a few days before.
There's a letter that one of the neighbors talked about, the presence of some letter that she was afraid of people involved in this cartel, things like that. But, you know, I go back again to the various police officers who have been on the stand. There have been a couple this afternoon saying there's no evidence that a lot of this stuff was going on, that maybe she was just trying to, meaning the victim, was just trying to pump up her own perception in the community, because there were a lot of people in that community dealing drugs.
Right.
And there was this rumor, oh, she's got really nice cars, she's got really expensive clothes, she's got Tiffany, you know, China, that she eats off of.
But there's DNA from another drug dealer in the house as well, and that can't be ignored.
And that's the next thing that this state's attorney investigator, who was just on the stand, was talking about right before the break ended. And Mr. Avila, that's part of his name. That's how he was referred to on the stand. But that's where it gets really interesting, because that guy's DNA is in the scene. He had just gotten out of prison in Florida. It was a federal prison in the state of Florida right before the crimes. And then not long after, he took off and he's living in Italy,
right.
But they can't get him out of Italy.
Right.
So, okay, well, what's going on with that?
I mean, I thought the argument was, I know it was a CODIS hit, so it was like I guess they compared DNA to one of the items that was inside of the apartment, and obviously there was DNA on file of this individual, and it was a hit. So I guess the prosecution's position that initially was that it was hearsay because they couldn't actually get his physical DNA; they had to get it from an actual computer system. But I also remember, and again, I could be wrong, that the DA didn't provide this for a lengthy period of time to the defense, which is disconcerting in and of itself. I think that's highly probative for the defense in terms of kind of questioning whether or not we have potential suspect or additional suspects, considering I know under the nails is, I think, a female DNA. So we have even a plethora, as I've said before, of other possible people that could be involved in this case other than Mr. Seura.
Yeah, really interesting trying to unravel all of this stuff. And I will admit for those watching that I've been paying a lot more attention to the Gasper case out of Cleveland, Ohio. The jury there is still deliberating, and the judge is going to let them go until about 4:15. So I was paying a lot of attention to that case and not as much attention to the Segura case, and I'm trying to get myself caught up very, very quickly. Julie Rendelman has done her homework, though, and
not today, but yeah, but I admit that I think I'm fascinated with all the look. Anytime you have DNA, cell site, all these different things kind of going back and forth, it makes for at least an interesting case.
And I just jumped into the chat room on live stream here to clear up a point there. We're talking about a couple of different people. So the defense is going to want to point the finger at one of two people. First is this guy who was in a prison cell who claimed that he was part of a cartel that ordered a hit on this victim, and that the 3 children were just casualties of that drug war over drug debt. Okay, well, the police say that person has a history of making things up of that nature, and that he has claimed responsibility in crimes that he could not be a part of because he was incarcerated when they happened, and his stories just don't make any sense. That testimony just flew by this afternoon in detail. If you want to watch it again to unravel it all, great, it's available there for you. So that particular person is not willing to testify as to what he was bragging about behind bars. So that's one person. The second person is this person who's apparently now in Italy, whose DNA was found on the scene. That's Mr. Avila. Mm-hmm. And that's where they're trying to go now, is to say, wait a minute, we don't know what's up with that DNA on the scene, because this guy, as I said, was in prison, then he left, and then he's over in Italy. Apparently he's a baker now and a student. That's what his official title is over there. But they're trying to figure out what his involvement is. Now, I'm personally just willing to dismiss the guy who claimed responsibility behind bars and say there's nothing to see there, let's move along. But the DNA on the scene from this other person, now that I'm interested in.
Well, you may be right about the first one if there's nothing else tying them to each other other than him merely saying that it happened, and we know kind of that he's admitted to all these other things, and they didn't hold to be true. Keep in mind, someone can lie about something and still be telling the truth about something else.
That's true. That's true.
But,
I think
but again,
the links, the links are so tenuous that are there. There's a fear of, I didn't, maybe somebody watching picked up on it, but I didn't pick up on the links being very clear in the testimony. It may be that I just missed something, or it may be that the links just aren't that clear. But if they tried to make them, but they didn't stick, at least not in my mind.
But you can't ignore the DNA at the scene.
That you can't ignore.
And that's not the only DNA at the scene. Remember, there's DNA under her nails, and I don't believe the DNA under her nails is Avila or the defendant. I think it's another individual that's potentially, that you can't rule out, who I don't think they were able to figure out who that was, but I thought it was a female DNA. And so you have, it's not just that person, it's DNA that's in areas of which one questions how that DNA got there, because it's not simply just someone coming to visit, to have some pie, with the victim. It's someone who potentially could have had a physical altercation with the victim.
And there's certainly evidence that that happened. So, we're going to go back to the courtroom in just a second here. It looks like the judge is just about to take the bench. So let's listen back in again. This is the trial of Henry Seura in Tallahassee, Florida. He's facing 4 first-degree murder counts. Those charges carry the death penalty. And we're in an evidentiary hearing on exactly where the defense is going to be able to go in this case.
And that would be the doctor's report as to Mr. Santos's mental illness or mental capacity.
Both the Dr. Hudson's reports?
Yes, sir.
Okay. They're part of.
I don't want to talk just to talk. The court has had an opportunity to read the case law that I've supplied. That's essentially what my argument is that the defendant has a 6th Amendment and 14th Amendment right to put before the jury evidence that someone else has confessed to committing the crime, that his right to do so is superior to any concern about hearsay. The case law all makes that clear, and that it is inappropriate to engage in a reliability, a credibility analysis when determining the admissibility of that confession. The state's free to impeach him with properly admissible evidence if the court decides to admit the transcript of the motion in limine hearing, but the weight of that confession is something that the jury should consider. That is essentially the defense in this case. We shouldn't be relegated to arguing reasonable doubt when the jury, when there is an alternative explanation that is corroborated by all types of evidence, physical evidence, forensic evidence, circumstantial evidence. It should be up to the jury to decide the credibility of the confession.
Would you want to comment on the emails? I guess the letter is already in evidence, so that's not really an issue. It's
Yes, sir.
Emails.
The emails I would suggest are admissible for 2 reasons. Although one of them is not really my reason, I'm just going to speak to it because the court has routinely, in discussing the issue, mentioned that it seems to be going to state of mind. That's not really, although I suppose it necessarily glances that on the way to my point. But to the extent it would be for state of mind, I would suggest that it's exactly like circumstances when the defense is that a victim committed suicide. Essentially what we are claiming here is that the victim's own choices about associations, her own conduct, is what ultimately caused her death. Choosing to be involved in a drug trafficking organization with a dangerous person is what caused her death here. And to the extent that it is state of mind, just as in those suicide cases where all of the case law says it's proper to admit statements regarding a victim's state of mind, it would likewise be proper here. My real point, however, in admitting the emails is that it's corroborative of Santos' claim that he is involved in some sort of drug trafficking organization and scheme with Brandy. The fact that she is acknowledging a clear and present danger exists for herself and her children as a result of whatever that arrangement or interaction is with Santos corroborates directly his testimony, and I would submit, in light of the disputes about what the DNA shows, is the most compelling piece of corroboration. And on that basis, I would say that the defendant likewise has a 6th and 14th Amendment right to introduce that evidence in order for the jury to make fair consideration of Santos' confession.
Mr. Hughes.
The problem with the corroboration, Your Honor, is that the only person that corroborates it is another statement by Mr. Santos. And you can't corroborate your own statement by your own statement. And that's exactly what's trying to happen here is that as to the emails that were just discussed, the only way they corroborate Mr. Carlos's statement, or Mr. Santos' statement, is if we use Mr. Santos' interpretation of those emails. We don't have Ms. Peters here to say what she thought those emails were about. And on their face, they don't. There is different, obviously, up to interpretation. Mr. Santos seems to put a spin on it that this is a code word and that's a code word and things along those lines. And there's just no way to corroborate that outside of Mr. Santos' statement. As it relates to the hearing that we just had regarding the testimony, again, the only thing that corroborated Mr. Santos' statement was his statement to another person. and a statement to another person. There's nothing evidentiary-wise that corroborates any of those statements, and in fact, it goes directly against that Mr. Avila was deported, wasn't involved in this thing. In addition to that, the fact that Mr. Santos has previously confessed to 2 other murders, one of which was high publicity. We have a high publicity one here, and he is self-admitted that he was lying about confessing to the murder in Kentucky. We know he was lying about the murder as it related to the law enforcement officer up in Atlanta because he was incarcerated at the time and could not have committed that particular murder. And now here we are in a 3rd murder that he's confessing to, and of course the state would submit that he is, there's nothing that substantiates his statement. There's nothing that even the witnesses we heard here. Even if you do believe that Ms. Peters was in fact selling narcotics, as Ms. Garland said, it still is a very, very small amount of money. Whereas Mr. Santos is saying that she was bringing all this money, all this drugs in from Brownsville, Texas to Atlanta and getting paid for it. At no point did he say she was selling narcotics. It was that she was bringing it transporting it to and from these locations. So even that doesn't corroborate Mr. Santos' story. But the biggest issue we have, there's obviously always a balancing act between the court that the court must do as it relates to testimony that's put before it. Clearly, the court cannot judge the credibility of a particular witness. That is the job of the jury, and there are case laws out there that talks about the court cannot sit there as a person and judge the credibility of a particular person. However, it is the gatekeeper for reliable testimony. And that is testimony when you take it as a whole, not just judging the person that's making the statement, but when you take the testimony as a whole in its entirety and judge it against facts, other facts of evidence, or would potentially be in evidence, judge it by the evaluation we have of the doctor in this particular case as to the mental illness of Mr. Santos, the fact that he is grandiose, he lives in fantasy, and narcissistic in that he wants to bring the attention to himself. You take that in addition to all the other information, you take it as a whole, and the testimony on its face as a whole is unreliable. And even then, when we look at this even further, and the court's inclination, as we talked about earlier, of what are the identifier of the issues, none of the witnesses that we heard from identify or deal with those issues that the court properly put forth. Those, of course, were the argument of the state. As it relates to due process, there has to be, chambers has to be met, and in that particular situation, it talks about the cross-examination. In that particular case, if you're going under the due process and under chambers, there has to be an availability for cross-examination. Under admission of against penal interest, again, there has to be available for cross-examination. And then if you go to former testimony, that's a little bit more lenient in some ways. However, as the court's already put forth, unfortunately, the state during the cross-examination of Mr. Santos was cut off by Your Honor, and we weren't able to fully do the cross-examination of Mr. Santos. In addition to that, you look at Earhart 8042, and it talks about in a situation where matters affecting the credibility that did not occur until after the first trial, or in this particular case, hearing, which would be the testimony of Mr. Santos, may result in the earlier cross-examination being insufficient to test the credibility when the testimony is offered at a subsequent trial. And that's exactly what we have here. For a long time, we've been trying to get mental illness, evaluations and things like that that were done on Mr. Santos. We had reason to believe he was in fact schizophrenic. We tried to explore that through whether or not there was a PSI information that was done when he was sentenced for federal court. Eventually, when we were told it didn't have it, nobody had it. In this particular case, we end up in a situation, of course, up till a couple of weeks ago, Mr. Santos had been saying that Leon Smith was the one that committed this, and he just had heard it through the grapevine, essentially. Well, all that changed a couple of weeks ago, and of course now Mr. Santos' statement was no longer hearsay of what he had heard, but it became, I was directly involved in this, and it changed everything as it relates to Mr. Santos' previous statement. So you take that, and now all of a sudden we start looking towards cross-examination that we were able to do during that hearing, and we did not have the information available to us that was subsequently done on his evaluation by the doctor, I think it was Dr. Hudson in this particular case, for us to utilize that during cross-examination. And given the results of that doctor, and given the fact that he was, the findings of the narcissism and the delusional aspects of Mr. Santos in confessing to multiple times to multiple murders that he didn't or could not have done, that was not available for the state for cross-examination during that hearing and the testimony of Mr. Santos at that particular time. I would submit to Your Honor that that certainly is a matter that affects the credibility of Mr. Santos' statement that we would have liked to have had cross-examination on, and it would, in fact, something that we weren't able to do, and it certainly should affect the credibility of Mr. Santos' statement, and it is not a cross-examination we were able to do, and it should render the prior cross-examination that we were able to do insufficient for purposes of admitting that that testimony at a later hearing or later trial.
Further, Mr. Prince?
Only if the court wants me to address a specific point.
No. Fairly confused set of circumstances, but ultimately, bottom line is I am not going to allow the hearsay statements of Mr. Santos. I am not going to allow into evidence the emails. Let me analyze how I've arrived at that. First, as to the emails, I think that's the simplest. They're strictly to show the state of mind of the victim. They are not admissible. The state of mind of the victim is not relevant. The fact she was scared of something only goes to her state of mind. There is no other exception that applies, and they're hearsay. If you look at them, I mean, they could be construed in a number of different ways. And that, you know, if you look at the first email in the chain, essentially you got Mr. Santos proposing some kind of Nigerian fraud scheme and all the wonderful reward the victim is going to get from taking part in this fraud scheme. So I don't know what those emails were intended to mean. I think they could be construed in a lot of different ways. But again, I think they strictly go to the state of mind of the victim, which is not relevant. As to Mr. Santos, I've outlined there are 3 potential ways it could be admissible under 90.804 sub 4 as an admission against interest. The statute provides a statement tending to expose the declarant, which would be Santos, to criminal liability and offered to exculpate the accused is inadmissible unless corroborating circumstances show the trustworthiness of the statement. I find the circumstances totally undercut the trustworthiness of the statement. Frankly, I'm not sure that anybody would believe what Mr. Santos said. Frankly, we don't know what he'd say until he got on the stand. He's given 4 or 5 different versions of what he has to say, and we'll go through that just a little bit more. The due process issue, the Chambers analysis, and I've read all the cases provided by the defense and gone back through them. Chambers provided a 4-step analysis to decide whether the evidence should be admissible. The Florida Supreme Court has since made clear that that's not, I forget what their wording was, but essentially not etched in stone, that those are the only ways they're admissible. Ultimately, it's a decision whether there is sufficient indicia of reliability to make them admissible. But each of the factors to me, would cut against the admission of them under Chambers. First, whether it was spontaneous. The earliest version we have is what was given to Mr. Whitfield back in the summer of 2012, which is 7 to 9 months after the murder. Certainly not spontaneous, not to a close acquaintance. As Chambers said, a statement made spontaneously to a close acquaintance shortly after the crime occurred. That's certainly not the case here. Now, I think the defense has gotten a little mixed up in what the cases say as to whose credibility I determine. I think the case is real clear. I cannot determine the credibility of Mr. Whitfield. That would be for the jury to do, but it is absolutely my duty to attempt to make some determination as to the reliability of Mr. Santos' statement. I don't make any determination as to Mr. Whitfield's credibility, although he certainly would have some problems. But the problem with that statement is it directly contradicts the physical evidence in the case. Says that the door was left open, the boy was the first one killed, he was the one inside the door, that was the first person the police found. All that is clearly inconsistent with the facts of the case. The second, and it really kind of goes into the second criteria, the statement is corroborated by other evidence in the case. Neither the statement made by Mr. Whitfield nor the more recent statement made by Mr. Santos in court is corroborated by the physical evidence in the case. The statement was self-incriminatory and unquestionably against interest. That may be the case, although there has been thrown out the possibility that Mr. Santos was under the belief that that statement could not be used against him to prosecute him, which would undermine that. But I think on balance, I would have to say factor 3 is only one of the factors that's been shown to be established. And then the last factor, of which I think is more critical of them, if there's any question about the truthfulness of the out-of-court statement, the declarant must be available for cross-examination. A basic tenet of our legal system has been to allow the parties the ability to cross-examine a declarant. Allowing this would prevent the state from having any ability to cross-examine the declarant. I think that's an important factor. To cut into the reliability of the statement, we've made various statements to law enforcement in Gordon, including what Investigator Newland has said, his prior testimony from March 3rd, 2014, which should be made part of the record. I think it is already part of the record. To Judge Fulford was 180 degrees from what he said in front of me recently. The reports of Dr. Hudson, although he found him to be someone who could tell the truth, basically was a grandiose personality person with a certain certainly suggests that there are questions as to the truthfulness of the out-of-court statement, and ultimately I find that there is little indicia of reliability to what Mr. Santos has to say. I guess the last theory would be the former testimony theory. Again, I've already listed or already commented on that. Fortunately or unfortunately, I cut off the cross-examination of the state. That was not intentional. I had no idea we would be considering the prior testimony of Mr. Santos at the time, but I think legally the only issue before the court was legal admissibility, so credibility was not an issue. It'd be grossly unfair to let the statement go to the jury without the state having the ability to cross-examine and show the various inconsistencies that Mr. Santos has made. All of these rulings are subject to review or reconsideration, I guess would be the better word, should we get into a death penalty proceeding. In a death penalty proceeding, there is a more relaxed standard of evidence. My rulings may not apply to that stage of the proceeding if we get to that. I think the next thing we need to resolve is the statements made to Mr. Washington by Mr. Paramore. We ready to do that?
Your Honor, if I can real quick, the court had mentioned that it was 8 months from the statement of Mr. Whitfield from summer of 2012. The murders actually happened in November of 2010. That is almost 18 months.
Okay. My years were off. You're correct. It was summer of 2012 is when the statement was made to Mr. Whitfield.
Yes, sir.
My math is not very good. Thank you for correcting that, Mr.
Yes, sir.
Hughes.
And finally, is there any finding as it relates to the new information not subject to the not available to the state for cross-examination of Mr. Santos at the time of the hearing?
I don't know what you're talking about.
There's the report from Dr. Hudson is subsequent to the cross-examination at that particular hearing. The state did not have it available.
Well, I mean, I think there were many areas of cross-examination that you could have used, and like I say, I think it'd be grossly unfair not to let you have cross-examination. Mr. Santos, frankly, after proper cross-examination, I don't think anybody would believe Mr. Santos. But anyway, that's my ruling. We ready on, you have Washington available? All right, we're going to start with Mr. Washington. Mr. Prince, you want to start with Washington?
Yes, sir.
All right.
Your Honor, did you want to, at some point, are you going to address Dr. Dela Cruz's testimony to admissibility?
Okay, I'm sorry. You had an argument as to its admissibility. I thought Mr. Fuchs was going to wrap that into any closing argument, but what was your theory on that?
The theory is set forth in the motion.
Well, I never saw your motion, so it's a little hard for me to know what your theory was.
Okay, but basically,
things go to the clerk's office, and 3 days later, I see them. Okay.
The motion in limine basically indicated that there was not a basis in Dahlberg Fry for a scientific opinion, that was all based upon opinion hearsay, things he read off the internet, and so that it would not qualify and should be excluded as testimony both in this hearing and at trial should it be submitted.
Well, I'm not going to decide whether it's admissible at trial at this point in time. If you'll give me a copy of your motion in limine, I'll consider it. Frankly, I didn't put much credence in what the testimony that was presented. It was basically based upon Mr. Santos' statement, so it kind of begged the question. But give me your motion in limine. I'll rule on that prior to trial. Swear the witness.
Do you solemnly swear or affirm that the testimony you give in this case will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Mr. Washington, please state and spell your first and last name for the record.
My name is Gregory Jerome Washington. Last name spelled Washington.
You know somebody named Paramore Griffin, Demario Paramore, correct?
Yes, sir.
Okay. What is his relationship to you?
We call ourselves cousins.
Okay. You were close with him back in 2010?
Yes, sir.
Okay. At some point prior to you going and talking to the Tallahassee Police Department about what he had said, did Mr. Paramore make statements to you about Brandy Peters and her children's murder?
Yes, sir.
And what did he tell you?
He told me that him and Haywood Griffin killed the family.
And did he say why that they did that?
Basically, he said that because they owed it money and they were playing games and stuff like that with the money, with dope.
Did he mention specifically that he and Mr. Griffin had fronted Ms. Peters drugs that she had not paid them back for?
I believe so, yes, sir. Yes.
Okay. Did he tell you why they had killed the children?
They didn't want to leave no witness behind.
Okay. At some point later, you were documented by the Tallahassee Police Department as a confidential informant?
Yes, sir.
And after you were documented, you were working with the Tallahassee Police Department investigator, correct?
Yes, sir.
All right. And in the course of working with that investigator, did they affix you with a listening device, a wire for lack of a better term, and send you back to talk to Mr. Paramore again?
Yes, sir.
In the conversation that you had with him the second time, did he essentially say the same thing in response to your question?
Yes, but he basically admitted, at one point in time, he admitted to, first when we was doing it, he told me outside of the wire that him and Haywood Griffin committed murder. Then over a couple of transactions I did with him, he never mentioned until the last transaction I did actually with him, he basically said, yes, me and Wood killed the family on wire. But before that, he never mentioned it on wire. But when I went in the wire, the last time I did the drug transaction, he admitted to committing the murder on wire.
And did he give the same reason for killing the children on wire?
I don't recall.
Okay. No further questions at this time.
Right. Mr. Washington, you've kind of made a career out of being a snitch, haven't you?
Yes, sir.
When all this stuff happened back in 2010, you were on the phone trying to actually call me and other members of the state attorney's office on it was a daily basis, multiple times a day, were you not?
Yes, sir.
And isn't it true that you were actually banned from calling the state attorney's office because your information was so unreliable at that time?
Yes, sir.
And we cut off your phone record, your phone stuff at the jails because of that information, correct?
Yes, sir.
Okay. And then this one came forth, and because of the importance of this case, we actually agreed to allow you to wear a wire.
Yes, sir.
All right. And it's because you told us that Mr. Paramore had said this to you.
Yes, sir.
Okay. And just for clarification, it was Mr. Paramore that said it, not Mr. Griffin, correct?
Yes, sir.
Okay. And then you wore that wire on this time, and you did a multiple series of buys, and you never could really get him to say anything, and we'll get to the last one in the first couple of times you try to do it, right?
True.
And then the last time you said it, you actually just kept hitting him and hitting him and hitting him and hitting him with it. And finally he said, you asked him about the kids, and he said, I guess they couldn't leave witnesses.
Yes, sir.
Never said I did it. He just simply said the kids were killed because they couldn't leave witnesses. Isn't that
Yes,
what he
sir.
said? Isn't that what he said?
Yes, sir.
Okay. No further questions.
Redirect.
No, Your Honor.
Right, you can step down. Who would be next?
Investigator Vinny Bosio.
Okay. What were you asking, Deputy?
May I step back, Your Honor?
Face the clerk and be sworn, please.
Do you solemnly swear or affirm that the testimony given in this case will be the truth, the whole truth, and nothing but the truth?
I do.
Investigator Bosio, can you introduce yourself, spelling your first and last name for the court reporter, please?
Sure. My first name is Vincent Bosio, B as in boy, O-C-C-I-O.
Okay. At some point, in March of 2011, you and Investigator Roberts, Tallahassee Police Department, documented Gregory Washington as a confidential informant to use in the Brandy Peters murder investigation, correct?
That is correct.
That was based on him relaying to you all that his cousin, person he called his cousin, DeMario Paramore, had confessed to committing the murders, right?
That's correct.
Okay. At some point, was he documented, and did you wire him to go talk to Mr. Paramore?
Yes.
During the course of those recorded conversations, did Mr. Paramore allude to the fact that he had some participation in the murders?
He made a comment about it.
That's a yes then?
Yes.
Okay. At some point, did Paramore actually state that you don't leave witnesses, dead men don't talk?
That's correct.
No further questions.
Cross.
Subsequent to that, Mr. Paramore was called in and did an interview, correct?
That is correct.
Okay. And at which point he told you that he didn't really have a phone during that time period, but he utilized his girlfriend's and his, I think it was his brother's phone during that time period.
That is correct.
Okay. And also during this time period, law enforcement went out and got surveillance videos and stuff like that, and there's nothing that indicates in any way, shape, or form that Mr. Paramore was involved in this particular homicide, is there?
Nope, that's correct.
Okay. Mr. Griffin, no information at all that he was involved in this homicide?
That is correct.
Redirect. Detective Bossie, you had initially stated that he was corroborated by alibi witnesses, DNA, and cell phone data, Mr. Paramore, right?
That's correct.
Okay. But you guys never actually got a chance to go talk to his alibi witnesses, correct?
Never what?
Never actually got a chance to go speak to his alibi witnesses.
The ones that he provided at that time, no.
Right. And the DNA wasn't submitted until after his deposition in after your deposition, I'm sorry, in 2016, correct?
That's correct.
And as far as the cell phone information goes, nobody ever went and talked to his brother and obtained the phone number from his brother. All you had was the prefix, right?
Actually, we didn't have to.
You didn't have to what?
We didn't have to go talk to his brother at that point.
To get the phone number?
Correct.
Why was that?
During the deposition when you asked me, obviously it was several years later, and job tasks were spread out throughout the investigators. It turns out that 5 court orders were done in this case to include Paramore's girlfriend, who at the time he said was using her phone as well. We were able to manipulate and look at the phone numbers and the 386 prefixes, who was common with Griffin. We were able to do court orders on them as well.
Did you guys ever go verify with Paramore's brother that that was the particular 386 number he was using at the time?
No, sir.
Okay. I know it's not your job, but were you ever aware of what Haywood Griffin, who was supposed to have committed the offense with Mr. Paramore, according to Mr. Paramore, what his phone records showed?
No, sir.
Okay. No further questions for the witness at this time. Step down.
Okay.
Further testimony?
Call John Sawicki, Your Honor. He's an expert witness, Your Honor. The state's going to stipulate to his credentials so I can get to the point.
He's already testified in front of me once.
Yes, sir.
Face the clerk and be sworn, please.
Do you solemnly swear or affirm that the testimony you give in this case will be the truth, the whole truth, and nothing but the truth?
I do.
Mr. Sawicki, can you please state and spell your first and last name for the court reporter?
John Sawicki, John Sawicki.
And in the case of reviewing information for this case, did you have an opportunity to review call data records for phone number 850-241-3381?
I did.
And who is the subscriber associated with that record?
Hayward Griffin.
May I approach the witness, Your Honor?
You may.
Purposes of this hearing. Is that a true and accurate copy of the records that you reviewed relative to Mr. Griffin's call data and tower data for the period around the murder in this case?
This appears to be consistent with what I reviewed.
Okay. Did you have an opportunity specifically to analyze the data related to the towers and sectors with which his handset was communicating during the night of the murder?
I did.
And what did that information reveal?
The handset was connected predominantly to 2 towers, and if I could refer to the records for just a moment.
Yes, sir.
Beginning at approximately 6:23 in the evening, and continuing through
6:23 p.m.
6:23 p.m., Your Honor. Continuing on through the most of the rest of the evening, and actually into the next morning, 11:19 the next morning. The handset's connecting to 2 towers. Sector 2 on Tower 232 and Sector 1 on Tower 157.
And what towers and sectors, where are those towers and sectors relative to the victim Peter's home?
I've actually got maps plotted that would show them. That would probably a little easier than describing it, but they're both located a mile to a mile and a half away from the crime scene.
Okay. And the individual sectors, are they those sectors with which the handset was communicating facing directionally the victim's home?
That's correct.
Okay. And was his handset within range, had his handset been at the victim's house, would his handset have been within range of each of those towers throughout the night?
I haven't seen anything that would indicate it was out of range. They're approximately a mile and a half away. These towers would more than likely be able to communicate with a handset located at that house.
So is the, if the handset were at the victim's house, are the cell phone's records consistent with that location?
Yes, they are.
Okay, no further questions.
God.
What cell phone company does he have?
Sprint.
Okay. As it relates to Mr. Griffin, you aware where Mr. Griffin lives?
I actually am not.
You're not aware of Mr. Griffin. If I were to tell you that he lives right in the middle of that area and not very far from the victim, you didn't do any comparisons to determine that he was actually at home during that time period, did you?
I don't know that we could do a comparison at this point to show that he was actually at home.
You don't know that the cell phone tower information that you've got, if that was his home, was in that Sector 1 or something like that, that it would show that he was there around his home?
You could show that he was in the general area, yes, but it couldn't show that he was at home.
Okay. The cell phone data that you have there, the events that are occurring that you're talking about that are throughout the evening into early morning hours, they are both active and passive, are they not?
That's correct.
So he's actually utilizing the phone?
Yes, sir.
So essentially, in order to commit this homicide, he would have to be texting, calling, or whatever it is while he's beating down Brandy Peters, correct?
I don't know that that is correct.
Okay, no further.
Redirect.
Why do you say that you don't know that that's correct?
Because, and I'll have to refer to the records again here for just a moment, but I don't believe that there is constant phone activity throughout the entire evening. And what I mean by that is there certainly could be blocks of time in there where the phone's not actually being used that Someone could certainly be doing something other than utilizing the phone.
Same as with the records for Mr. Segura that you reviewed. There are
That-
periods of inactivity.
That's correct.
No further questions.
Your Honor, I'm sorry if I have to recall them for the state's purposes, that's fine. Do you have those maps you're talking about?
Yes, sir.
And the 157 and the 232 are the two towers that we're talking about?
That's correct.
Okay. Your Honor, I'd like to move these into evidence for the purposes here.
Any objection?
No, Your Honor.
How many sheets are there?
There are 3 sheets, Your Honor. We can mark them 1A, B, and C.
1A, B, and C for purposes. I'm afraid we get it mixed up because of evidence. You keep it separate? Okay. Be for purposes of this hearing.
No further questions, Your Honor.
You want to do anything with the map, Mr. Prince?
No, Your Honor.
All right, you can step down. Who would be your next one?
No further witnesses at this time, Your Honor.
Okay. So does the state have testimony?
Your Honor, I wasn't aware Mr. Sawicki was going to be testifying about any kind of cell phone records. Mr. Corbett is not still in the courthouse. He is at the Tallahassee Police Department. I would ask to give a break. Mr. Corbett can testify the fact that Mr. Griffin's home is within that tower information, that tower location.
I'll just stipulate to that fact. I know it is.
All right. We'll accept that. You have further, Mr. Fuchs, you wish to present?
No, nothing further than that.
Okay. All right. You can be heard, Mr. Prince.
It's essentially the same argument as with respect to Santos. There is evidence which is corroborative of the statement in the form of the cell phone data. The expert testified that the records are consistent with the phone being in the area in the directional sector of the victim's house, combined with a confession that was repeated once on wire and once not on wire. I would suggest again that the credibility of that confession is something that is proper for the jury, not the court, to consider in determining what to do with it.
Tell me the theory you think it fits, because I think we need to be clear here on the record what legal theory we're proposing. We have the due process, the admission against interest, or I guess those are the two in play here.
Yes, sir. I'm suggesting that it's admissible regardless of hearsay pursuant to the Sixth Amendment and due process 14th Amendment.
Okay, under the Chambers case?
Yes, sir.
All right.
I don't think there's that much more that I need to say about that.
Okay.
The court's read my case law and understands my position.
Mr. Fuchs?
Your Honor, go to Chambers. The confession or statement was made spontaneously or close to an acquaintance shortly after the crime occurred. We don't have that in this situation. I don't think it actually is in evidence, but I'll tell Your Honor that it was around March of 2011, so we're talking about 5-6 months after the event that Mr. Washington came to law enforcement in order to do this call that we're talking about. So element number 1 has not been met. Number 2 has certainly not been met. There is no confession or there's no corroboration by other evidence in the case. Mr. Prince is arguing that because the cell phone records for Mr. Griffin was being utilized during that time period, that is a corroboration. Your Honor, that's where Mr. Griffin lives. He's at his house. If that's the case, you're talking about all the neighbors that would be there if they made some sort of statement are potential suspects. Being in your own home is one of the biggest protections, and safe in your own home is one of the biggest protections the Constitution of the United States allows for. That goes to the Fourth Amendment. Simply the fact that Mr. Griffin is at home utilizing his phone, and then somebody else says that he was involved in the killing does not implicate Mr. Griffin. Mr. Griffin never made this statement. This was made by Mr. Paramore to Gregory Washington, and let's make that clear. Mr. Griffin has never made a statement regarding this. Then to try and bootstrap it in because he's at his home utilizing his phone, and I believe the testimony of Investigator Corbett would be that everything's consistent with being at his home. So that it doesn't meet the first or the second element of the chamber's analysis as it relates to that. Furthermore, there's always the evaluation of prejudice versus probative. Gregory Washington is such a, and I know the court can't make a determination as it relates to the credibility of a particular witness, but Gregory Washington had done this so often, he was actually banned from calling the state attorney's office. That was actually here and put forth in the court, and that he is the only person this statement was in fact made to. Even Mr. Washington said, Mr. Paramore never said on that wiretap that he had killed somebody. He just said that the reason the kids probably had to die was because of witnesses. I think we all know that's the reason why the kids had to die, is to make sure that there is no witnesses as to actually killed them. That is not a corroboration or a situation in which we can then bootstrap it further. That's
Welcome back to the Law News Network, everybody. We're going to work to bring you back to the courtroom as soon as we can here, but right now the attorneys are in yet another big argument over evidence. They keep talking about a specific case in Florida that seems to be the critical case that they have to look at to try to make sense of whether or not this hearsay should come in. It's the Chambers case, also running an analysis of the rules of evidence as to whether or not what's being said is probative and whether or not it's just going to cause undue confusion or delay. Sometimes judges can keep things out of trials if it's just going to cause a ridiculous amount of confusion of an issue, and that may be the case here. So Julie Rendelman is still with us here. What do you make of the evidence rulings? Because oftentimes we want to say, hey, look, if somebody's accused of a crime that could result in a death penalty, that person ought to be able to throw whatever they want at the jury and then let the jury sort it out.
Well, but the judge's job is not just to throw everything at the jury and let them sort it out. He has to follow the law. And I think, you know, at least when it comes to the initial individual in terms of Santos, I think the judge is doing his best to follow the law. He's basically, you know, and he's referring to kind of the tests that are required in terms of, you know, making a determination as to whether or not it's admissible, whether it's spontaneous, whether, like, i.e. was the statement made around the time that the incident happened, which it didn't happen with regards to Santos, whether he told a close friend, which in this case he didn't tell a close friend, you know, so he's trying his best to do that, you know, and obviously if the defendant is convicted, then it'll be up to an appeals court to make a determination as to whether or not he got it right. And because it is a death penalty case, they're going to look at it very carefully.
Exactly. I mean, these things just are appealed forever, and the judge doesn't want to make a ruling that's going to result in it having to be retried.
No, I understand that, but he also has to, you know, look, I mean, I don't want to minimize this, but anyone can basically say they did something. That doesn't mean that every single person who, you know, makes a ridiculous statement can get up there and testify. In this case, you know, it's a unique set of facts because you have an individual who's, at least initially with regards to Santos, you have an individual who's admitting to a crime. You know, the prosecution's arguing he's admitting to a crime of which he's admitted to many crimes, and he lied every time he did that, and he may have some type of psychological problem. And so the judge is basically what the judge said. You know, and he was pretty clear. Is I don't know how anyone could believe him, which is a bit of a stretch. I mean, you know, it's not necessarily for the judge to make a determination that no one could believe this witness. But I do think that there is some links that might be missing in terms of kind of the corroboration that he's referring to as to establish, you know, why what he's saying is the truth, other than maybe an email or two between him and the victim.
Yeah, I mean, we've got a lot of different people that they're trying to bring into this, saying, oh, well, this person claimed involvement, and then that person claimed involvement, and then this other person was found to have DNA on the scene, and then he took off for Europe, and that's where he still is, and we don't have extradition rules that will stick in Italy, so we can't really bring him back. You know, right. I mean, but I'm starting to wonder if the prosecution actually has it correct here and saying, hey, wait a minute, these people are claiming involvement, but we've got mental health issues, we've got reasons why they might be lying, we have evidence that they have lied many times over and over again.
Yeah, but you have to keep the DNA evidence out of that thought process, because the DNA evidence is at the scene, and there's
no, that's separate. I
Okay,
agree
so
with
just so we're clear, I mean that's there, and that's not a red herring. I mean that's an issue that the prosecution has to get over in terms of, as far as I'm concerned, explaining away why it would be there, and why, and how, if any, it's not relevant to who the murderer is in this case. In terms of the other stuff, yeah, I agree with you. If we simply had Santos making this admission that he's the person that's responsible for this death, and he hadn't done it on other occasions of which he was proven to have lied, then maybe there'd be more validity to what he's saying. Unfortunately, that's not the case. I will say one thing, having no judgment on the officer that took the stand that testified as to his checks in regard, the officer that just testified, I think a few minutes back, in regards to him, doing an investigation and making a determination that this witness, meaning Santos, had confessed to things that lied about in the past, is we also have to remember he also may have some type of bias because he is law enforcement, and so there might be something in terms of his testimony that may have room for some cross-examination as to his kind of, the way he wants this this investigation to go, because obviously they believe that the person in custody is the person that committed the crime.
Okay, we want to also let people know what's going on. The Seura case is all wrapped up for the day after what turned out to be a 3-hour and 20-minute evidentiary hearing on a number of evidentiary points that will be critical for the defense's case. The judge basically saying, hey, look, a lot of this can't come in, and gave specific reasons on the record as to why. We're also waiting for things to happen or not happen, depending on what's going to happen in the Gasper case out of Cleveland, Ohio. That's the defendant who is facing a litany of charges related to the traffic death of an Ohio State trooper. The judge said he was going to let the jury go home at 4:15, and we're at about 4:21. And a few minutes ago, all the attorneys came back into the room, and they're just kind of sitting there waiting for the judge. So we don't know if the judge is going to turn around and let them go, or whether or not a question by the jury, which was submitted, I think, within the last hour, is going to be answered in open court. We don't know if it's going to be answered in open court, because we also don't know at this point whether or not it was answered in chambers or in the jury room. So we're waiting to see exactly what happens in the Gasper case today. But the judge did say he was going to try to send them home at about 4:15 today if they didn't have a verdict. The jury question is what presumably may have changed that timeline. But as soon as we have something that we can take you to see in the Gasper case, we will take you there directly. Meanwhile, I want to go back to some of the testimony at the beginning of this evidentiary hearing in the Seura case, because one of the people on the stand was a so-called gang consultant who seems to know a lot about gangs, or does he?
Right? And the viciousness of the act itself and the way they were killed, right, with the brutality, right, and of course, once again, the footprints that were indicating that there was more than one person, the surfaces of the weapons that was used that indicated to me that there was probably more than one person involved. All to indicated that all this was probably a Zeta crime, cartel crime, and there's a reason that I say that, because if in fact she was bringing drugs from Brownsville, Texas, which if she skimmed $100,000, I'm just hypothetically saying if she did, that means that she would have had to have been bringing huge amounts of drugs. You cannot go into Brownsville, Texas and buy drugs unless you're dealing specifically with the Zetas, because they control that area. Okay. There's not going to be, you're not going to be able to go there and buy drugs in that amount from anybody that's not connected with the Zetas. The second thing that I took into account was the spade. The Zetas initially were military people. Now in the military, the ace of spade is the death card.
Again, this is testimony outside the presence of the jury, and this person is a gang consultant who testified there that this particular murder has elements that would suggest it may have been committed by a gang. But Julie Rendelman, what's interesting here is that a lot of this guy's qualifications were attacked on cross-examination, and we're going to get there in a minute. But, you know, I wasn't there for all of the testimony, presumably setting up his credentials. But then more than one time over again later on, he's like, oh, yeah, you know, I Googled it. I read it on the internet. I read it in news articles and everything. You know, how does that an expert make? I mean,
I don't know that I have to respond, except I guess now both of us can become experts on this case and a plethora of different topics. You know, I didn't get to see most of his cross-examination, so I don't know, you know, just based on our conversation, it sounds like they had quite a field day with regards to where his quote-unquote expertise lies. I mean, I have trouble, you know, being able to assess a crime scene and making a determination as to whether or not, you know, it appears to be gang-related or not. But then again, I'm not an expert in that specific field.
Yeah, let's listen to some of the cross-examination on this guy's qualifications, or as the judge ultimately found, his lack thereof.
Of my cousin.
So the research you did was calling people who you believed, you connected through your cousin, who you believed in fact were members of a gang to discuss facts of this case.
No, members of the cartel, sir.
Or members of the cartel.
Yeah, they're different. Gangs are different. But anyway, I didn't have no reason not to believe that they weren't. They were giving me information that was consistent with what I already had read and reviewed in books and the internet and different newspaper articles throughout the nation concerning the brutality and killing that cartels do.
All right, so you in fact did Google searches to read newspaper articles in order to try to form this opinion.
I did.
Is that correct?
Yes, correct.
Now, can you identify any methodology that's generally accepted in the scientific community that would allow you to form an opinion based upon talking to people who claim to be something and doing Google searches on the internet?
Well, it's not scientific methodology, but I use the same approach that the police officers use when they're doing expert or investigations on specific gangs or whatever. You know, there is no, especially when it comes to the cartels, there is no scientific data right now that really explains who they are, what they are scientifically. And because it's dangerous for the researcher, especially the researcher that doesn't know what I know. It's dangerous for them. So there is not any scientific methodology per se that I could point to and say, okay, this is the way they do it, the scientific community. But me personally, as I stated, I do the same thing that police officers do. I contact people in the community or in communities that I believe are involved or could be involved or could connect me to people, right, that could give me the information needed.
You've talked a lot about California, especially California.
Ultimately, this is testimony that did not necessarily sway in the favor of the side attempting to put it in front of the judge, because the judge is just like, okay, you know, where are we going to go with this? And I think the answer was pretty much nowhere. But Julie, let's talk about what you need in order to get an expert qualified. Because a lot of people turn around and say, oh, well, most experts are all of these scientific types, or they're professors, or they're people that have written all these studies. It's not necessarily it. It's just someone who has education or expertise in an area. There can be an expert plumber, theoretically, who has learned on the job. You know, it doesn't need to be somebody who's written 20 million studies about whether or not pipes might burst in a certain way.
That's true. I mean, sometimes, you know, one of the things that the judge is going to look for is, you know, how long this by the way, although it's not required, it is kind of helpful if the person has an education in that field, you know, whether it be, you know, licensed in that field or any of those things. But, you know, some of the things the judge is going to look for are those various things, along with whether or not they've testified as an expert before, in what jurisdictions they've testified as an expert, and whether they've ever been denied expertise in those areas. Remember, the reason for an expert is so that the jury is allowed to listen to their opinion about something, whereas in the normal layperson, their opinion is not relevant. And then it's up to the jury to make a determination as to whether or not to accept that opinion or not. So, you know, in terms of deciding whether or not someone's an expert, you know, again, a lot of times you can determine someone's an expert, and it's for the jury to decide what weight to give that person.
Yeah, I just open up my evidence book here because I, of course, keep
you
it with
always
me.
have it with you.
I do. And I have to remind myself exactly what the standard is so that I can let everyone else know. A witness who is qualified as an expert by knowledge, skill, experience, training, or education may testify as such. So that's the standard. And it can be any one of those things. But I'm not sure whether or not, even if this guy was able to be certified as an expert, I'm not necessarily sure he came across as believable. He says he talks to people who are in cartels and in the communities, but does a lot of his research reading news articles on Google.
I think the biggest thing is that, again, when you're the defense attorney, is that really the witness you want to get in before a jury? Because they're so easily cross-examined, and if you start to take them apart, then you start to view the defense in a certain way. And so there's a desperation that we talk about on the prosecution side when they call the jailhouse snitch. Well, you start to see the desperation on the part of the defense's side when they start to call someone who basically their background involves, you know, looking on Google for different articles just like you and I could do. So, you know, you have to be careful as a defense attorney that you don't want to look bad in front of a jury. So, you know, don't leave it necessarily up to the judge. You can decide for yourself not to call these witnesses.
And one of the issues that the judge decided in this case this afternoon is that he was not going to allow in testimony that this other person named James Santos apparently confessed to a bunch of buddies behind bars that he somehow ordered the hit on Brandy Peters, the victim, and ultimately then resulted in the deaths of her 3 children. But the judge said that's not coming in for hearsay and other reasons. But so that's the bottom line on the hearing. I want to go back and listen to some of the testimony of one of the people who was prepared to say that he heard James Santos talk about this, because Santos himself pled the Fifth and wouldn't testify. Let's listen to Benjamin Whitefield on the stand from this morning.
He asked me did I know anything like surrounding like that case and stuff, and but he didn't. He tried to like to portray it like he didn't know anything about it, and then but as time progressed, then he started to tell me more stuff about it and about his involvement in it.
What did he tell you his involvement in the murders was?
That it was something about a drug debt, and he was in communication with her while he was at FCI over off Capitol Circle, Federal Correctional Institution, and he was using, I guess, some type of email system or something they have set up for prisoners for federal prisoners over there at FCI.
Okay. Did he eventually admit to you that he ordered her and her children's murders?
Yes, sir.
Okay. Did he tell you about any of the details of how the murder was carried out?
He told me that she had some dishes that supposed to been like I think these dishes was made by Tiffany or something like that, and he said that that she had, it was like supposed to been 3 computers in the house, and he said that they had them when they came and committed the murders of them Brandon and her 3 kids, that they took one of the computers. I think that might have been the computer. I don't know for sure that he was communicating with her on.
Did he say specifically who he ordered to carry out these murders?
No, he just said.
You said you started talking about something about dishes, and
Yes, sir.
you didn't follow that through. What were you saying about
You
dishes?
saying about some dishes that she had that was supposed to Tiffany dishes that supposed to been worth like $3,000 or something. It's him or somebody supposed to have purchased for.
You're saying the people that committed the murder took those?
No, he's saying that they supposed to took the laptop.
Took a laptop.
One of the computers that he was communicating with her. I guess it might have been one that he was emailing her with.
Okay. So he was just saying he had purchased them for her at some point.
Mm-hmm. Yeah, purchased her like in I think like a vehicle, and supposed had got her like a passport to go to Colombia, stuff like that.
Did he say anything about one of the children being killed in front of Miss Peters?
Yes, I think he told me about I think the little boy was supposed to have been killed in front of Miss Peters first, and then the two little twin girls.
Okay. How long did you remain at the same correctional complex as Mr. Santos?
I think we was side by side maybe for maybe about 3 weeks, a month and a half. So.
Okay. And you came forward and shared this information with Florida Department of Law Enforcement agents in, is it late 2016 that took place?
Yes, sir.
When you were almost at the end of your sentence, correct?
I was about, let me see this. Yeah, I think I had probably about 2 more years, a year and a half, something like that, left for my sentence.
Without game time, you're saying?
Yes, sir.
Okay. And you've since been released from state prison?
Yes, sir.
Okay. Why was it that you decided to come forward with the information that Mr. Santos had shared?
Because this gentleman here, Mr. Henry Seura, they said that he wasn't the one that did it. And so he was trying to figure out a way to help him, but he didn't want to help him and then implement himself. And so I just, and me being wrongly accused myself, and I didn't want to see him lose his life like that.
Thank you. No further questions at this time.
Yes, sir.
That's testimony from Benjamin Whitfield, who was an inmate with James Santos. James Santos had been saying behind bars that he somehow orchestrated this entire murder spree that resulted in the death of a victim, Brandy Peters, and her 3 young children, 2 of whom were twins. Now, the prosecution, I think, has made a pretty strong case this afternoon that James Santos, the person about whom that witness was talking, has a history of fabricating these elements. But before we get into more analysis on that, I just want to also let you know what's going on in the Gasper case out of Cleveland, Ohio, a different case involving a trooper who was killed in a traffic accident, a defendant accused of being on methadone from a prescription to treat another underlying addiction to painkillers he was given after a workplace back injury. Bottom line is that case, they've gone home for the day in that as well. So there will not be a verdict in the Gasper case today. The jury apparently had a question this afternoon, but that question was not answered in open court, so we don't know what that question was. Interestingly enough, in the Gasper case, the judge said that he wouldn't allow the jury to hear readbacks of testimony, but they could have exhibits back in the room. And I thought, Julie, that was a bit bizarre because at least in New York here, you can get readbacks. If you're on the jury and you're confused about what was going on, you can ask for a readback of testimony.
By the way, I've never heard of that ever, so I can't even imagine how a judge would allow that. That seems...
Are we
sure we're not right about that? Because I've never heard of a judge not allowing a jury to review that evidence that was previously before them, i.e. witness testimony.
Well, they can review it. I mean, I don't know, maybe Ohio is one of the states that allows jurors to take notes. I'm not sure. But I think the judge told them that they were to rely on their memory and not a readback.
That is the most...
It's the note that I got, at least from the person who was watching when that was
I really hope they're wrong, because, I mean, that's terrifying to imagine that a jury who's deciding the fate of this individual isn't allowed to hear a readback of testimony of something that is deciding the guilt or innocence of this guy. Notes are simply for your own review, but notes are wrong all the time. The purpose of using a court reporter is to make sure you get down to every single word someone says to make sure it can be used at a later time. So that makes no sense to me whatsoever.
Well, I was told that's what was said. I don't have the clip to prove it, but I thought it was a bit
I'd like
bizarre
to see that proof.
As well, too. So I'll have to dig it up for you. Julie Rendelman will have the proof as soon as I can get my hands on it. But anyway, let's go back to the Seura case in Florida, because we got this guy Santos. He claims he's involved. He won't testify that he was involved. He said, I plead the fifth. All these other people who were in jail with him were parading across the witness stand saying, oh yeah, he said it, I heard it. Okay, well, we got hearsay issues, we've got credibility issues, you name it. This didn't go anywhere. The judge said, I'm not allowing this stuff into trial. Did the judge make the right call?
I think he did. Based on everything we've heard so far, I think he did make the right call. I think it's hearsay. And I think there's no exception to it. And I think, unfortunately, for the defense, I think the negative value is outweighed by any probative value. I understand the argument to be made is that the jury should hear and let the jury make their own determination at, and weigh it based on all the things that they could find out potentially about the fact that he had lied on all the other occasions about what transpired. But I think at the end of the day, the judge made the right call.
Okay, one interesting thing about this testimony from the witness who we just listened to, Mr. Whitfield, he said that the version of the story that he heard was that the little boy, the youngest victim's body, was supposed to have been left near a door, so it was the first thing someone would see.
Right.
Okay, but that's not how it was found. The children's bodies were in a bathtub.
Right.
And then he says, well, I heard something about the bathtub or the bathroom being involved too. And at some point, one version of this story was that the kids were killed, at least one of the kids, if not more than one of them, were killed in front of the mother. So it sounds like there are 5 or 6 different versions of this story flying around in jail, and nobody is able to actually pinpoint the one that actually happened because they all don't line up. You can't have a victim's body left by the door to be found first and then found in the bathtub and assume that the story is correct.
But keep in mind that Santos isn't claiming he did it. Santos is claiming he hired people to do it. So one would expect, and I'm not defending, I'm not saying that Santos is credible, but one would expect if Santos wasn't in the actual residence when the crime scene, when the crime occurred, he may, whoever he hired to do it, may be giving information that might be inconsistent at different times, depending on how many people went into that place and what they saw. So it wouldn't be surprising if he hired someone that he wouldn't know necessarily exactly what went down in the room where it happened.
Yeah, okay, so at the end of the day, though, how can you continue to put these people on the stand and say that they're reliable? And ultimately, the judge said, we can't. That's why the jury doesn't get to hear any of it.
Right. Exactly. There's a ton of different versions, and I think one of the children was shot. So there is an argument to be made that one of the children would have been potentially present when the mother was killed. And I guess for argument's sake is that the child was killed because they may have seen things, or the children were killed because they didn't want to leave any witnesses behind. But that would support Seura being the shooter, and that would support a drug cartel being the shooter.
Yeah, well, we'll try to continue to unravel this here on the Law News Network. I want to listen to one of the neighbors of the victim because this was interesting. There's discussion here about a letter that apparently concerned the victim very, very much.
Cicely Timmons.
Could you spell your first and last name for the court reporter?
CIESLYTIMMONS.
You were with Brandy Peters on the 19th, correct, during the day? Were you with her when she received a letter from a James Carlos Santos that day?
She came to the house after
she brought it to you at the house?
She came to my house with it after she had read it.
Okay. You knew Brandy pretty well, correct?
For about 6 months.
You knew her. You knew what she looked like if she was scared or concerned about something. Did she, at some point when she came over to your house, discuss that letter with you?
Yeah.
Okay.
She was scared when.
Did you see the letter?
Yes.
May I approach the witness, Your Honor? No. For purposes of this motion hearing, I'll identify this as Defense Exhibit 1. Do you recognize a copy of this envelope? Postmarked November 17th, 2010. Mm-hmm. Is that the letter that Brandy received on the 19th?
Yes.
Did you have a chance to look at that envelope at the time?
She came to my house with it and I read it.
Did you read it?
Yes.
And what it states on the letter accurately reflects what you recall at the time. Word is bond, bond is life, and a man should give his life before his word fails. Say what you mean and mean what you say. Death before dishonor. Dear Mr. Mailman, if this letter happens to get lost, just send it to heaven because it's going to an angel. I thank God for you and ask that he look after you and our 3 angels. That's what it said on the outside of the envelope?
Yes.
How did Brandy appear upon reading that envelope?
She was scared.
Are you scared?
Yes.
Who are you scared of?
Carlos Santos.
No further questions for the witness at this time.
Right.
Ms. Timmons, prior to receiving this, you said you'd known Ms. Peters for about 6 months at that point?
Yes.
Prior to her receiving this, isn't it true she'd only really been known Mr. Santos for maybe even a month, not very long, 6 weeks, something like that?
From my understanding, that's the understanding that I got from it.
Okay. Didn't know him before all that?
Not that I know of.
Showing you the letter that was written here. Does it also say send me pictures? Given all of that, Brandy, isn't it true that Brandy's concern wasn't so much of her being killed or dying, but more along the lines of being involved with this guy, Carlos Santos, who wants to marry her and all that kind of stuff?
Well, once she was scared about the letter, but before that, I mean, she was just really trying to find out who he was, as far as I know.
So she was looking to figure out who he was at that point?
Yeah.
Had no idea who he was?
She didn't seem to know who he was, but when she got a letter, she was scared.
And that's because the letter talks about weird stuff, weird statements and things like that. Fair to say?
Yeah.
Okay. Kind of freaked out, kind of like you would if you were on a first date with somebody and then you try to get out of it real quick when they're a little weird, right?
It was crazy.
Yeah. Fair enough. All right. Thank you, ma'am.
Free direct. Ms. Timmons, Ms. Peters had prior dealings with Mr. Santos. That's simply not something she discussed with you.
No.
Nor did she discuss with you any drug trafficking activities by her, correct?
No.
Thank you. No further questions at this time.
You can step down.
That's testimony from a neighbor about this bizarre letter that Brandy Peters, the victim, apparently received from this James Carlos Santos, which, again, I'm trying to unravel all the details in this because they're starting to get muddier and muddier. But this guy who was in prison claiming he was involved, I'm assuming this is the same James Santos who sent this letter. So how does the victim get a letter from...
By the way, just, earlier you said to me, you're more familiar with the case than you are, like that I was.
Yeah.
And I didn't hear this testimony today. So I literally, when I just heard this, my mouth dropped because I just said, I was like, where the heck did they get this letter from? And now I'm starting to second guess everything I just said 2 minutes ago about whether this should come in or not. Because now you have potentially the person who's claiming that they killed this woman having such a connection with her to whatever degree that he sent a letter to her days before this murder happened, and we're supposed to now ignore that. Now I admit that I'm confused and have more questions than I have answers.
Yeah, I mean, the letter itself can be examined, and the writer apparently wants to sit and plead the fifth, but the letter is the letter.
Well, I am questioning whether or not was there latent prints did someone try to get latent prints from this letter? Did someone try to get DNA, which you could have potentially gotten from this letter, to see if it is the same Santos that sent it? I mean, I have so many questions now that I don't know the answer. I don't know if it came out or not. I have a feeling it didn't, but I am more confused than I was about 5 minutes ago.
Yeah, this case is just becoming increasingly confusing. I wish that I had all of the actual motions in front of me right now, but I don't have them. Apparently that's my homework assignment for myself this evening. I want to continue on with the next clip because we had this parade of other witnesses who are neighbors talking about letters, conversations, what was going on in the neighborhood, and exactly whether or not the victim was involved in drug trafficking, which is one of the defense's theories, that maybe she was killed as part of a hit as the result of being involved with some drug cartel. And so the defense was trying to call many of these neighbors in an evidentiary hearing to convince the judge to put these witnesses before the jury to hear that information. Let's listen to the next neighbor on the witness stand.
Ms. Garland, can you please state and spell both your first and last name for the court reporter?
My name is Lakeisha Garland, Lakeisha, Garland, Garland.
You knew victim Brandy Peters?
Yes.
How long did you know her for?
She was my neighbor. I moved into Swakoko Villa 2007, 2008, till up to the time of her death.
You remained friends with her up to the time of her death?
Yes.
Okay. Did you have a daughter that was about the twins' age?
The twins were a little older. The twins
little
were
bit
older than my daughter.
Okay. Was your daughter friends with the twins?
Yes.
Okay. They used to play together and things of that sort?
Yes.
What about you and Brandy? Were you two close as well?
Yes.
Okay. Did you remain close all the way to the time of her death?
Yes.
Okay. Back when you and Brandy were neighbors in 2008, were you aware of her reputation in the community for being involved in drug trafficking and with drug traffickers?
Yes.
And what was her reputation in the community?
That she had her own drugs she was selling to the community. Of some, who were the people, I didn't know. I just knew that she had her own upon to the time she got with the boyfriend, Kalo.
And what happened at the time she got with Kalo?
He then wanted her to be part of drugs with him, even though Brandy had her own.
What about your own personal knowledge? Did you ever personally witness Brandy engaged in drug sales, cocaine sales?
Yes.
How frequently did that go on?
She had a few people come to her place, and some she'll go off and meet. She wouldn't really want too many people to come to her house.
Okay. What about after she moved? Did you remain aware of her reputation in the community for involvement in drug trafficking?
Yes.
And what was her reputation after she moved?
She knew that some people wanted to get on with her, but she would never let nobody get involved with the situation that she had going on, and she would never invite them to her new place where she was living at. She would always drive off and meet them.
Did you know anything about her having a debt, a drug-related debt?
I heard about it, but her speaking of it word of mouth, no. I just knew that she had a cousin that wanted to get on with her, that wanted to help her with it. She just would never involve him with it. She told him she just didn't want him to get involved. She only wanted to do it on her own.
Okay. When you said that you had heard about her drug debt, that was not from her. That was other members of the community that knew Ms. Peters. Is that correct?
Yes.
Okay. No further questions for the witness at this time.
Cross.
You talking about you were neighbors with her before she moved to the address on Saddle Creek Run?
Yes.
Okay. So back on like Holton Street?
Yes.
Okay. Fair to say, unfortunately, that's a neighborhood that there's more than one person in there that's selling drugs and stuff like that. Okay. Ms. Peters, in selling these, if she is in fact selling drugs, you said she had a couple of people over there a couple of times, correct?
Yes.
Okay. At any point was she coming out with large suitcases full of narcotics and selling big amounts?
No.
Okay. You're talking about small street level, $20 or something like that?
Yes.
Okay.
She would always let them come in-house, not outside.
Okay.
It would never be nothing done outside.
And then when she moved away, she didn't ever want to invite anybody back to her house for any
Nope.
of this stuff, right?
She would never invite nobody to her new place, no. She would always go off.
Kind of distancing herself from all
Yes.
that. Getting out of it.
No, she actually would drive off in her car to meet people for the sales. She would never invite them to her new place.
In Tallahassee?
Yes.
Okay. All right. Again, talking about very small levels of stuff, not big suitcases full that you see on TV and stuff like that, right?
Well, I never seen her of us moving distance. I never seen her do it from there. So I couldn't say from Saddle Creek if she was moving it from there.
Okay, so you're talking about back in 2008 then when you saw most of it?
Yes.
Okay. After that, you really don't. You just heard of word of mouth.
Yes, but I knew that she still word of mouth, would never invite him to her house. She'll go off and serve away from, because she would never want nobody to come to her new place.
Okay. All right. Thank you.
Redirect. Yeah, she ultimately was, to your knowledge, involved with Kalo's drug trafficking activities, correct?
Yes, plus her own.
Plus she had her own source of supply. And Kalo ultimately was caught and sentenced for possession and distribution of large quantities of cocaine, correct?
Yes, but he also, he came to her for some help. because he told her he hadn't messed up and he needed some help from her. And that was the last conversation. You know, I was around with him, with her.
I understand. No further questions for the witnesses. Tasha.
So when did she move away from Holton Street?
2008.
What?
2008.
So it'd been a couple of years that she'd been moved away.
Yes.
How much contact were you having with her between 2008 and 2010?
It was like on and off.
Beg pardon?
It was like on and off.
Phone calls?
Phone calls. She'll come over to my place. I would. We also. She had a birthday party for Vontae.
She had a what?
She had a birthday party for Vontae, so we went to this birthday party that she had for him. And it was just like she'll come to my. She mainly would come to my house, to where I moved at.
How many times had you been to her new house?
I haven't been to her new place because she had Vontae party at a park.
So you've never been.
No, Brandy always came to my house.
All right, you can step down. Next witness.
Your Honor, I want to again ask the court for a little direction on this. I do have additional witnesses, and those witnesses have not presented their testimony during the course of the trial yet, but they don't bear direct.
That was another of the neighbors of the victim in this case. She's testifying there about what's going on in the neighborhood. You know, was the victim selling drugs? If she was it big amounts of drug sales or little amounts of drug sales? You know, and the testimony is small amounts. Well, if the neighborhood presumption is if the victim is involved in selling drugs, and that's an if, then it was small amounts, then is she tied up in some cartel if it's just street sales?
Well, I don't know the answer to that. I mean, I don't know also that the neighbor telling you how much sales were going on in her house is necessarily going to know exactly what was going on. And again, keep in mind that you know, her being involved with a cartel, you have the small fish and you have the big fish. She could have just been a small fish that was selling, you know, small amounts. That doesn't mean that she's not going to get killed for that.
Depending on the value, and that's something that this neighbor couldn't testify to.
Exactly.
How much money was changing
How would she
hands.
know? Except that we know from what we've heard that she was driving nice cars, and you know, maybe living above her means.
Well, that's the accusation, and I think that the police said we had no evidence of it when we went through what was there at the house. That's
right.
Not the case. At least that's the way the police termed it. So, okay, we're going to continue on listening to yet another one of the neighbors of the victim here. This one talks about what was going on the night of the murders.
Did you and your wife Shayna hear the dog over by Brandy's house barking?
We heard what I would call excessive barking coming from that direction. I didn't know if it was their dog or not, but definitely heard what I felt like was out of the ordinary.
Out of the ordinary to the point that the police were at some point called?
Yes, they were.
Okay. Do you remember what time you heard that dog barking at?
No, it's been so long now, I probably need to have my memory refreshed, to be honest with you.
May I approach the witness, Your Honor?
You may.
If I let you review a police report which reflects your initial statement, would that refresh your recollection?
It absolutely would.
Just read that to yourself.
Okay, starting here. On scene.
Just read it to yourself.
Oh, okay, sorry.
Does that refresh your recollection?
Yeah, the first part, yes.
Okay. At what time did y'all hear the dog barking and finally decide to call the police?
It would have been probably maybe about 10 minutes before I actually called. Maybe about 10 or 15 minutes before I actually called.
Okay. What time did y'all actually call at?
The time that was stated was like between, I would say about, what was it, 1:30 or something like that?
Yes, sir. No further questions for the witness at this time.
Cross? No question, Your Honor. All right, you can step down, sir.
All right, thank you.
Okay, yet another witness on the stand. This is a neighbor saying, well, there was a dog barking loudly. And Julie, we've heard this as the the tone of bad news in a neighborhood before. You mentioned the O.J.
The
Simpson
OJ, I
case.
feel like we're back at the
You
O.J.
know,
Simpson
when
trial.
the dogs go nuts, apparently something is amiss. And in this case, that's the literal truth, if we're to take him at his word, because he said it went on long enough that it resulted in a police call.
Right, exactly. I don't know that the barking of the dog necessarily means that the crime happened at exactly the time that the dog was barking, but it is reminiscent of the O.J. Simpson case with regards to, I believe, the Akita that was barking away during that trial, that crime.
It's bringing back memories that I've long since forgotten.
and have tried to forget.
Yeah, we're going to wrap things up, though. Just a reminder, we're covering 2 trials here. The Gasper case, the jury is home, but the attorneys and the judge might still be arguing about a jury question. They have not come back out into open court, but we're going to keep an eye on it here for reasons being that we don't know if they're going to do anything in open court. We would not want to leave you hanging here on the Law News Network, assuming something is going to happen when it's more likely than not that it won't. So, Julie Rendelman, LawNewz trial analyst, former prosecutor, current criminal defense attorney.
You don't have to mention each one every time.
I'm going to mention all 3 titles
every time. That means so much to me each time you say it.
I will start mixing them up in order to keep things fresh
do like
and live.
Each time it's more exciting because I never know which way you're going to go.
Julie Rendelman, former prosecutor, LawNewz trial analyst, current criminal defense attorney. It's always nice to see you, even though you do verbally abuse me frequently.
No, thank you for having me, as always.
All right. A reminder for you folks watching at home that we're live from 9 a.m. until 5 p.m. Monday through Friday, unless testimony starts early or late, and in which case we adjust our schedule so you don't miss anything. For now, we're going to be back tomorrow morning with more testimony in the Henry Segura case out of Tallahassee, Florida, and we're going to be continuing to watch for a verdict in the Joshua Gasper case out of Cleveland, Ohio, because that jury will be back tomorrow for more deliberations. For now, though, this is Aaron Keller at the Law News Network, wishing everyone a good evening.